Check, check, 1 2. 2, check, check. Mic check, test 1 2, 1 1 1. 1 2. Mic check, testing 1 1 1. 1 2, 1 2. Mic check, 1 1. 1 2. Check, check, 1 2.
Um, Good morning, commissioners. Good morning. Are we all in? Secretariat, are we all in? She's making money. She's making fees. Says, I'm saying to him, you are making money. You are making fees. Secretariat, is everybody in? Somebody must tell me if everybody is in. Yeah, okay, all right.
Good morning, Chief Justice.
Good morning, Commissioner Singh. Good morning.
I
Good
think from the
morning.
virtual platform, we are in. Thank you.
Yes, thank you. I think Commissioner
morning, Chief
Barnett is still there as well, and Commissioner Breitenbach. Good morning to all of you on the virtual platform.
Morning, Chief Justice.
Thank you.
Good morning, Chief Justice.
Thank you. Good morning. Um, Once again, good morning to all the commissioners. We are ready to start. You can bring in the candidates, Secretariat.
Chief Justice, it's Singh.
Yes.
Sorry, as they bring in the candidate, I note that there were 5 vacancies that were listed, but we've got just 2 applicants.
Yes.
Perhaps at some stage we can discuss the issue with our sifting committee and why we're not getting sufficient applicants. Thank you.
Okay. Do you want me to ask them to delay a bit with the candidate, bringing the candidate?
Perhaps if it will help all of us as commissioners.
Yeah, okay, all right. Secretariat, if you can just delay the candidate, bring in the candidate a bit. Yes, Commissioner Singh.
Yes. Thank you, Chief Justice. Yeah, I when I saw there were 5 vacancies and we've only got 2 applicants that were shortlisted, perhaps we could hear from our colleagues on the sifting committee, what challenges they had and how we deal with this matter moving forward in terms of filling vacancies. Thank you.
One option is that we could discuss that maybe under deliberations. What do you think about that, Commissioner Singh?
No, I'll have no problem with that, Chief Justice. Thank you.
Yes. Commissioner Nyambi has his hand up. Thank you.
No, I'm covered by your intervention.
Yes,
because we
yes.
had a meeting yesterday and we knew that we were going to have to.
Yeah.
So it's not relevant now.
Okay, no, that's all right. Thank you, Commissioner Singh. I welcome the Judge President of the Competition Appeal Court, Judge President Manomi. He's here with us. Welcome, JP.
Thank you, CJ. Nice to be here. Thank you.
Thank you. You may bring in the candidate. Good morning, Judge Nuku.
Good morning, Chief Justice, and good morning to the commissioners.
How are you this morning?
I am well, thanks, Chief Justice, under the circumstances.
You are ready for us.
Well, I am here, Chief Justice. That's all I can say.
Yeah? You are kind of ready.
I am, Chief Justice.
You are
Thank
ready.
you.
Okay, all right. Well, let me take this opportunity to thank you for making yourself available for an interview by this commission. We welcome the fact that you have made yourself available and you have come to subject yourself to the interview. Yesterday morning, this commission had a meeting in which one of the resolutions it took was to adopt the criteria for the selection of candidates for judgeship. Included in that document is a commitment by all of us here that we will ensure that every candidate is treated with respect and courtesy, but that doesn't mean that there will not be robustness in questioning. So where it's necessary, there will be a robust questioning, but all of this will be done with due regard to the candidate's human dignity, and there will be respect. So no matter how the questioning might be, never think that there's anybody here who wants to just treat you unfairly and so on. You understand?
I do. Thank you, Chief Justice.
Thank you. I will ask you some questions, and thereafter we'll give the Judge President of the Competition Appeal Court an opportunity to ask you questions, and thereafter the Minister and all the commissioners who may wish to put questions to you. Okay.
Yes.
Thank you. Let us start with your qualifications. You have a BProc degree and an LLM. Sorry?
Oh, I thought you were done, Chief Justice. I was going to say that is correct.
Yeah, yes. And then, but you have got a diploma. Is that right?
I do have a diploma in corporate law and a certificate in insolvency practice, yes.
Yes, yes. Now, before you were appointed as a judge in the High Court, you had practiced as an attorney, is that correct?
That is correct, Chief Justice.
Were you admitted in 1996?
I was admitted April 1996, yes.
And you were appointed as a judge in 2016?
1st of July 2016 was the effective date, yes, Chief Justice.
So that would mean that by the time you were appointed as a judge of the High Court, you had been practicing as an attorney for about 20 years, is that right?
More or less right, except that I started acting during April 2015, and my acting stints were continuous until my appointment. So it would be 19 years as a practitioner proper, and then started acting in 2015 until my appointment.
Yes, but nevertheless, you practiced for a long time.
That's correct, yes, Chief Justice.
Yes.
That's correct.
And your practice, how was the diversity of your practice in terms of branches of law?
We had more of a general practice, Chief Justice. Initially, we started off with criminal work. At that time, legal aid used to give instructions to attorneys. That's where we started, and we developed into MVA. I then took it upon myself to qualify as a conveyancer and a notary public, and we branched into that area. I had always had an interest in commercial matters, hence you'll see that I did this diploma in corporate law and subsequently did my master's in commercial law, which incidentally included a module in competition law. We did have some commercial matters that we were fortunate to deal with, but I must just confess upfront that we never did competition law as when I was in practice.
Yeah, well, not many black practitioners get to receive instructions or briefs in competition law and commercial law, serious commercial law matters, isn't it?
That's correct, Chief Justice. It was a challenge and still is a challenge.
Yes.
But nevertheless, I was never deterred because I did my master's I finished them in 2011. I still had not given up. My interest in competition law started during the early days after the enactment of the Competition Act. The Competition Commission used to run some public awareness seminars and workshops, some of which were held in Cape Town. I attended some of those, and that's where I really picked up this interest. And I thought that democracy had brought with it an opportunity for us to branch into those areas, but unfortunately it was to be a dream deferred.
Was there a specific purpose why you chose to do a master's that had a master's in commercial law as such, seeing that you did not have a lot of commercial law in practice?
I was always hopeful, Chief Justice, that at some point in time, the opportunities would come my way. And I wanted to prepare myself for the time when the opportunities do come so that I would be ready. Because it is one thing to hope that you might get an opportunity and you get it and are not prepared. So I was preparing myself for an eventuality if the opportunity knocks on the door.
That's very good. And then you said that one of the papers you wrote for your master's was in competition law.
Yes, Chief Justice. My master's was a combination of coursework and a minor dissertation. So one of the modules in the coursework was in competition law.
Yes. You would have written a dissertation. What was your dissertation on?
My dissertation was in company law.
Yes. And what was the topic?
I dealt with the codification of the director's duty of care, because the introduction of the new Companies Act had codified the director's duties as opposed to the position that existed prior to that, because they were dealt with in terms of the common law. And I did a comparative analysis between South African company law. I also looked at the UK company law, which, as I understand, that our company law derives mostly from the English law. I also did a comparative analysis with the position in Australia.
Yes. Now, you have been a judge in the High Court since 2016. That gives you about, what, 6-7 years as a judge?
Close to 7 years.
Close to 7
6
years.
years and a couple of months, short of 7 years, yes.
Yes. Now, of course, if you are appointed to the Competition Appeal Court, you would be sitting on appeal over decisions of the competition tribunal, is that right?
That's correct, Chief Justice.
And generally, the competition tribunal consists of specialists in competition law, am I right?
That is correct, Chief Justice.
And those people would may have more experience in terms of competition law than judges who might come onto the competition appeal court who might not have had a lot of exposure in competition law, is that right?
That's correct, Chief Justice.
How do you feel about that? Namely, sitting in an appeal court over a specialist tribunal which has got specialists or experts in the field of competition law when you might not have had the same exposure.
Let me just start by saying that, Chief Justice, I have done a scoping of the work that the Competition Appeal Court has done in its first 5 years and in the last 5 years. The majority of the matters that come before the Competition Appeal Court are procedural matters, interlocutory applications. And then you have matters that would concern core competition issues, which would mainly relate to Chapter 2 of the Act. When it comes to the fact that the tribunal members may be more experienced than me, and I must sit as an appellate judge in respect of their findings. It is, to me, Chief Justice, it still seems to be that the whole exercise is about the interpretation of the statute, it being the competition law. Generally speaking, the principles of interpretation apply across the board. What is a little bit different in respect of the competition law matters is that there may be some economics that come into play. But how you deal with that is the same way you deal with evidence in a medical negligence claim where you will have had experts, because it's the evaluation of the evidence based on the framework of the law, the principles are set out, and you evaluate whether the facts as presented drive you to a certain conclusion. So on its own, I don't think that it is an impediment. And I will also be sitting with colleagues who may also have more experience than I have. In the few matters that I have sat in the Competition Appeal Court, I have learned a lot. The colleagues there are very helpful. The matters are debated extensively. And when the judgment is ultimately returned, you feel that you understand the issues. That's all I can say, Chief Justice.
Yeah, well, I was not asking the question because I think it should not happen. But in our legal system, it happens. It has been happening for a number of years. The Labor Court and Labor Appeal Court had the same situation for a long time after the two courts had been established, where the judges in the Labor Court used to be judges with lots of experience in labor law and expertise, but the judges in the Labor Appeal Court, some of them didn't have a lot of exposure. So, but even before 94, it happened in labor law. You had specialist tribunals such as the Industrial Court, but its judgments would end up through a review process in the, an appeal process in the Supreme Court of Appeal now, you know. So it does happen, So you shouldn't feel like it's something that doesn't happen. But you would accept, would you not, that even when it comes to interpretation, you can't just say it's just the interpretation of the Competition Act. Understanding the concepts of competition law and the dynamics becomes quite important, because if you don't understand the basic principles of competition law, you could think a particular interpretation is correct when you think about interpretation, but in practice, it could cause a lot of problems in the industry. Is that correct?
That is absolutely correct, Chief Justice.
Yes,
That
yes.
is correct.
Now, you have, how long have you acted in the Competition Appeal Court?
I acted from January last year, Chief Justice.
Have you acted continuously up to now?
The appointment is for a year, yes. So it was for last year, and then this year again I was appointed until the end of the year.
Yes.
But the court does sit, say, once a term, and sometimes you may not sit in a term.
Now, if you were acting in the High Court or in any of the other courts for that period, you would have done a lot of cases, and you would have gained a lot of experience, because there are lots of cases in other courts. But is that the same situation in the Competition Appeal Court? Has this given you a chance to do a lot of cases?
No, it's not comparable, Chief Justice. As I say, in a term, you may find that you sit in one matter. For example, last year, I think the matters I sat in last year, I sat in 3 matters last year. The 4th one I was going to sit in was settled. And this year, then I sat in my 4th matter. So the matters that I've sat in the Competition Appeal Court from last year to date are 4 matters.
Yes, it's a very limited number of matters.
It is.
Yes.
I accept it is.
But obviously, that must be because of certain challenges in the Competition Appeal Court.
It has to
it's
do
not because
with-
you were not available.
Yes, it has to do with the flow of work from the tribunal to the Competition Appeal Court.
And how many judgments have you written yourself during that period?
I wrote 1 dissenting judgment and 1 judgment which was unanimous.
Yes. Do you believe that having written only 2 judgments in an area in which you didn't have a lot of exposure before has prepared you enough for a permanent appointment in the specialist field?
Chief Justice, with the training that I have also been exposed to during the period that I have been acting, I believe so. If you look at the judgments that come out of that court, I don't think that there is any year where you would find that there is more than 15 judgments on SAFLI. So it is that kind of an environment.
So you don't think that it's a situation where you should get more weight and get more cases to just gain more experience? You think it's enough?
Well, Chief Justice, I would accept if, on consideration of my broader experience, the Commission comes to the conclusion that I still need some exposure. But from my perspective, if that limited experience is taken together with my broader experience that I have from the High Court and as a practitioner, I think that has equipped me enough for consideration for appointment into that court.
Yes. And in terms of your High Court experience, have you sat in many appeals, full bench appeals?
I have, Chief Justice. In the Western Cape, there is a practice that during the first term and the third term, the first week is reserved for full benches, where you will sit in no less than 2 full bench appeals. So from 2016 up until the 2020, that was continuing, and then of course COVID disrupted that, but then after that we went back to that. So I've sat in a number of appeals, full bench appeals. Also there are appeals that emanate from the lower courts, the regional courts and the magistrates court. I've sat in a number of appeals in that regard.
Yes, thank you. I will now give the opportunity to the Judge President.
Thank you, Chief Justice.
Thank you. Good morning, Judge Nuku.
Morning, Judge.
Judge Nuku, I just first wanted to ask you about the volume of work that comes to the Competition Appeal Court. In other words, if you were to have to wait another day when you might have had more exposure to the cases, if the volume continues as it is at the moment.
Sorry, Judge President, may I ask you to speak up a bit?
Sorry.
Yes.
I just wanted to ask you about the volume of work that comes to the Competition Appeal Court. In other words, if you were to be faced with a situation where it said that you needed more experience of the cases, if the volume continued on the basis that it is at the moment, how long would you have to wait until you'd gained 10 cases or 15 cases under your belt, if it was continued at the level of the frequency it is at the moment?
It would take very long because, as you would know, if you write 2 judgments in that court in a year, that's a lot. It's rare that you'll find a judge who has written 3 or more judgments, So it would take quite some time.
Okay. Of the judgments you've mentioned that you've written 2, the one I know is related to dominance in the e-media case, is that correct?
That's correct, Chief.
And what was the other judgment concerning?
The other one was concerned an application for temporary stay of a review,
Okay.
which we decided now in March, on the 24th of March. So it was more an interlocutory application.
All right. Can I then get to the approach that you might take to the interpretation of the Act? Do you consider that some knowledge of economics is essential for a judge who's wanting to interpret the Competition Act?
It is essential because you have got to be able to evaluate that evidence. You must be able to make sense of that evidence so that in your interpretation of the Competition Act, you attach proper weight to that evidence.
And do you feel that you've had some exposure to those issues through your course at the university and through the seminars the courts have done and cases that you've sat on?
The seminars have really been very helpful. In the matters that I've sat in, including the ones where I did not write a judgment, I got a good exposure to that. One of them related to Section 4, which is one of the issues that come often to the Competition Appeal Court. The other one you mentioned is the one that related to the abuse of dominance, an issue which also comes often to the court. The other area that is reserved for the Competition Appeal Court, the merger control, I was only involved in a matter which concerned procedural issues determining the rights of participation by a party in the merger proceedings. So I have kind of had a broad overview of the business of the Competition Appeal Court, I would say.
Do you have a philosophical approach to how to interpret a competition statute. As you probably know from the seminars, there's a great debate between what's called the Neo-Brandeis school of thought and the traditional Chicago school of thought, and some people are somewhere in the middle of those two schools. So in other words, if you are faced with a particular case and you've got to interpret some of the terms in the Competition Act, do you have a guiding philosophy as to how you would interpret difficult language in the Act?
I think South Africa is in a unique position because if you look at the Competition Act itself, it's broader than what other jurisdictions carve out as competition law. I say this because it makes it plain that there is public policy considerations that come into play. So my approach should be to ensure that the interpretation I give to the Competition Act is aligned firstly with the Constitution, and secondly, it is designed to achieve the objectives of the Act, which include competition proper in its sense, as well as the public policy considerations.
So if I can be more specific, if somebody said to you the Competition Act should only be concerned about, when it comes to prohibited practices, about whether the practice leads to higher prices or a reduction in supply, would you regard that as appropriate or too narrow an approach?
That would be too narrow in our context, in the South African context.
And so if it's too narrow, what other criteria would you then look at as being relevant?
Well, the Act, Section 2 makes it plain that one of the concerns of the Competition Act is the social and economic welfare of the consumers. So I would also factor that into the consideration.
Okay. And my final question is, if you were to be appointed to the court, historically many of the judges appointed to the court have gone to higher places. Would you be willing to give a commitment that you would be available to serve on the court for at least a minimum of 2 years?
JP, I would, because as I explained to the Chief Justice when he was questioning me, I've always had a particular interest in competition law. I made myself available for consideration for appointment into that court because of my appetite in competition law.
Thanks, Chief Justice.
Thank you, JP. Minister?
Thank you very much, CJ, and good morning, Judge.
Good morning, Minister.
Yeah, I only have one question for you. With the coming into effect of the Competition Amendment Act, we now see the Competition Commission embarking more on market inquiry. Do you think it will have any effect on the issues of access to the markets and dealing with issues of abuse of dominance by the various role players in the markets that they choose to proceed with market inquiries?
Minister, I think the amendments have brought about, the amendments would have far-reaching consequences in the sense that my reading of the Competition Act is now that upon conducting that market inquiry, the Competition Commission is then able to make its findings and suggest some remedial action which is binding, something which is akin to that which prevails in respect of the public protector. So now it's not only a question of looking at the structure of the market and the distortion, it has to make recommendations as to how those are dealt with going forward, which is, in my view, a very welcome intervention, because there had been market inquiries before which would come up with recommendations, and as you would know, there was nothing much that would happen in the way of those recommendations being implemented. But my view is that at least the amendments now have given teeth to the Competition Commission to deal with the structural problems. Because the competition issues, in my view, can be looked at in two ways. There is an issue that pertains to the conduct of the market players, and then there's an issue that deals with structural issues. So the market inquiries are designed, in my view, and can achieve a lot in respect of structural issues.
So do you think this could have the intended impact of having small players also having access to the markets if the market inquiries are used effectively?
The Act makes it clear that that is one of the mandates of the Competition Commission. And upon embarking on those market inquiries, the Commission is able to identify problem areas and is able to recommend solutions. So I think it can have that effect, Minister.
Thank you, CJ.
Thank you, Minister. Commissioner Nyambi.
Morning, Judge Nuku.
Good morning, Commissioner Nyambi.
How will you describe the performance of the Competition Appeal Court, especially in the last few years?
May I ask you to give me a context? Is it in terms of the matters that have been finalized that come before it, or just to help me understand the question properly?
I'm referring to matters that have been finalized by it, given your acting stint and your experience as you have been part of it for the past year and now.
The matters that have come before the Competition Appeal Court, as at the time that I've been acting, and the ones that I've scoped in respect of the last 5 years, I get the impression that they are dealt with speedily, they're finalized timeously. But of course, there's this issue of a low number of case load for that court.
What are the immediate challenges that you think you will address should you be given opportunity to be part of the Competition Appeal Court?
Well, I have not particularly identified any challenges. I make myself available to that court so that I can contribute my understanding of competition issues.
Thanks, Judge Nuku. Thank you, CJ.
Thank you.
Thank you, Commissioner Nyambi. Commissioner Dodovu.
Thank you very much, CJ. Just one question for you, Justice. A number of bodies here acknowledge the fact that you write well, you deliver good judgments, but they also raise a concern about the fact that you have outstanding matters that you had partly, and that you have some reserve judgments, which is a concern. Can you please address us on that and indicate why you have delayed judgments? Thanks.
Thank you, Commissioner. The judgments I listed in my questionnaire were on the 29th of November. Those judgments are in respect of cases I had in that month, and all those judgments have been delivered. I had two partly heard matters that I mentioned in the questionnaire. One is a criminal matter which I'm doing on circuit. It's, I'm going to be finalizing that matter sometime in August. It's set down for 16th of August, continuing thereabout. The other one was, let me just think now, can I? But partly head matters were matters that were our partly head as at that time. So in respect of delay, there is no issue of delay because those were judge matters had in that matter. The part head matters, it's matter, you run a matter and then one counsel is not available, so you have to postpone and there's nothing much you can do. It's not a delay on the part of the judge, but it's just that you can't finalize the matter without the cooperation of the parties.
Are you certain that you were propelled by a burning desire to finalize your reserve judgments, or was it a malicious compliance because you were coming here? This is an experience that I've seen, that a lot of people have that, and at the time that they come here, they rush this judgment so that during the interview they say, we are done with that. And this is a recurrence.
No, that is a fair question, Commissioner, but I can tell you no, because the time frame for the delivery of the judgments that were outstanding as at that time is in line with the time frames generally in respect of which I deliver my judgments. I deliver my judgments timeously. Other than those matters that I listed as outstanding as at that time, I have not picked up that there is a complaint of me delaying the delivery of judgments.
Thank you, CJ.
Thank you very much. Commissioner Matolo-Tlepu.
Good morning, Judge Nuku.
Good morning, Commissioner Matolo-Tlepu.
My question is just a concern regarding, the lack of competition lawyers and competition judges. I mean, it's a concern of this commission that there are very few. We have shortlisted only 2. And there's an outcry from especially black legal practitioners, that we are not exposed to competition law. Most of us have done all those courses and nothing is coming our way. But what do you think can be done to frustrate this? Because it's becoming actually a disaster now. What do you think, in your own view, what do you think can be done to make sure that smaller firms get access to competition law and actually we get more applicants to be judges?
Commissioner, that's a very difficult question because my assessment of the competition law space is that most of the parties that litigate in that space are big corporations, private corporations. And I need not say that, unfortunately, they have no commitment to transformation. The Competition Commission plays its part. It does instruct black attorneys. I know it instructs black counsel to lead the team. So the market, the players really, there is the Competition Commission on one hand, and these big private institutions on the other hand, who kind of seem married to their big 5, if I may say that. So it's really a difficult question for me to answer. I also have been, that's my experience as I was a practitioner, as I was narrating. I had always hoped that I would be able to break into that space. But unfortunately, the private companies don't seem to be keen on utilizing the services of black practitioners. An experience I had many years ago where I had been invited to do a presentation in one of the big insurance companies. I got into their offices and I thought I could get a chance because the person that I was talking to was a black person, but he told me something that was very disheartening, that for him, his bosses will understand if one of the big 5 law firms loses a matter. But if my small practice loses that matter, he may be fired. So there are those considerations that are out there. And how we address that is a big challenge.
Thank you, Justice.
Thank you, Commissioner. Judge President Mlambo.
Thank you very much, Chief Justice. Judge Nogo, good morning.
Good morning, JP Mlambo.
And I want to thank you for availing yourself for this position. It shows that you are serious in the advancement of jurisprudence, especially by black jurists. Let me put it that way. I note that in your questionnaire, you've listed something like 8 or 9 judgments which were reversed, your judgments which were reversed on appeal, and you list 4 which were unsuccessfully appealed against. And I'm just curious, have you had more reversals than affirmations in your career as a judge? Or don't you track that? Like me, once I've written a judgment, that's it.
I only track those ones where the matter is ultimately heard. As you would know, you would hear a matter, you make your decision, there's an application for leave to appeal which you dismiss, and then the parties petition to the Supreme Court of Appeal. I'm not able to track those ones. So I would not put them in the mix.
Okay.
So if those are to be considered, I am certain that there are more matters that have not been successfully appealed than those that were successfully appealed. And then again, coming to those ones that were successfully appealed, I've reflected on them. If you look at them, except just for one, all of those matters are matters that I had in my first 3 years, my appointment, including from 2015. So the last matter would be 2018. And those were complex matters. I have reflected on those matters and I've learned a lot from them.
Thank you for that. Have those judgments in which you were reversed, was there any adverse comment by the appeal judges against how you handled or how you approached the matters?
Broadly, no, but I think there is one matter where the SCA was a bit critical of my acceptance of the deponent's evidence. There is also another matter where not harsh, but it was critical of the manner in which I dealt with agreed facts between experts. I think and then there was, I think there were some, those were the critical comments. But I was not harshly criticized, but.
Thank you very much for that. I've got 2 more questions. One is, I think the Chief Justice took you through your experience, especially in competition law matters. We all come from the same boat. We never even had a whiff of competition law matters when we were in practice. Now, the judge, you say you wrote 2 judgments. One was a minority judgment. I'm interested in the other one, where you say it was unanimous. How long did it take you to write that judgment?
We had that, I think, just over a month. We delivered judgment on the 24th of March. We had the matter during February.
I see. Okay. I've got 2 comments. I think I'm just interested in your comments to the comments I'll make to you. If you prefer not to make a comment, that's fair. The first one, I think the Chief Justice gave you the example of the Labour Court and the Labour Appeal Court at some stage, that it had more labour law specialists in the Labour Court than in the Labour Appeal Court. And someone who may be sitting in this room coined a phrase to deal with that, to say, if you are sitting in the Labour Court and your judgment is reversed by the Labour Appeal Court, you should celebrate because you are correct. And that if the Labour Appeal Court upholds you, you should be worried. Do you have a comment to that?
I would rather not comment on that.
Well, one more. The current Deputy Judge President of the Northern Cape, when she was approached to act in the Labour Appeal Court, she confessed that she had no experience in labour law and requested that she be first appointed to the Labour Court and do some time there before she's considered for the Labour Appeal Court. That was acceded to, and in later years, she actually deputized for long durations as the Judge President of the Labour Appeal Court, having gone through that experience of the Labour Court and then Labour Appeal Court. What do you think of that approach? Just to deal with people who say, I may not have enough competition law experience. I don't know what the regulatory environment is, whether judges can be appointed to the competition tribunal, but I'm just asking, do you have a view about that?
Well, I think in respect of the tribunal, I think there is no scope for judges' participation there. So there is a statutory issue there that would prevent that from happening.
Yes.
But once again, I think it's something that has got to do with how a particular person views his or her shortcomings. And as a way of addressing them, that may be a viable option, as the example you make demonstrates.
Yes. Thank you very much, Chief Justice. I've got no further questions.
Thank you, Judge President. I don't see any other.
I do, Chief Justice, I'm afraid.
Okay. Yes, please go ahead.
Thank you, Chief Justice. Good morning, Judge Nuku.
Good morning, Commissioner Ngwaitobi.
Yes, I just want to follow up the point that was made by your Judge President in the CAC about your philosophical approach to competition as a starting point. But I want to make something tangible so that I can tease out precisely what your philosophy is, because there's, someone can say, I reject the Chicago school, but only to find that their Chicagoists in a closet. So I do want to explore that. The Competition Commission published its findings. They were launched at the Competition Annual Conference last year on concentration levels in the market in South Africa. I mean, the findings show that in the last 20 years, there's been more concentration than less concentration, and that small and medium enterprises, let's call it black firms, that have tried to enter the market have exited on an average of 2 years, which is an illustration of high barriers to entry, also an illustration of how market power is abused, and also finding that, generally speaking, competition policy has been ineffective as an instrument of disciplining the exercise of market power, right? Yes. So that's the context to my question. So I want to ask you whether you think deconcentration of markets should be a goal of competition policy. Because even there is a debate about whether deconcentration per se should be a goal of competition policy, or whether deconcentration only with an anti-competitive element should be a goal of competition policy. So on that philosophical debate, where do you stand?
Deconcentration, which has the results of preventing the participation of black firms in the market, is a problem. That should be the concern for the Competition Commission and the competition authorities. Hence, I say that the issue of the market inquiries is, in my view, one of the tools that can be used to deal with the structure of the market.
No, I'm asking a different question. Do you think deconcentration per se should be a goal of competition policy or not?
Not in the abstract, Commissioner. As I said, deconcentration which has concentration or disconcentration which impedes participation by small and medium enterprises and those firms owned by historically disadvantaged persons is, in terms of the Act, a concern for the competition authorities.
Yes.
I'm not sure if
No,
we're talking past each other.
Yeah, I think we are talking past each other, but I'll leave the question, because I think that that's the very debate. Is some people say concentration is not a problem, right? And others say concentration is a problem per se. And that's what I'm trying to test, because that's where you find this distinction between whether one is a Chicago school believer or whether one actually believes in our Competition Act as such. So that's what I was trying to explore. But I think you've said what you wanted to say on that topic, and there's nothing else to add. Then I want to ask you something else about your own experience and how you can, I would say, mitigate on it. I mean, I think the elephant in the room, I think Judge Manoim, the Chief Justice, as well as Judge Mlambo are touching on this thing, is that people say, well, when we look at Judge Nuku's application, we can see he has potential, but we think that he doesn't have enough years, especially because he has not done competition law before. And you may say it's because of the structure that is racist and that's not enabling black practitioners to get in. So those explanations are fine, but where we stand at the moment is that you don't have the experience. So that's what I want to actually ask you to tell us, that, look, this is not going to be a problem. This is what I'm going to do to fix the deficit in my skills knowledge, because I'm going to a court of appeal. And that court of appeal is very important, because from there we go to the Concord. There is no other avenue of fixing the problems that come with the judgments of the CAC. So we've got to get really tried and tested judges. So that is what is being sort of suggested. And so I don't think it's an answer to say, oh, well, interpreting an economic problem is the same thing as interpreting an RAF problem, because it's clearly not the same thing. So something else is still expected of you to say to this commission, to this commission, to satisfy us that you are not a risk to an appeal court where we have no remedy. If we lose before you, we have no remedy, because the Constitutional Court is not going to accept cases except if they are unique. So you are going to be the final say on these topics. So that's really, I think, what is being tested, is what can you say to us to be satisfied that you are actually a safe pair of hands?
I understand that question, Commissioner Ngoetobi. In answering Chief Justice, I indicated that it is for the Commission to evaluate what I have put in front of it. There is nothing more that I can say more than what my papers demonstrate. If on the basis of that, the feeling is that perhaps it's too early for me to be appointed, I can live with that and continue to act in the Competition Appeal Court if invited. But if the Commission considers my application and thinks that despite my lack of experience, I show good potential which should not be lost, that I can also live with.
Nothing else, Chief Justice.
Thank you, Commissioner Ngoetobi. Commissioner Kay.
Thank you, Chief Justice. Good morning, Judge.
Good morning, Commissioner Kay.
I'm picking up on, or giving you another opportunity to persuade me and others sitting here that notwithstanding your lack of experience in this field, you've gone to trouble to gather what the major debates are in the competition law enforcement area in South Africa involve. In other words, there are policy debates going on in relation to competition law enforcement, and I'd like you to indicate what those are and what you've done to grapple with them, if possible.
Well, the one issue that I picked up that seems to be of great concern to the Competition Commission is the issue of the interpretation of Section 41B of the Competition Act that prohibits certain conduct. And in particular, it seems to me that the concern there is a phenomenon called characterization, which was brought about by the Supreme Court of Appeal in one of the matters that landed in that court, where the Supreme Court of Appeal referred the matter back to the tribunal, saying that the tribunal must embark on this process of characterization. And by that, I understood it to be that what it was saying is that Section 41B needs to be contextualized properly so that when you evaluate a complaint that relates to that section, you are able to see if it's the conduct that should be condemned in terms of that section. Because there may be instances where on the face of it, the conduct at issue appears to be prohibited, but on interpreting that section properly and looking at the conduct may come to a different conclusion. That's one aspect that I have picked up.
I think that I'm looking for an indication of the broader debates, the policy considerations behind what competition law enforcement in South Africa should aim to address.
Well, I think my response goes back to my reading of the Competition Act, and in particular in light of the amendments, that our competition law is not concerned only with pure competition law issues. There are broader issues of public consideration, public policy that come into play.
Thank you, Chief Justice.
Thank you. Commissioner Pillay.
Thank you, Chief Justice. Good morning, Judge Nuku.
Good morning, Commissioner Pillay.
Judge, I'm just mopping up on the adverse comments that have been made by bodies and persons, etc., and quite a few of my fellow commissioners have already dealt with a number of them. There is one outstanding adverse comment which I would like you to respond to, and that's that it was raised by one of the law bodies that you've got limited appellate experience. Now, I'd like you to address that issue, but I would like you to address it in the context of one of the matters that you mentioned, and that's the matter of B versus RAF, where the Supreme Court of Appeal was quite critical because you had gone behind the trial court's finding in relation to the joint expert minute. I don't know if you recall the matter.
Yes, I do recall. Thank you.
And the Supreme Court of Appeal found particularly that that was not appropriate for an appellate court to do. So perhaps I could ask you just to address the underlying concern that you've got limited appellate experience, and then just tie it to that particular matter and the finding of the SCA.
As I have indicated earlier, Commissioner, the comment that I have limited appellate experience is without foundation. Firstly, because of the appeals that we do weekly sometimes. And secondly, the full bench appeals where we sit on judgment in respect of matters coming from our own colleagues. The matter that we referred to is a matter that we had in July 2016. I had indicated earlier on that the majority of the matters that were overturned come from the first 3 years of my appointment as a judge, and I have reflected on them, and I have learned a lot from what the superior courts have said. The issue in that matter, there is always a debate, I sense, when it comes to the evaluation of expert evidence as to where to draw the line between the facts, the opinions, and an expert going as far as now dealing with legal position. I think in that matter, I felt that the agreement between the expert was not only limited to facts, and that is what I was criticized for, and I accept that criticism.
But you do see the difference in the role between a trial court's role and an appellate's court role in the handling of that expert evidence. I think that's the issue that the ACA touched on.
Absolutely, I do, yes. No, as an appellate court, you have no role in respect of undisputed facts, the facts that are common cause, to put it that way, because once they are agreed, they are common cause, you can't go behind that. But the difficulty becomes, as I was trying to explain, where in your view as a judge, this agreement is not just about the facts, but goes further than that, which I think was my mistake in that matter, which I accept.
Thank you, Chief Justice.
Thank you very much, Commissioner Pillay. I don't see any other hands. Commissioner Moiman.
Thank you, Chief Justice. Good morning, Judge Nuku.
Good morning, Commissioner.
Just one question from my side in relation to your appreciation of the Competition Tribunal within the context of the amendment to the Competitions Act. I just want to get your appreciation in relation to what is your understanding of the Competition Tribunal? How does it relate to the Competitions Appeals Court and the Competitions Court? But more than that, how does what is your appreciation in relation to the work of the Competition Tribunal in relation to the abuse of dominance, how can the Competition Tribunal address the challenges with regard to the measure control regime, but more than that, the role of the Competition Tribunal in relation to its work around toughening the penalty regime as envisaged by the amendment to the Competitions Act. Thank you, Chief Justice. Thank you, Judge Nuku.
Thank you very much, Commissioner.
Thank you.
I'm told that we are going to have this load shedding from time to time, but as yesterday, it would be an interruption of a short duration, like 5 minutes. I think we are able to continue. I'm told that there are hands in the virtual platform who would like to put questions to the candidate there.
Thank you, Chief Justice.
Yes.
Clement Marumuahai.
Yes, please go ahead, Commissioner.
Sorry, Chief Justice, should I not first answer the question that was asked?
I'm sorry. With the load shedding, please answer the other question first, and then we go to the Commissioner on virtual.
Thank you, Chief Justice. Thank you, Commissioner. My understanding of the structure of the Competition Act is that we have the Competition Commission, which policies and refers matters to the tribunal, which is an adjudicative body of first instance. It also deals with the major controls. It then makes whatever findings it does, and those in respect of which the parties are unhappy would then come on appeal before the Competition Appeal Court. And in certain instances, its decisions may continue, Chief Justice.
I'm sorry, there is some noise. Just wait a bit. I assume technicians will attend to it. Okay, all right, thank you. You may continue.
So I was saying, and then some of its decision may be subject of review, which reviews then come to the Competition Appeal Court. And in my view, it can't really be for me to say how the tribunal should go about its business, particularly where I have made myself available to sit as an appellate judge in respect of its work. I appreciate that it does a lot of work. There may be certain areas where there might be criticisms. I think that goes with any adjudicative body.
Okay, thank you.
Thank you, Chief Justice. Thank you, Justice Nuku.
Thank you. Commissioner Marum Mwachai.
Marumo Wachai.
Marumo Wachai. I think you could tell from my demeanor that I was... I apologize, Prof, once again, but you can see I'm getting there with the training. Marumo Wachai. Oh, okay. I'll keep on trying. Okay, please don't be offended, Prof. Please go ahead. Oh, can you hear me on the virtual platform? Or maybe it's the effects of the load shedding. We need to wait a bit. Yeah. I think we'll just have to be patient a bit.
Maybe try Mr. Barnard. He seems to have his hand up just to check if...
Commissioner Barnard, can you hear me?
I can hear you, Chief Justice.
Commissioner Barnard, can you hear me?
He says he can hear you, Chief Justice, but it's very faint.
Oh, but I can't hear him.
Yeah, it's coming from here, but the sound is very faint.
Yeah. Maybe we should take a 5 minutes break. Let's take a 5 minutes break so that they can fix the IT. Okay, thank you. We'll take a 5 minutes break, Judge Nuku.
Thank you, Chief Justice.
112. Who must we ask? Mr. Barnard, can you hear me? Mr. Barnard, can you hear me?
Yes, I can hear you.
Thank you. Oh. Can you still hear me, Mr. Barnard?
Yes, I can.
Okay, perfect. Yeah.
We are just waiting for all the commissioners to come in, otherwise the technology has been fixed. Okay, we are going to continue now. Commissioners on the virtual platform, can you hear me?
I can hear you, Chief Justice. It's a bit softer, but we can hear.
Oh,
We can hear you, Chief. It sounds very bad.
Oh, must be my
Affirmative,
voice.
Chief Justice.
Okay, I think Commissioner Barnard had a question for the candidate. Commissioner Barnard, would you like to put your question?
Thank you, Chief Justice. I can just mention Professor Mpumalanga. I think we've lost him online. I'm not sure if he's... he was busy.
Is he back online? Yeah.
I'm not seeing him on our virtual platform.
Yeah, no.
He's gone.
Oh, is he there? Okay.
No, he's not here.
Okay, when it does come on, then we'll give him a chance. But in the meantime, maybe Commissioner Barnard can put his question.
Thank you, Chief Justice. Good morning, Judge Nuku.
Good morning, Commissioner Barnard.
I suppose first we must declare that we were at the Cape Law Society, and I know I visited your home village outside Mthatha at the time as a celebration of your permanent appointment, and enjoyed some of your community's hospitality. So maybe get that out of the way.
Thank you, Commissioner Barnard.
I want to just ask, my question is really just related to the dominance matter, the e-media and multi-choice. And it's really about the differences. I want to ask you about, to perhaps explain to the Commission the difference between your approach and which was the minority judgment, and then the approach of the majority in that matter. It's, reading the matter, it seems you might have been more conservative in your approach than that of the majority, and maybe focused more on the merits, while the majority focused on the fact that it was an application for an interdict pending further competition litigation. So the question is, what was the difference in approaches there? And then the second aspect of that is, what did you learn from that matter having regard to both judgments? Thank you.
Commissioner Barnard, I think the difference boiled down to the question whether I felt whether a prima facie case had been made of the prohibited conduct. The majority felt that the facts had made a case for an abuse of dominance.
Thank you. And what did you learn from that matter? If your experience of having a look at those two judgments?
It's difficult to say what you have learned in a situation where you write a dissent, because a dissent is not something that you write as a matter of course. You write it on the principle that you feel that on the facts before you, a case has not been made. But I accept the decision of the majority, as I must.
Thank you, Judge Nuku. Thank you, Chief Justice.
Thank you, Commissioner Barnard. Is Commissioner Prof available now?
He doesn't seem to be on virtual, Chief Justice.
Yeah. Is there someone else on the virtual platform who wishes to ask questions?
There are no hands up, Chief Justice.
No. Yes. Yes, okay, thank you. I had been given a message earlier on that I think I'm going to say Commissioner Prof until I've mastered the pronunciation, because I don't want to do injustice to his surname. I'd been given the information that he was going to initially be on the virtual platform, but he would join us around tea time. So the Secretariat tells me that they've tried to call him now. He's not picking up. It may be that he's on his way. I'm not sure. So I just share that information with everybody. One doesn't want to conclude in circumstances where a commissioner had questions, but I think the Secretariat would need to keep on trying to get hold of him unless there is a different suggestion. Commissioner Malema?
CJ, that commissioner's surname has got two words. The first word is Marumo. Spears, Marumo. And then Agai. Marumo Agai. So Agai is A-G-A-E. So you call them at the same time, Marumo Agai.
I think you'd make a very good teacher, Commissioner. I think the way you have explained it is Marumo Ahai.
Yes.
Yes. You see, you are a good teacher.
But on a separate matter, CJ, I think if we lost Prof, it shouldn't be something that we can't proceed on the basis that is disconnected. So I think you have made several attempts. You tried, even the commissioners on the platform said it's not there. We still have a lot of candidates to go through.
I know. I don't know what is the feeling of everybody. I was just thinking in case he feels strongly about whatever he wanted to ask. That was my only concern. Let's start with Commissioner Nojesi.
I support Commissioner Malema without further motivations.
Yes, okay. Justice Spencer.
Thank you, Chief Justice. I also concur. He must either be in attendance here or
the
virtual platform.
Okay. Is that what you also wanted
neither
to say?
here, no.
Okay.
Yes.
It looks like that's the. We all agree. Okay. Thank you very much, Judge Nuku. We have come to the end of this interview. Once again, thank you for making yourself available. You are now excused. Thank you.
Thank you, Chief Justice.
I'm going to ask that we have a brief discussion before the next candidate comes in without the media. So if the media could excuse us a bit and don't bring the candidate as yet, Secretariat. Yes. If there are any members of the media inside, they should just leave for a few minutes. Are there any?
I'm just going to leave the letter on the table for him.
Sorry?
I'm just going to leave the letter.
Secretariat, please bring the candidate. Good morning, Judge Spills.
Morning, Chief Justice.
How are you this morning?
Yeah, I'm good, thanks.
Good, thank you.
Except this chair seems to be some problem with it.
You are not comfortable?
It's, it looks like it's about to.
And we have not started asking questions.
Absolutely, I might fall off it.
Do you wish something to be done for it to be changed, or will you manage?
Well, let's see how it goes. I just won't recline.
Oh, I don't want you to fall off while you are being questioned.
We'll try.
Yeah. Okay, all right. You have made yourself available for consideration for appointment as a judge of the Competition Appeal Court. Today is the second day of interviews that this commission is having this month. Yesterday we had a meeting as the commissioners, and we took a resolution adopting selection criteria for appointment for judges in various courts. And one of the commitments we have made is that while on the one hand we will be robust in conducting interviews with candidates where it's required to be robust, at the same time we will have due regard to a candidate's human dignity and respect, will show respect and courtesy. Nobody here wants to or aims to humiliate any candidate or treat any candidate unfairly. So we'll try and strike a balance between making sure that there is proper questioning, but there is respect and courtesy. You understand?
Thank you.
Okay. Now, there are two immediate issues that we'll need to talk about. Before we do that, I just want you to take you through your CV briefly. What are your academic qualifications?
BCom, LLB, HDIP Tax, HDIP Company Law, and then an advanced company law.
Okay, you might wish to speak a little up.
Certainly.
Yeah, BA, LLB, you said.
No, BCom,
LLB, yes.
And then HDIP Tax, HDIP Company Law, and then an advanced company law when the new Company Law Act came in.
Yes.
And all it fits.
Yes. You practiced as an advocate before appointment as a judge, is that correct?
Yes, I was an attorney prior to that as well.
Yes, how many years were you an attorney?
Very briefly. I think it was about a year. I was articled for, so I did part-time law, so I was articled for 2 years, I think, with the article period.
And as an advocate, you practiced for how long before your appointment as a judge?
Can't recall offhand. I think I came to the bar in 73 or 74, and until 2009.
Yes. You were appointed as a judge of the High Court in 2009, is that correct?
Correct.
Yes. So that would mean you have been a judge for about, what, 14 years?
Correct.
Yes. And do you do a lot of commercial matters as a judge of the High Court?
The moment, yes, I have.
Yes.
Sorry, if the answer is over the period, yes.
Yes. In your practice as an advocate, did you also do a lot of commercial matters?
Yes.
Any competition matters? I know at that time
no, I
there
sat
might
on
not have been a competition
My apologies.
appeal court and so on.
No, my experience then was with the Security Regulation Panel on Takeovers and Mergers.
Yes.
I'd served there, I think, since 2004, but I may be wrong
Yes.
with dates. But it was more the experience that I had as an as council, involved with the kind of issues where there would be overreaching or attempts in the telecommunication industry, the airline industry, medical, and I think I mentioned telecommunication, medical as well. Might be one or two other areas where I had commercial, quite intense commercial experience in the dynamics of these industries, airline, telecommunication, media, and medical, pharmaceutical in particular.
You have acted in the Competition Appeal Court. How long have you acted?
I was appointed 2 years ago. I've only had one matter, and it was recently where I sat with the Judge President, well, two Judge Presidents, Judge President Monaghan and Judge President Mpumalanga.
Yes. So you have only sat in one matter?
Correct.
Did you write the judgment in that matter?
No, I'm not the scribe.
Sorry?
It's still being drafted, but I'm not the scribe.
Yes. So is the position that you have never had the opportunity of writing a judgment in the Competition Appeal Court?
Not in the Competition Appeal Court. I did write 2 judgments in the High Court, which did involve aspects of the Competition Act.
But were those reviews, or otherwise how would a competition matter have come to the High Court?
It had to do with the jurisdictional element. The one had to do with the jurisdictional element. The other, and it was actually recorded, I think it's reported in the competition law cases. The citation is there, it's in my application. The other, so there was a jurisdictional aspect. The other, trying to recall, but it had to do with some competitive issue. But again, it might be tangential, but I identified it in my application.
So when you seek to be appointed as a judge of the Competition Appeal Court, bearing in mind that in an acting capacity you have sat only in one matter, what is the basis on which you say you have the requisite knowledge and experience required at the Competition Appeal Court level that you would say we should take into account in?
Thank you.
In deciding whether you should be recommended?
Okay. The competition law is fundamentally about, I think, 3 things. The one is to encourage economic development, and here we have our transformative elements, which are quite unique. And it includes, obviously, the SMEs, the encouraging of SMEs, their growth, and then historically disadvantaged persons entering, having shareholding in corporations. The one level, the other is so that's the economic growth level. Then there's the anti-competitive element, which is to protect consumers or advance the interests of consumers in what may be highly concentrated markets. And the final one is the constitutional imperative, or there may be a fourth, and that is the respect for international conventions. I've had experience in aspects of competition law by reference to the pharmaceutical industry in relation to TRIPS, the TRIPS flexibilities, the Doha Convention, which is in regard to intellectual property, particularly with reference to pharmaceuticals, and access to medicine. So I may not have sat in a court, a competition court, but I think the experience I've had commercially and in these fields, as well as having presented papers on access to medicine at on international platforms, I was invited. I didn't promote myself for it. I did courses, and pursuant to the courses I did, I was invited. So I think I can contribute. I think I can contribute through experience and the application of the principles of market forces, look through the prism of a constitution, and the advancement of our people.
You don't think that, seeing that you have only had the opportunity of sitting in one matter, you would need to sit in more matters before you have reached the stage where you can say you are ready to be appointed to the Competition Appeal Court?
I think I've set out my CV, what
I'm sorry, please raise your
I believe
voice.
I've set out my CV, what I believe I'm capable of, my application in many fields of law where I might have dealt with it for the first time. But that call is yours. It's the JSC's call. But I've laid bare what I believe I'm capable of, my ability in analytical thinking, in concerns for ultimately the various imperatives of legislation, understanding of what they intend to achieve. And I've gone through courses, I believe that, but it's your call. It's the call of the JSC, not mine.
Well, as I think you are aware, there is a complaint that was lodged against you some time back, which seems to remain unresolved. The complaint that was lodged with the Judicial Conduct Committee. I think that seeing that the JCC is effectively a body, a committee under this commission, I think I must apologize to you on behalf of the commission that the complaint hasn't been dealt with for a long time. It would appear that a recommendation was made by the Judicial Conduct Committee for this body to consider deciding that a tribunal should be set up to look into that complaint. We don't have all the information about the complaint here, so from that point of view, it's difficult to ask a lot of questions on it. But we decided that we would give you the opportunity of an interview. I don't know whether you might be aware what the complaint was about.
Sorry, are you asking me now, or must I wait until you've completed what you want to ask me?
Yes, I'm just asking, I don't know if you are aware what the complaint was about that I'm referring to.
In
You
fact,
are not?
Sorry, I didn't mean to interrupt.
Okay, all right.
So, sorry, Chief Justice, if I may.
Yeah, if there's something you want to say.
If I may, yes, I would like to.
Yes.
I've spent something like 2 years asking. I've applied previously for this position. I, in fact, had requested for some time to be considered for an acting appointment to the Competition Appeal Court. I do not know why I wasn't. I was given indirectly, and I'm quite happy to share that with one or two, whoever may be appointed. I think it's inappropriate to disclose what I was told when I let me go back a bit. When I became a judge, I'd applied to become a judge. During that period of application, I was approached by Mervyn King. Mervyn King asked me whether I would consider doing competition law work. I indicated that I think it would be unfair to parties, since I was applying for a position on the bench, to in fact take on a matter. He didn't say what matters they might be, but he suggested that I do that work. Now, he had a man of great experience. He was a judge at the time. He headed the King Commission. I was a member of that King Commission. He headed the insider trading task group for that legislation. I was the originating co-author of that piece of legislation, which became known as the Insider Trading Act, and you'll find it's now in the Companies Act. Why I'm saying this is that others believed that I had that capability, even at the bar. When I came to the bench, I requested the then head of that court to be considered. I heard nothing until many years later, when I attended a conference and there was an indication that there was some training. So I said, well, may I be part of this training? It would have been about 6 years ago, 5-6 years ago. And that, can I please be considered? I was then given what I believe is, in confidence, a reason. I'm happy to share that, but I'm not happy to share it on a public platform. That's number one. Number two, in regard to this matter, I think it should be placed on record that I was approached just before my interview with a letter, being the letter of complaint. I made my position known that I had for 2 years, and it is in the documentation in my application, I think it's a period of 2 years, asked to be advised of what the complaint was. I think the emails that are in that application, my application, I'm sorry to be long about this, but you've asked me, and I'm answering as best as I can. There was no comeback. But literally 10 minutes before my interview, I'm shown a letter. I explained that if this is what that was about, I know nothing about it. I recall the name Cost Consult. I recall the name Hoskins or Haskins. I recall nothing else about the matter. The only thing I could do was to try and Google my name with Cost Consult before I came in, to see when it might have been heard, whatever, because I did not read that letter. I don't know what date it was. I think it was 2017. I may be wrong. But I am concerned that having tried for 2 years, sorry, I didn't mean to ignore anyone, tried for 2 years to establish this, and then asked 5 minutes, 10 minutes before I'm interviewed about it. I do not recall it at all.
Thank you, Judge Bill.
But I would like to say something else with respect.
Yes.
And that is, this body, the judiciary, asked me to go to Botswana and give a 2-day lecture, thorough lecture, seminar, to judges of the Botswana court on the Bangalore principles on the ethics of the judiciary. I find it, well, I can't say, it's not for me to make the call, but it appears that my peers do respect me, do respect my integrity, do respect my work ethic. If something slipped through the cracks, they slipped through the cracks. Again, Chief Justice, I didn't look at the date when the complaint was made or what it was about. If I could be assisted as to the date and the year. But I imagine, I seem to recall, because my first reaction was, why am I asked to go and give lectures on ethics if that is something that's before, to another, in another country, to their judiciary, their whole judiciary. So I'm afraid I have been long-winded about it, but it is concerning that 2 years I've spent trying to get to the bottom of it, and 5-10 minutes before I'm interviewed, I'm then asked, and I do not recall it.
No, thank you, Judge Spiel. So your request or suggestion is that in the light of all the circumstances, the Commission should not attach much weight to it.
Well,
Is that?
I can't speak for the
Oh, you
Commission.
can't. You can't.
The Commission must make its call.
Yes. Okay. No, that's all right. As I understand the position, at the moment you are 74 years old, is that correct?
Okay, now we're talking of my shelf life.
Sorry?
You're talking about my shelf life.
I'm sorry, I can't.
You're talking of my shelf life. My sell-by date.
But am I correct in terms of your age?
Sorry, I think I was trying to formulate an answer and wasn't. I am 74 years of age. I retire next year. My appointment letter came through on the 26th of August, 2009. I was acting from 1 June 2009. I have asked the OCJ to give me a precise date of when my retirement comes up. I have not been given that date yet, but it certainly would not be later than 1 June, if I understand the acting appointment correctly, that it would be taken into account. So, yes, 1 June 2024 will be when I retire. I have indicated, though, if I may anticipate what's coming, and I hope I don't do it inadvertently,
Yeah.
is that I have, and I put this in the letter.
Let me rather put it to you.
Yes, sure, with pleasure. My apologies.
As you have indicated, you would be retiring at 75, which is next year, you say, not later than 1 June, I think you said.
Correct.
Yeah, because Section 3 of the Section 3.2 of the Judges' Remuneration and Conditions of Employment Act provides that permanent judges in the High Court and Supreme Court of Appeal retire at 70 if they have finished a certain number of years in service, and if they haven't finished that number of years, they can continue beyond 70, but nobody can continue beyond 75. Is that right?
There is an exception with respect, Chief Justice, and that exception is if you've got a part heard.
Please just speak up again.
There is an exception,
Yeah.
Chief Justice, and that is if you're sitting with a part heard. And in my representations, I've indicated that I, in fact, do have a part heard. I've indicated its nature. I asked the parties, which is the two accused and the state, what their expected duration of the trial would be, anticipating this question. The accused say if they are not convicted, the trial hearing, the evidence, will take 3 years. And it was 3 years as from the last day of term in March this year. So that takes me to 2026. The state is of the view that it will take 2 years. If I do convict, then there'll be a matter of sentencing. If I don't convict, according to the accused, it'll be 3 years. I can't rush the matter because of already allegations on the record that their fair trial rights are affected because of the a number of things, the health of each accused. The one is what we call an awaiting trial prisoner, effectively detained. And he has been medically examined because I felt it was appropriate at that time, we're going back a year or two, to establish when he could sit. He claimed he could only sit 2 weeks in every 4 or something like that.
But let me interrupt
So,
you.
sorry,
Justice.
bottom
I'm
line, sorry. My apologies,
let
Chief
me
Justice.
interrupt you.
Yes.
It's not my understanding that there is such an exception in the Act. The position would be that if your date of retirement arrives and you have a parted, you would continue with the parted, but it doesn't mean that you would that your retirement would be postponed. That's my understanding. You would continue with your parted, but you get discharged at 75 because the only exception, as I understand the Judges' Remuneration and Conditions of Employment Act, actually there is no exception under that act, as I understand it, for anybody to postpone their retirement beyond age 75. You can stay beyond 70 under certain circumstances, but not beyond 75. Is your understanding different?
It's not that perhaps I put it incorrectly as an exception. I'm obliged to complete this case, however long it takes, however old I might be.
Yes.
That case, sorry, my apologies. That case cannot run continuously because of the medical certificates, and I was long-winded, I apologize for that. Because of the medical certificates, at the moment, the best I can do is 3 weeks running, which is being objected to at the moment, 3 weeks running, 1 week minimum break, they contend 2, but I've directed that they go and have a reassessment. So basically during this period, I am a judge being obliged to complete, and I believe that that period where I am not sitting, because I can't sit, not that I don't want to, I can't sit, I can be of use. Insofar as we're talking of a year and a bit, when I got appointed, I seconded, is the right word, to the Land Claims Court. I believe that within the year, I was able to produce a judgment which I believe has an impact on what was perceived to be limitations of land claims, the way they fill out their form of giving a generalized.
I'm sorry, Judge.
Sorry,
I'm sorry.
then my apologies. I've misunderstood that. I believe I can make a contribution reasonably
Yes,
quickly.
but Judge Spill, what does that have to do with the question whether, as a matter of law, a judge can continue as a judge and postpone his or her retirement beyond age 75? Because that's my question.
Sorry,
it's a question of law.
Okay, my apologies. All I can say is that I am obliged to be here as a judge until that case is over. However you wish to use me during that period is the prerogative. Whether I can remain as a judge and still perform a function as acting, I don't know. If it's not possible, it's not possible. Yeah. But I'm not, again, I'd understood that I can make a contribution immediately.
Well, maybe you can make a contribution, Judge Spill. I said to you, or you knew where I was going with the question about your age, and you wanted to tell me, you said there was an exception. Actually, I put the question to you that at 75 next year, you will be obliged to retire. And you then said there's an exception. And you said if you have a parted, as I understood you. And I said, that's not my understanding of the law. my understanding is you retire, but if you have a parted at the time you retire, you will then continue with the parted. That doesn't affect the position that you are retired. And of course, a judge is a judge even after retirement. So you just continue to finish, but you finish that case only. You are not there to start new cases after you have retired. There is a provision where if you have not reached 75, the JP can call you back to assist for not longer than 3 months a year. But that, I think, won't apply to you because you will have reached 75. So the point is, do you dispute the proposition that in terms of the Act, you will be obliged to retire as a judge when you reach 75 next year in June?
My apologies, I used the word exception incorrectly. No, I don't dispute that. All I think I was looking at the practicalities of my being obliged to, not being obliged, remaining on and being of use. But I don't challenge anything that has been said. I used the word exception inadvisedly.
Yes. Now, if one accepts the position that in June next year, at the latest, as you put it, you have to retire, what public purpose would be served by this commission recommending that you be appointed to the Competition Appeal Court when you have just 1 year to go before you retire, in circumstances where, if necessary and if you want to contribute to that court, you can continue acting, they can let you continue acting, but what purpose would be served, public purpose would be served by us having you recommended for appointment?
There seem to be two issues then. One is the fairness of treatment, where I am now regarded as expendable. I can make myself useful for a short period. The other is that I think I can contribute because if I can, I will have time. Up to June. I've got practical skills. I've got practical knowledge, which I can share. Now, if it's perceived that, well, I must just remain acting, that's, again, the JSE's decision. I'm not here to defend a position. I'm here to hopefully make a contribution. And then the question is the fairness of my input. That's all. But that's, again, with respect, the call of the JSE as to how they perceive such contributions I can make and whether it should justify in these circumstances. And I've laid bare that right from the inception when I became a judge, I had asked to be considered.
Is there a difference between the contribution you can make during the remaining year as an acting judge and the contribution you can make as a permanent judge? Is there a difference in that contribution?
Chief Justice, I made 2 points. The first point was the fairness. You make the call on the fairness. That's it.
Thank you.
But it's not me to make that call either.
Okay, I will allow the Judge President to put questions if he has questions for you. Judge President.
Thanks. Judge Small, I'm going to go into different topics then, really, to deal with issues of the...
Please bring your mic closer, JP.
I was saying to Judge Small, I'll go on to these issues have been covered with you. In relation to the competition issues themselves, I wanted to first deal with your comment in your motivation. It's on page 34 of that pack, if you've got it. And
sorry, page 34.
34 of the manuscript at the bottom of the page. You say
Yes.
in paragraph D that you have a concern that competition law at present does not adequately integrate constitutional requirements, and then you go on to experience. I just wanted to deal with that
Yeah,
first
sure.
part of it as to what did you have in mind when you said that? In other words, is that a reflection on the statute or the way judges have interpreted the statute?
No, I think it's firstly the precursor to the amendments to the Act of the Competition Act is very Eurocentric. In fact, while during this case where gave me the opportunity to sit, their words, their phrases, they do not. They seem to color perception that there's something special outside ordinary fields of economics, commerce, and understanding of anti-competitive behavior that now gets classification. But let me return to the Eurocentric approach. So it starts off with a Eurocentric, particularly when in relation to intellectual property. The amendments to the Act brought about a significant change, but it also has created tensions because it speaks at the same time of economic development and obviously the transformative measures which I referred to earlier. But by the same token, and refers to the Constitution. Now, if you take one example, access to health care. Now, if we look at the first decisions by this Court of Appeal, the Medicare case, there the Competition Appeal Court did not flesh out at that time, the Constitutional Court did, but the Competition Appeal Court didn't flesh out the impact that the access to medicine under the Constitution had on the way one looks at anti-competitive behavior. Sorry, this was a merger. Sorry, my apologies. It was a merger and acquisition, which is also part of the Competition Act and under the court's jurisdiction. So there's that element to it, but added to that is a further layer, which I seem to recall it's in the same provision, the early provision, which then speaks to, but respect international law. That international law then brings back certain of the call it laws that are developed within the World Trade Organization as opposed to the World Health Organization. The World Trade Organization devised TRIPS, and I can speak about that because that's intellectual property, and the intellectual property issues, certainly in regard to the pharmaceutical industry, do impact competition law. They obviously do. The Treat Action campaign was successful in the AIDS issue, HIV/AIDS issue, because it actually went to the Competition Court. To the Competition Tribunal. And it resulted in a finding by the tribunal, and then when it came to the compensation element, they backed off. The pharmaceutical companies backed off. So I don't think we should lose sight of there has to be respect for the international laws because they are there and they do impact on us and the perception of whether you're going to invest in a developing country, South Africa, as opposed to another developing country where your laws may be perceived not to be conducive. So there is a need, I believe, to harmonize these disparate threads, and value judgments are having to be made because the Act requires us to look at all aspects, and one of the aspects will be our international accords such as TRIPS and the extent to which we are balancing our internal aspirations with economic reality of how far do you go and where can you draw a balance. So I hope I've explained as best as I can where I see it. We've got, as far as I know, 2 cases now. The, my apologies, the Medicare, so that's now the Constitutional Court case, and then the e-media case, which has to do with abuse of dominance, which did apply the jurisdiction, the jurisprudence of constitutional input into the considerations of the court. That is where I come from. Thank you.
All right, so the examples you've given, I think the Medicare is the Mediclinic case, the Mediclinic merger by the Constitutional Court, and the Glaxo welcomed related to licensing of antiretrovirals, and those are both examples of where the competition law worked. I understood from this, it worked for the values that you've talked about, the right to health, right to health care, that you saw a failing in other cases.
In earlier cases, I think bear in mind that the initial decision of the Competition Appeal Court in relation to the was it Mediclinic?
Mediclinic, yes.
Mediclinic did not take that into account, and I think the legislation with its amendments is strong and powerful. I don't believe I am saying that that the Act is inadequate. I believe that the Act is remarkably flexible. But we're going to have to apply the Act to exigencies as and when they arise. And there is overseas jurisprudence in countries that have written constitutions which still inhibit issues when it comes to an area I'm familiar with, which is access to medicine. So I wasn't being critical of a process. I think I was being more that I can make a contribution to it in light of these various threads that need to be taken into account and which would have to have regard, in my view, to the facts and what facts need to be fleshed out and their dynamics, how they impact.
How would you deal with the problem that some of the more conservative thinkers saying is that if you move away from the consumer welfare standard to some other standard, there is no limiting doctrine. In other words, everything would be found to be unlawful. How do you, as a judge, if you feel the way you do, deal with that criticism?
I would simply apply our law as it is with the overarching constitutional considerations which would temper inappropriate cases. So, sorry, going through my mind was something, it might come back to me, which would give an example of that, where the law is there, you're not, and again, I'm uncomfortable by pigeonholing things. We need to appreciate the consequence, and I think that's where I'm coming from. We need to appreciate the consequence of using these, what may at first sight be rather extensive and overly progressive, but law develops from a standpoint of taking what there is, not jumping, but through logical progression, applying and characterizing matters in an order where you can rationalize a a greater priority, or a priority. And so I don't see there needs to be a conflict. There needs to be a characterization and understanding of the dynamic, and then bringing across in a rational way that can be, I don't like to use the word sold, but that's the word that comes to me, that can be rationalized legally and practically. So no, there's no jump to another dimension. There is, and if I think I did attach the presentation I made on artificial intelligence and law, and there I referred to a paradigm shift. It had nothing to do with some revolutionary node. It is take your dynamic, understand what you're dealing with, and bring to the fore your key principles. So, access to medicine. One looks at a question of, well, what trumps what? Can one rationally explain whether the constitutional value of right to life, where you have a pandemic, where you have epidemics, how is that supposed to be balanced against the right, the monopolistic right established by a patent? These are things we need to grapple with. The Eurocentric view was that, well, it doesn't, intellectual property is king. That has been ameliorated. So no, there is no jump. There is applying a set of norms, considering all of them, considering their effect, and then finding a way in which one balances in a rational way that can be brought across to others why this approach is rational, why it is not changing something overnight, but rather than taking a value that is more supreme than another value and putting that at the top of the hierarchy. I thank you for giving me that opportunity, because I think I've expressed myself better than I did earlier.
Thanks, JP. Thank you, Judge.
Thank you, Judge President. The Minister indicated he doesn't have any questions. Commissioner Malema.
No, thank you very much, CJ. I just want to make a follow-up on the questions the CJ asked. Maybe put differently. Judge, when are you retiring?
I'm told, I believe, 1 June, should be 1 June 2024. A year and a bit, that's all.
1 June 2024?
Correct.
Now, you saying you are told, I want you to tell me, because you should be knowing yourself, when are you retiring?
I asked, sorry, Commissioner Malema, I had asked about a month and a bit ago, what is my actual retirement date? I am waiting for a response. I have not received it. The calculation is that my appointment, my letter of appointment came through on 26 August 2009. I know this because it was 2 days before my birthday. That's not because I have a great recall. Just happened to be that. My acting appointment, I had acted from 1 June. And as I understood it, as long as you act continually until your appointment, that is taken as the period. So that's why I believe 1 June, but there may be considerations that may or may not advance it. But I believe 1 June is on paper the appropriate date. There were earlier acting stints. I don't know if they're taking into account. I'd understood it's your permanent, continual acting period. So that's why, my apologies. That's why I can't be definite. What I can definitely say is it is no later than 1 June 2024.
I know it's our responsibility to decide to appoint you or not to appoint you. I mean, to recommend to the president to appoint you or not to appoint you. But do you think it's fair for this body to recommend to the president to appoint a person who's going to serve for less than a year in a court where we're actually struggling even to get people? If we appoint you and you go on retirement, it's almost going back to square one. So, in all fairness, and we are going, if we recommend you, we are going to recommend you now is April. We don't know when the president is going to appoint you. He takes his own time. He might appoint you in June, after June. He just appointed now the SABC board. It took forever for him to appoint that board. So it might take whatever period for him to appoint you. And that becomes less than a year into retirement. Really, do you think it is fair for not that you are appointing, but in helping this commission to come up with a good decision? Because after we take a decision of appointing, we'll get subjected to scrutiny. We get criticized, we get applauded and all of that. Do you think it's the right thing to do at this stage?
Fair enough. Thank you for the question. I see fairness slightly differently. If I was competing, there are 5 vacancies. If there were 5 candidates standing, I would not have applied, because I would have taken a position where somebody else could have gained that experience in long term. So I see fairness from that perspective. There are 2 candidates and there are 5 vacancies.
But what do you do to the fiscus? I mean, you are going to get some increase for a position that you almost served for less than a year.
Sorry.
And then you go for the rest of your life with that package. What do you say to the fiscus?
May I assist
Yes.
then? The starting point is that there is no extra remuneration. So if that was a perception by anyone who's not a judge, then if I could assist there, and I'm sure the judge presidents will confirm that, there is no extra remuneration. There is only extra work.
Okay.
Nothing more.
Now the last one, CJ, through your indulgence, the complaint, I know you don't know the merits of the complaint and all of that, and the same happens to all of us, that this complaint is here. We can't do anything about it. We can't say it is a strong case or serious allegations or anything of that sort. And I also don't know, because when they say there is a complaint, in the absence of anything before us, we then Google you, then there will be this tax issue, or maybe, we don't know what the issue.
What issue? My apologies.
No, I'm saying, I'm not saying there's an issue on you. I'm saying, if I were to Google you, and then they say there is a tax issue about you, I didn't Google you, or there is sexual harassment against you, or there's GBV against you, I don't know what the complaint is. But the complaint is firmly there. It's there, it's undisputed. The JCC, they've received the complaint, and the problem is that on our side, the matter is not being resolved, right? And we also don't know what the issues. Will it be fair for us to appoint you without knowing even the merits of the complaint? Because it is undisputed that there is a complaint. It is undisputed. And only after we appoint you, the details, because remember, that's why we said this matter, if it can be resolved outside, let it be resolved, because we didn't want to raise this out of respect in the presence of the media. But once they hear now that there is a complaint against you, then they go and dig up on the complaint, and boom, here we have appointed a person who's accused of serious violations. Will it be fair for this body to appoint you with this complaint that it is before us? Or should we wait and say, let's have the matter resolved, and then we can look into your candidature, perhaps if it's possible. Thanks, CJ.
Thank you. The OCJ had 2 years to find this. I wrote. It's there. It's on the application, and the correspondence is attached at the end. I glanced at it. The only complaint, sorry, I can't say only complaint. The complaint is regarding a delay in a judgment, delivering of a judgment. That's all. It's got nothing to do with my behavior. It's got nothing to do with anything else. So, I believe my record is good in delivering of judgments. Again, I'd like to know what year that was, but I don't think it's current. And I believe that the profession as a whole, through their input, considers me to be courteous, considers me to be hardworking, diligent, applying. So it appears to be a matter concerning a long outstanding judgment at that time. But again, perhaps the Chief Justice can assist us to the year when the complaint was lodged. But
Thank you, Judge.
Sorry, my apologies. I hope I've answered.
Thank you, Guy. Thank you.
Thank you, Commissioner Malema. Commissioner Nyambi.
Thank you, CJ. Afternoon, Judge.
Good afternoon.
The comments by BLA, the issue of late delivery of judgments, and they've also noted the criticism from SCA on the matter of the City of Joburg Metropolitan, and the court noted interference and intervention in the matter, and the inappropriate conduct. Probably to invite your comment to deal with this part of criticism.
Yes. So what I did was I prepared a response which I believe the commissioners have. One in response to everyone other than the BLA, because the BLA appeared to invite a detailed response effectively dealing with allegations made, whereas the others, Nadal would be an example, asked, well, how do I juxtapose, how do I put in context the findings of the Constitutional Court and the SCA with regard to my refusal to recuse myself in a matter, and it was appealed, my refusal to recuse myself in a matter that is ongoing 4.5 years, and it is covered there, but if I may, what I have attempted to set out on reflection, that case started, and I'd forgotten about this, that case started when I was still an acting judge. I'm talking of the Ngobeni matter, because that's the one that's come up. That was, I think it started in early August of 2009. It proceeded until September, late September 2009. My appointment came on, as I said, the 26th of August. So I carried a lot of my profession with me. I carried, I believe, an aggressive, a litigating lawyer, because that's what I was. I also gave opinions, but I was a litigating lawyer. And I think that came through. But I also would like to think that in my explanation, I have addressed that I was searching for truth. It was a very difficult case, and that's why I've put in the short and the longer, the appendix contains a very, what hopefully is a detailed response. I start off by saying that if I found in favor of the plaintiff then, and the police were justified in shooting, I would have done an injustice. And I pointed out that I had, shortly before the case started, made a finding as to how police do react and how they're compelled to react in situations where, on what the police's version was in the civil case, that I understood that I've got to, I cannot do something that would undermine what I had said earlier about their responsibilities and how they can enforce it. But I also said that if I found in favor of the police, but that person that my finding was incorrect, I would again do an injustice. I then identified my approach to how I would weigh the evidence. And the reason I had to do that, and I started realizing the motivation. The person who shot an Inspector Ledwaba was dead. The original investigating officer was dead. How does one assess where, at the end of the day, it's an assault? It has an element of an assault on an individual. I had to disabuse my man, obviously. He ended up being paralyzed from one of the shots. So I'm either going to make a finding in favor of somebody who pointed a gun at a policeman, or I was going to make a finding against the police when they were negligent in taking his firearm, which he said was cocked, and inadvertently pulling the trigger. I explained that I was uncomfortable in using an onus, because an onus in a case like that, where the consequences are so grave, both sides, a policeman who was justified in shooting or a person who should not have been shot. He was doing nothing, and that the scene was swept, basically. So what I did was I explained right in the beginning of my judgment the factors that I was going to take into account. I was going to look at the forensics. I was going to look at the evidence overall, and I was also going to look at what the procedure police, the standard procedures that would be applied if there were two people at a scene, which is what the police's version was, as opposed to one person being the plaintiff only. I did as thorough a job as I could, but my search was for truth. What I realized on reading the SCA's judgment was that abrasiveness that I came with as a counsel, and again, I only appreciated it when looking at it again, that it's a different outlook between that and the responsibility of a judge and the perceptions that are created by either an abrasiveness. And what I'd like you to draw from this is where I am now. And what I've tried to indicate is that insofar as there was a complaint about the way I conducted the inspection, I've explained that. I explained why I could not visualize the scene from the photographs. It became difficult. And when that becomes difficult for a presiding officer, I believe he has a duty to go and resolve that in his mind by going to the scene. An elaborate scene was created for me. We were just going to look at the scene so I get a picture. And I'd actually asked counsel for the defense, have you seen the scene? The answer was no. So it was in a way not the blind leading the blind, but an uninformed. I was going to receive an uninformed argument, and I was uninformed. I was having difficulty visualizing. But when we got to the scene, what then emerged was So basically, it is the city of Johannesburg, but it was, but their rights have been subrogated by either insurance or reinsurance company. So basically, the claims manager or whoever was the representative had then created a scene. And the vehicle in which the plaintiff was also brought on the scene. So they wanted to take measurements, they wanted to do things. I explained to them that to do all this is going to be incredibly difficult. Does anyone have a camera? Let's take photographs and let's see. There were photographs by the police had taken on the night. So there were those. They said no one had a camera. I enjoyed street photography, so I always had a camera in my car. So I said, here, I've got a camera. Take photographs, take what you want. No one offered. So I said, well, then I'm happy to take the photographs. Tell me what you want me to look at. I will take them. If there's something that I find that I think may be relevant, may be of relevance, I will tell you and can be taken. What the parties did then was to have detailed measurements. They prepared the detailed measurements. They described the measurements that were taken, and those photographs all became part of the record. So I was of the view, wrongly, that it was unnecessary for me to provide a minute. It was wrong because Mr. McKesson, sorry, the owner of the vehicle that was brought, it turned out that vehicle, in fact, was the very vehicle that was driven by the plaintiff on that night, and it still had holes in it. He then wanted to explain the holes, or he was asked, but there was both the exterior door and then there was the inner panel. And instead of noting or asking him to say nothing, because I think that it was quite fluid. I was being shown measurements and things were happening.
I'm sorry, I'm interrupting you, Judge Spills. Can I appeal to you to try your best to give concise answers?
With pleasure, but I am basically being asked about something that I've actually responded to in that note. So I'll be short then. My answers and my rationale are in the appendix. Insofar as where I am now, insofar as the inspection is concerned, I've given a judgment on inspections in land claims matters. I believe it is a thorough roadmap, so I believe I've gained from that. Insofar as the question of my temperament, my running a court, whether I'm descending into the arena, that matter before the Constitutional Court and the SCA, the recusal applications, the Porritt matter. There were, and it's written in my note, 1,800 or more pages of founding papers where effectively 4 years of that case was put through a microscope, and they challenged everything I did. The basis, saying I was descending into the arena using Ngobeni, I refused to recuse myself. And and then it was taken to the SCA. The SCA upheld my decision. They then asked for reconsideration by the SCA. It refused. It then went to the Constitutional Court, which refused, and then again a reconsideration was sought. So I believe I've been taken through how I conduct myself. And I believe that the considerations of the balance of the legal fraternity as to my temperament and my conduct, how I run a court, does reflect that I am not that person, that abrasive person that came in and threw my toys out the cot.
Thanks. My last one. So that when doing deliberations, I don't become unfair to you, as you won't be part of it. CJ asked a question that what will be the difference acting now till your retirement and being appointed permanent? And I want to confirm what was your actual response to that question.
Fairness. Fairness. A person who, right from the beginning, had been identified while at the bar as having the capability of being in that court, not being given that opportunity right through my career. And eventually, through Judge Victor, 2 years ago, I think, when she was acting, and then Judge Valley when he was acting, there were no cases that came through for me at that time. So I've been waiting and I've been sitting and I've been waiting. It's your call. I'm not going to go with that further. It's a matter of fairness, as you perceive that fairness, as to whether there should be some form of recognition to being in that court or whether it's going to be an acting. I'm not making that call.
Thanks. Thank you, CJ.
Thank you, Commissioner Nyambi. Commissioner Baloyi? Sorry? Follow up? Okay. Commissioner Malema?
Thank you. No, let me understand this. That you have been identified from the bar and then this has not been happening and all of that, then you say fairness. Do you think you are entitled to this position?
No.
Because that explanation comes across as saying, I'm entitled to this position.
Not at all. It's something for you to consider. I'm just raising it. I'm not saying one way or the other.
Okay.
Thank you.
Thank you.
Thank you. Another follow-up? Okay.
It's a quick one, CJ. Have you applied for this position before?
Yes.
Which year was it?
I think 2 years ago.
The same position of this?
I believe so, yes.
Okay, I missed that point. Thanks.
Thank you. Thank you. Commissioner Baloyi first.
Thank you, CJ. Good afternoon, Judge.
Yeah, afternoon.
Yes. Judge, my concern is about your availability.
I'm sorry to interrupt you, Commissioner. I just want to say, with regard to the date of your retirement, Judge Spill, the Secretariat has informed me that they have contacted a senior person who deals with the discharge of judges and benefits, and it's somebody that I know has been dealing with these things for a long time, yeah. And she says that your date of retirement is 22 March next year.
That's good.
Okay, all right. I'm sorry I interrupted you.
Well, then, thank you then. Then it's even shorter.
Yes.
It's March.
Thank you. Judge Spill, I started to say my concern is about your availability. You, in this sporadic matter that you are doing, you say that it's set down to sit 3 weeks of every 4 weeks. Now, that's what you say in writing, and I think when you were speaking there, you might have said 2 out of 4, but whichever it is, it seems like you're therefore not available to, in fact, discharge duties if you were to be appointed to the CAC, because on that formulation, you left only with 1 week in a month. And I don't see, and if you care to comment, I don't see how that works out to avail you to sit in the CAC if you were to be appointed. Do you have any? Do you want to comment?
Yes, certainly. There are 2 comments. The first is that is my optimal, is 3 weeks out of every 4. They contend that they can't. They raise their need to prepare. Again, each time they do it, I've got to consider their fair trial right. I've got to weigh the amount. We're talking of hundreds of thousands of documents, by the way. So far, I don't know how many tens of thousands have been. But Mr. Porritt is in prison. He claims that he doesn't have adequate access to all the documents, etc., etc., etc. So every now and then, I've got to give more time, but it's got to be motivated. That's why I'm not prepared to say anything under that period. That's the first thing. The second thing is that the Competition Appeal Court sits, I think, 1 week at the end of every term, or is now trying to be more accommodating as to when, but effectively a 2 week, I think a 2 week, 1 week for preparation and 1 week for the hearing. And it appears to be, but then I'm subject to correction. I don't know, but I'm sure the JP will enlighten everyone during your caucus that it's unlikely to be more than 2 weeks in every term. That needs to be set aside. So it would appear not to be a problem.
Can I just put it this way? If we work off how you formulated it, you've worked on the basis that it will be 3 weeks of every 4 weeks. And you must have thought about it, reflected on it, and decided that's how it's likely to run. And
No, I didn't say, my apologies.
May I just finish, please?
Yes, you may. My apologies.
I accept that you say that the parties think differently, but on your planning, you work on the basis, and let's assume that is so. That's how it plays out. That as a matter of fact, you sit every 3 weeks or 4, right? And include preparation in there. Can we at least accept that leaves you potentially with just a week to be available for the CAC work? You've now said there will be a week for preparation. Then you don't have that time for preparation. So we're likely to run into the trouble that because your trial must take precedence, I would assume.
Yes.
We are likely to run into the trouble that you get appointed, and yet through no fault of your own, you're not available on this formulation.
A term is three months. The
Sorry?
term with respect is 3 months.
Yes, how does that help?
Well,
I'm not sure. How does it answer what I'm asking you?
Because we work around that period. We can work around that period. So last week of term, the last week of term would be available. Week before that would be available. And the reality, because I've been conservative, the reality is that there are applications and there are requests to have longer time to prepare between the periods. And the difficulty I have as the presiding judge is the concern about a fair trial right. So when Mr. Porritt says, I have got hundreds of documents to go through, I don't have them with me, or I need to consult, there's a limitation to how he can consult, or he claims there is. So effectively, that is very conservative. Historically,
yes,
it is not so.
Okay, thank you. Thank you, Judge. Thank you, CJ.
Thank you. Before I go to the minister, I just want to say we are not doing very well in terms of time, commissioners. Obviously, if there are strong issues that you feel haven't been covered, that you think are important to be covered, by all means, I'll let you ask questions. But I'm just asking everybody to reflect and see whether whatever they may have wanted to ask, whether it's really important given the time constraints. Minister? Oh, okay, all right. Commissioner Maru. Okay, please. Marumo Ahai.
Marumo Ahai.
Yes, thank you. Commissioner Malema has helped me, so I think I'm improving.
It's sad because even his name is always butchered, you know.
I'm sorry.
But I'm indebted.
I'm sorry.
Good afternoon, Judge.
Afternoon.
When you started, I got the impression that even though you don't have much experience in competition law issues, there is an issue that you seemed to be more interested in, which is mergers and acquisition. You kept on referring to that. And when I looked through your work, I could not find a judgment that I could actually talk to you about.
that you have, and of course, I understand the limitations and your experiences in terms of not having those kind of competition law judgments, and I take that. But I'm curious, when a judge is appointed to that court, which I consider very important, and it seems like I get a sense from judges of the High Court that this is just another court where we can come with our experience and be able to perform our functions. And that might be true to some extent. But I just want to test your engagement or your thinking around competition law issues generally, and specifically to those that I'm going to pose to you. And I think that is important because I need to have some sense of comfort that as a judge, you have thought through about competition issues, both on the law and the economic side of things. I want to ask you, in relation to mergers and acquisition, obviously Section 12 and Section 12A of the Competition Act deals with mergers. The other one defines what a merger is. The other one deals with the requirements and all those kind of things. The question that I'm not sure if you have thought about this, but I would really like to hear your views on it. What role does public interest play in mergers generally? And how should South Africa approach the issue of mergers, which on the one hand, they seem to be promoting employment and they will lead to job opportunities. But on the other hand, they seem to be restricting new entrants into the market. How should we deal with that, and how should we balance that? It's just something that has always been on my mind. I just want to hear your views on that.
Sure. But I need to take, if I may, there are three assumptions made. The first is that I'm focusing on merger. No, I see it holistically. So competition law is competition law, warts and all. So it's not, I wasn't trying to.
So sorry, Judge, I was asking just to be fair to you, to ask you something that you have exposed
No,
to.
I'm more
and
than
I was
happy
just
to.
asking in relation to what you said. I was not making an assumption that you are.
Obvious. Sorry, I misunderstood then. Insofar as merger and acquisitions, my experience was at the Security Regulation Panel, where I was a panelist, I think the appeal panel, for I think 3 or 4 years, 2004 to 5 years. So again, it's I think the Section 12A is mergers. So 12, I think I'm right. But what it requires is to take into account those earlier values that are set out right in the beginning, the purpose of the Act. So yes, it is a difficult issue. And again, I think what one has to do is understand the factual matrix, the facts, sorry. Understand the facts. Understand the dynamics of A, where we are now, and B, where it's likely to take us, because that's what mergers and acquisitions is about, and the concern about the monopolistic or cartel environment it might create, and all the other problems it might create. So there is a balancing. I think unless we have a specific case before us where that is weighed and said, well, what impact will it have now? Does it have an immediate impact? But then again, does it have an impact in the future? And then we've also got to have regard not only to its dynamic in A, with regard to employment opportunities, B, the concern about concentration, C, the uncompetitiveness it may result in, and D, if I haven't mentioned it already, the impact on the consumer and the long-term effect that all these may have on each of those variables. So I can't give you and say this is at the focus. These are the tools that we have. these are the things we should be concerned about, and not just now, but what is going to happen, and that's the real problem, I think, and the quandary, is do we see it as immediate short-term? Do we see it longer-term, a 5-year? Or should we be looking at these issues and not speculating, but informed decisions based on the expert evidence presented as to where will it really take us to? And is it beneficial overall, if not a weighing of those? But I can't take it more than that in this forum.
No, it's fine. I'll leave it at that. I'm going to ask you another question, content-based, because I want to satisfy myself that the person who's going to sit in that court really does understand the issues that generally arise. What is your view on the dichotomy between horizontal and vertical restraints? And in particular, what should be the South Africa's approach in relation to rule of reason and per se restrictions, per se rule?
Sorry, rule of reason and the per se?
The per se rule.
Again, I think you can accept that I am not steeped in the subject.
It's fine.
But I think you can accept that these are terms that are used to describe a situation and a possible outcome or a deeming situation. But at the end of the day, there are countervailing, as you've just pointed out. You even have the situation of vertical affecting horizontal, horizontal affecting vertical. So even if we stayed just within a paradigm, we may not be able to stay within one paradigm either. But if we are looking at vertical and we're looking at horizontal, there are a lot of impacts. And to then try and classify, and that is my concern about the way it's been approached. One's got to open up and not compartmentalize, because there are nuances. And when you hear, and when I heard argument, what is coming through is sometimes you're trying to fit a round peg into a square hole, because that is the norm, that is the perceived norm internationally. And again, I'm not knocking it. They come with a vast experience, and they've been able to hone in on a phrase that explains something much bigger.
I think it's more complicated than that, but thank you very much.
Yes, but also thank you, Professor Maruma Achai, because I want to follow up just on one small issue. It's not...
Commissioner Muratobi, please follow up.
Yes,
that's the last person I have on my list.
Yes.
Yeah, thank you.
I was trying to restrain myself.
Oh.
but Judge Spilk, if I could just, in relation to the 2 points that were raised with you, the per se rule and the rule of reason, maybe to simplify it, what is the difference between Section 41A and Section 41B of the Act?
You're asking me, basically, I think if I'm correct, 41A deems certain things, 41A is about a prohibited practices, so Section 4 is dealing with prohibited practices.
Well, both of them deal with prohibited practices. But
yes.
What's the difference?
Well, sorry. Now you've got your horizontal and your vertical. Now, I can't recall offhand if 4.1 and 4.2 are the separators between horizontal and vertical. If not, then horizontal has a general consideration, and then you've got your specifics. That's my recollection, but all I need to do is Google the Act, call it up, and I can tell you straight away, because it's that simple.
Thank you, Chief Justice.
Thank you. Commissioner Pillay, you are the last one.
Thank you, Chief Justice. Good afternoon, Judge
Afternoon.
Spilk. Mine is only to deal with the 2 objections that have been raised against your application, Judge Spilk. And in relation to both of them, you were given notice of the objections, and you've responded comprehensively in writing.
Yeah.
I just want to summarize your responses so that we have it on record. In relation to the objection by Makakula attorneys, the essence of the objection was that they appeared in a matter, that represented litigants in a matter before you, that they didn't get a court order from you which to enable them to tax costs. And I think your response was that you handed down an order as you should have, but that the responsibility to get the actual physical copy of the court order, that's left to the attorneys to sort out, and it's not something that falls within your purview. Am I correct? That's your response?
Correct. That they need to go to my registrar or registrar, get the file, and as I showed on that screenshot, has got that order that was given, and it was merely a matter of the attorney, if they were in court as they claim to have been, to have taken that file to the typist and had the order made.
Thank you. The second objection is the one from Koikanyang Incorporated, and it relates to the Grace Chauke matter. The essence of the objection is that there was an urgent application before you, that the matter was argued in August 2023, and as at August 2020, and as at March 2023, the judgment in that matter was still outstanding. Now, your response, I think, as I understand your response, is that there was an inspection in loco and you don't give the exact date of the inspection, but you traveled out to the site?
No, I didn't. I directed that the parties go out.
Right,
I was not involved in that.
You weren't there at the time?
No, I told them that the simplest way of resolving it was if there were, remember we're talking of what is removal of people from a stand of land. They said that they were there. The city had claimed that they were only demolishing or removing those who did not have structures. There were photographs. It was a simple matter. Instead of all the fancy arguments that I was being presented, it's an urgent court and it was a busy role. They go out, they look for themselves, they report back, because what you see can't be hidden. It's a simple matter.
May I just ask, was the matter, did the court reconvene after the inspection?
Yes, I was told that they had identified which and who was and was not there.
The question is, did the court reconvene?
Yes, we did.
Yeah, that's the answer.
And the matter was argued and it was left at that stage?
No,
judgment has been handed down?
No, what happened was I was told, I can't recall when argument, I think argument may have preceded. They then were told to go out. There may have been further argument, but what did happen was that the city said that they accepted that those who were there or had been there should not have been removed. And that was it. So the urgency was now dissipated. The question, and it basically had been resolved by the parties. When I was eventually told, because I had a lot of stories before then, but what I eventually was told during the course of whether it was argument or discussion or an understanding of what that inspection had revealed, that I was satisfied that the city and the party had understood in clear terms who could remain, who had the structures, and who didn't. My recollection is that names of the individuals, because there was a group of applicants, not just one, were identified and was accepted. And if I could just add to that, is that I've referred to the fact that nobody after that, neither for the applicant nor the respondent, asked me for a judgment or decision or ruling. So I had accepted that they had sorted it out.
Thank you, Chief Justice.
Thank you. May I just follow up?
Yes, sure.
Was this an urgent application?
Yes.
It had come before you in August of 2020?
2020, I think.
2020.
It was during COVID.
Yes, during COVID.
Yeah.
And are you saying that as we speak now, it is true that no order was made and no judgment was made? There may be an explanation, but I just want you to confirm.
Yes, correct, because there was no need. And
Was
nor
there-
had anyone asked for it afterwards.
Was there a settlement agreement between the parties?
No, there was no settlement. They'd sorted themselves out, it seemed.
Outside of court, or they sort it out outside of court?
They told me, the city said that there was that they accepted that those who were entitled to have been there and who could show that they were there at the inspection, they were entitled to be there. That was it. And the applicants accepted that. I think there were 1 or 2 people, or maybe 3 or 4, who could not show that there'd been any demolition, and that was all accepted. So that was the end of the matter. I moved on to my next matter.
But that's strange for me, Judge Spiel, you know. As far as I know, a matter comes to an end, a matter in court comes to an end because there is an order of court or a settlement agreement. I don't know of any other way, because of course, if one party withdraws the matter, that's another way. But based on what you are telling us, there's no settlement agreement, there's no order of court, there was no withdrawal.
Correct. And that, in fact, has happened recently, where in the land claims.
Yeah, please don't tell me about the other one.
No,
So
I
the-
need
the-
to, with respect.
No. This is a matter which comes before you. It's an urgent application.
Yes.
Parties go out to have a look. Was it not your responsibility to ensure that there is a formal ending of the matter one way or another? Either the applicant withdraws the application if they have reached an agreement, or the parties conclude a settlement agreement, or you issue an order one way or another, rather than have it just pending.
With respect to what I was being told is that there's nothing pending. They've sorted it out. And it has happened, and I need to explain this because the perception is that there is no alternative. In the land claims, I'm told it's settled. I have now insisted, not insisted, I said, could I please have an order so that we can close the file properly? But it does happen.
But in the absence of a settlement agreement or a withdrawal or an order, what is the status of that file? If the head of court wants to deal with it to say, is this matter finalized or is it still pending? Must a date be arranged? What does it do with it? What is the status of that file?
I would explain if there was a problem. But as I say, nobody asked me after that, and nor does that complaint say that anyone had asked me to provide reasons or an order. So they sorted it out. And I believe that is the end, that is the answer that I give, is that everyone had accepted that they had sorted it out amongst themselves. That was it.
Well, I'll let Commissioner Place
Sure.
put one question.
Sorry.
But I wanted to say to you, I think it's the responsibility of a judge who has been seized with a matter to make sure that there is clarity about the status of the matter going forward.
Thank you. Thank
Judge
you,
Paul,
Chief
just
Justice.
Yes, Commissioner Place?
Thank you, Chief Justice. I'm sorry about this. I just want to put on record what the complaint is, in fairness to the complainant. The complainant says that the matter was heard in July 2020. It was postponed to August 2020 for an inspection in loco to be conducted. And then he says the matter was argued on about August 2020, which is consistent with what you've said today. It reconvened after the inspection in loco. And it says here that Judge Spilg reserved judgment on that day. That's what the complainant says.
So in other words, the complainant is saying
Fair
something
enough.
different.
Yeah.
He says the matter was argued before you. They have been waiting for a judgment. There has been no judgment. That's different from what you are telling us.
No, well, it's a matter of recollection. I actually I asked my registrar when the matter came through if she could give me the file and could she give me any record. They can't find the file, and insofar as the record is concerned, there was only the one recording that was available, and as I indicated, the technician couldn't, or apparently it needs a technician who may or may not be able to get the second recording. My recollection, and it's my recollection going back 3 years, is that yes, there was argument. I can't recall when, but obviously I accept that it was after the inspection. But the argument would have gone on the basis, what are you guys fighting for? Have you not identified who is, who isn't? And they would have said yes. And that was it. as far as I can recall.
Okay,
CJ, just
I think I would prefer to leave it to the JP of your court. He might wish to follow it up in court. I'm not sure. Okay, Justice Spitzer.
Thank you, Chief Justice. Good afternoon, Judge Spilk.
Afternoon.
You have already accepted that the matter was argued before you,
Yes.
and surely your bench book should tell you how the matter was ultimately disposed of.
Yes.
Because we have a complaint here where the parties tells us, we argued the matter, the judge reserved, we went away, it's 2023, we're still waiting.
Yes.
And
my understanding was that they had resolved it, that they amongst themselves, when I had indicated, well, what are we really fighting about? Is there not the simple thing?
But
sorry, my apologies.
But they didn't come both to you, did they, to say we have resolved the matter? You might have been told by
correct.
whatever source.
No, they didn't. In court, it was apparent that they had identified who is and who wasn't, and that was fine.
Yes, but what I'm putting to you is, can we accept that after they'd gone on your suggestion to do the inspection, they never came both parties to you and said, we have resolved the matter? You heard through some source that they'd resolved
Correct.
it. But that's not acceptable.
Okay.
You can't have parties before you who have a dispute, and they bring the dispute as an urgent dispute. You're supposed to resolve it. You hear argument, they go away, and you hear from somebody that the matter was resolved, and as a judge who was dealing with the matter, you never do anything to get the parties back to confirm to you that the matter was resolved. You accept that?
Yes, I do, but nobody came back to me and said, where's a judgment or anything of the nature. So I think my assumption at the time was a fair assumption that if I'm wrong, well, I'm wrong, but nobody until this complaint has ever asked me where's the judgment or anything like that, neither party. So my assumption was that it had been sorted out.
Okay, you can see I've been battling to try and finalize, but Commissioner Malema
Yes, sure.
and the Prof.
Judge, which procedure is that one that after arguments and everything else, instead of issuing for judgment, someone must come and tell you to issue a judgment? Which procedure are you referring to?
No, I'm not referring to any procedure, but if a party or something slips by, then you will get some notification saying, we're awaiting a judgment, nothing has happened. You said you were reserving, we haven't heard it. Nothing like that happened.
No. You owe us justice. We came before you, we argued, and you know it's the practice of the practitioners respecting judges. You can't be saying to the judge, when are you delivering, because there's no such a procedure anyway. You can't refer me to any procedure. In the absence of that, are you saying for as long as there's no one who says where's the judgment, you will never issue a judgment?
No, that's not what I'm saying. What I'm saying is that I understood that through when the argument proceeded, because clearly there was argument after the inspection, I identified what was really there, what was at stake, and what was at stake had been resolved. Because through argument, it was accepted that these people were in fact there, this group, and another group, I can't remember, 3 or 4, were not there. That was it.
And you hear from someone that we're not even told about, that the matter has been resolved, meaning that you heard it from a gossip.
No,
because the only procedural way, if it's not gossip, even if it's written in the papers, you can't even cite that as a judge. Whereas an unidentifiable body, The only procedure is that they must come before you and say we have resolved the matter. They've never come before you, and in the absence of them coming before you, what do you do as a judge? Because there are a lot of young practitioners who are listening here. They are learning through this process. If the parties before you don't come to you to say we have resolved the matter, what do you do as a judge? Do you go and hear things through a grapevine? Do you go and read about them in the papers? What do you do for as long as the two because you are a court as you sit there. As long as the court has not been told by the parties interested that they've not resolved the matter, what is the procedure?
That is why I was hoping to get that recording, because it was in that
Judge
process
Bill,
the various
Judge Bill,
council.
I'm going to interrupt you, I'm sorry. The question is simple. What do you do in this situation? What procedure do you follow? The answer should be, this is the procedure. If you know it, if you don't know it, I don't know what procedure is applicable.
No, thank you. But it was prefaced on the basis that it's gossip. It wasn't gossip. It was the parties themselves during that hearing.
No, but Commissioner Malema is talking about after the inspection. He says they didn't come back to you, both parties, to say we have resolved the matter. And he's asking, where that has not happened, what procedure do you follow as a judge?
But before he answered, Chief Justice, you said to him, you heard from someone.
Yes.
And he confirmed that he heard from someone.
Yes.
So he can't now say he heard from the parties. He said he heard from someone, and then that the parties have resolved the matter. I'm saying, you cannot hear from someone or the paper other than the parties which appeared before you. In a situation where the two parties never said to you in court that we have resolved this matter, even if you hear it outside, as long as these two have not come before you, what is the way forward?
Okay. All right. The facts of this was that there was an inspection. I wasn't sure when we started this discussion whether the argument was before and after the inspection or just before the inspection. The Commissioner pointed out that the complaint indicated that there was argument afterwards, so I accepted that. So trying to recall what happened. They have their inspection, they come back. One of the council adopts a high-handed attitude effectively regarding, yes, but we've always had this position. I then flesh it out between them, and the outcome is there's an acceptance that those identified at that inspection who had a structure there could not have been demolished, because the city's case was that they never demolished any structure that was there. The outcome of the inspection showed that there had been a demolition. Those people, the occupants, had been then identified. There were others, 3 or 4, where weren't. During that argument, it was accepted that those, because that was the city's case, if you had a structure, we couldn't have demolished it. We couldn't. And it's clear because that's the law. So it was from the parties themselves during the argument where that arose. So it is hearing when that argument took place, because I believe there was argument before and after having been told what that complaint is. It wasn't just before. There was a sequence of argument, yes.
But Judge Spill, if you now say that this is what was said during the argument that took place after the inspection, that there was an acceptance by one of the sides of certain proposition, if they didn't tell you at that hearing that the matter was resolved, on what basis did you not give an order or decision if there was no settlement agreement? Because it seems to me from what you are saying that earlier on You suggested that they should do an inspection, which they went and did. Then they came back and presented argument before you. During the argument, one of the parties accepted a certain proposition from the other side. But they didn't say to you, we have resolved the matter. And if they didn't say we have resolved the matter, on what basis did you not give an order or judgment then?
Chief Justice, I'm going back a bit, but my recollection, and it may be faulty, but that is my recollection, is that in engaging, it was accepted by the parties that those who had been demolished and they were identified, they could, the application was to stop an eviction or to allow them to go back or whatever. And I was comfortable that that had taken place. So I accept that I should have made a note, but I'd understood that it had been resolved, and the fact that nobody came back indicates to me that it had been sorted out and my understanding was correct.
But come back from where? Because the inspection had happened before the second time of argument. So they were to come back from doing what? The second time when they came back to argue, there had been an inspection. They argued.
There was a pig-headedness, I mustn't use that term. There was an attitude adopted by certain counsel that did not make sense, and I then fleshed it out, and then it was accepted.
But at the end of that session, did they say we have resolved the matter?
No, I'd understood that they had. They did not say so expressly. I'd understood that they had identified and had worked out through the problem and through my engagement with them.
So they had an argument before you for you to decide the matter. They left without saying they have resolved the matter, and they did not say you don't have to make an order. They didn't say you don't have to give a judgment, but you decided not to give a judgment because during argument, some proposition was accepted.
Yes, they had accepted that this was the rational way, that you can identify who the people were, and that was it.
Okay, I think...
CJ.
Oh, okay, I'm sorry.
Yeah, CJ, I was just, you took from me when I was doing the...
You want a follow-up?
That follow-up, yeah.
Okay.
So now, we are now agreeing that...
sorry.
What the CJ was saying to you, which you agreed to, that you heard it from someone, it doesn't exist. It's not true. It's not correct. You didn't hear from someone that there was a settlement.
No, it was during the course of the arguing and putting positions or putting my concerns or putting my understanding to the parties.
So now I'm saying you are leaving that one, that argument that we were saying you heard from someone that they've resolved.
No, I don't believe I ever said that.
You said that the CJ said to you, you heard it from someone. And you said, I heard it from someone that the parties have resolved this matter. We are leaving that one.
No, I don't recall saying it. I don't believe I said it. If I did, it was always incorrect if I did say it. But my recollection is that it was after the inspection, but it was always the parties themselves who were before me. And I certainly didn't hear from anyone other than, or make any assumptions other than from what was put to me and what was argued before me and their responses, but it was only the council involved.
Yeah,
so there's no misunderstanding on that.
Okay.
There was no third party.
So let's leave that one. Even on this one, the parties have never said to you, we have resolved this matter. They've never said that.
Not expressly. I understood that they had.
Not
expressly, no.
I might not understand those things of expressly, and I'm not a lawyer, I'm a layman. I want to live here and go and explain properly.
Yeah.
No one ever said to you, we have resolved this matter, of the parties.
Sorry, can I just try and recall? I may have put, then, is there any issue where A, B, and C are accepted, D, E, and F are accepted. And that's it. You know, my difficulty is that I've tried to get correspondence that preceded this, because there was correspondence that preceded this, but I can't.
No, Judge.
If I may, sorry, my apologies, I don't mean to be disrespectful.
No, I hear you, but I'm saying to you, in your own ways, there's nothing wrong with accepting that, the version you have put to us. I'm trying to put it in a layman's perspective. That which you are doing now of trying to say, you have said this, and then you have said that, you all do that all the time. And then Mugai Tobe and them will say, no, the other party has conceded, the other party has. Conceding and not conceding does not mean you can't deliver judgment, or you conclude that now the other party, because it conceded, it means now there is an agreement. And then there must not be a judgment. You know that. That is not how the procedure is followed. All I'm saying is, as they were busy conceding to you, as you put them to this side and put to this side, they were conceding to you. None of them, at the end of those concessions, none has ever said to you, we have now resolved this matter through your wonderful intervention.
No.
No one said that. Yes.
That's quite correct.
Thank you.
Thank you. Commissioner Dudovu, are you covered or not?
Thank you, CJ. CJ, I never wanted to say anything on this session, but for the reasons that I'm convinced that you best know, I want to follow up this particular matter.
Okay.
Now, Justice Berkeley, throughout this interview for the last 2.5 hours, your buzzword has been fairness, and justice. Do you think in your good conscience that you were fair to the parties who appeared before you, who spent their time, who spent their money, who made heads of arguments to you and say that you must resolve the matter as a justice of the court? Do you think that you are fair? You are fair to these parties?
Thank you.
I just want to follow up on that question so that Judge Spilk answers 2 questions.
Yeah,
I think
okay.
what I'm most concerned about, Judge Spilk, on this, and I think it's probably fair to put to you, is that you are asking to be appointed as a judge of appeal in a court whose word is final, except at the Constitutional Court. You take a junior judge who does what you have done, which seems to amount to an abandonment of a judicial function, and a complaint comes before you. Would you really endorse that conduct?
Sorry, would you?
Would you, as a senior judge of appeal, endorse a conduct of a junior judge who did what you did, which is to abandon a judicial function?
Thank you.
Do remember to answer both.
Yes, of course.
Yeah.
The first question related to, do I now consider what I did fair? In light of what took place there, in light of the fact that nobody said, we need an order, what has happened? I'd understood that it had been sorted. At that time, I considered it fair. Now that there is a complaint that has been lodged, my first question is, well, why was there never a request? Where's your decision? People are in limbo. Nobody's in limbo, as far as I understand it, because they would have raised it. Insofar as an abandonment of a judicial function, I made a call in an urgent court week. Maybe I should have made a note. I should have called the parties back. I can't recall the sequence of events. What I do know, and I put it there, that there were 27 urgent matters that I was dealing with. And if you consider it an abandonment, I don't. It would have been an abandonment had I been asked straight after or any time after that, please, you've overlooked this or you haven't given a judgment. And I did nothing. That I would consider an abandonment. Thank you.
We are going to,
No, I just want to say the
Oh,
last
okay.
thing, CJ.
yes, sure.
During the closed session, when we discuss, when we deliberate on this interview, I'm going to say, and I want you to comment on that because I don't want to say it in your absence. I'm going to present a view that says this judge is not responsible. He has abandoned the case. That is very important, and he expects the people who appeared before him to tell him to deliver the judgment. And on his own volition and accord, he cannot exercise a judicial duty that is befitting a judge to deliver a judgment. What is your view on that?
With respect, I would ask you then to take into account the view of my peers, of the judicial officers who are here, who can perhaps answer better. So I don't want to engage in an issue where my track record is here. It's in this. What I've done, whether people respect me or not, appears from the reports you've got. So it is a factor. I accept it's a factor. But I am responsible, and I've been made responsible for, aside from my judicial functioning, which is set out by the views of the legal profession, also responsible and convene 2 committees within the High Court. So my conscientiousness, my dedication, if this is seen as anything, at best it's a slip-up. But to consider that with respect as the spilg that is known by the judiciary and by the practitioners, I would leave to those who have for better part of 14 years engaged me. Thank you.
Thank you,
Thank you. Well, Judge Bill, we are going to end this interview. But I'm surprised that
Sorry,
you had...
Chief Justice.
Oh, I'm sorry.
No, it's just you can ask this for
Okay.
me. I just want to know, now that you know those parties are still unhappy because they have not received their judgment, will you deliver the judgment?
Absolutely.
And by when?
I can do it within 2, well, I'd need to find the bench book, but, I just need to be practical, if you don't mind. I need to find the bench book. I am happy not to get the record, the balance of the record, and I can do it in 2 weeks. But now that I know it's there, I can do it in 2 weeks.
We are ending this interview now, but I wanted to say I'm surprised that you handled this matter in the manner in which you handled it, Judge Bill. Not only because you have been a judge for a considerable number of years, but also because prior to appointment as a judge, you practiced as an advocate and as a senior counsel for a long time. In my view, a very junior judge, an acting judge, would know that if parties have argued a matter before him or her, a judgment is required of him or from him or her unless the parties have resolved the matter and have told them that, and they would even preferably say, put it in writing, do a settlement agreement, unless they tell the judge in open court where it is recorded that they have resolved the matter. That would be done by a very junior judge, in my view. So I'm surprised that with all the experience that you handle this matter in this way, and now look at the controversy that it has raised. This is such a controversy should not arise out of whether the matter was resolved or not. And if when the parties left, if you were in doubt whether there was still a judgment expected from you, you ought to have asked the parties, in the light of A, B, C, D, do you still need a judgment? Or if they say they have settled, you say, give it to me in writing, or let's place it on record in open court. That's what would be expected from a judge.
Thank you, Chief Justice. My answer, and it may be unacceptable, may not be adequate. I was in an urgent court. I had many matters on the roll. I did the best I could. Sorry, I did what I understood was the situation. There is now a complaint that it is not what I understood. I'm more than happy to give that judgment in 2 weeks.
We have reached the end of the interview. Thank you very much, Judge Spill. You are now excused.
Thank you.
Thank you. We are at 1:30. Do we go for lunch and come back and deliberate? Do we deliberate and go to lunch after that? What is everyone's view? We deliberate and...
I propose that we deliberate.
We deliberate?
Justice, and then
Is that
adjourn
fine?
for lunch.
Yes. Okay. JP, when we do... Oh, okay. Yes, the media and welcome the Judge President of the Mpumalanga Division of the High Court, Judge President Lehodi, who has joined us. JP, you are welcome. Thank you. Good afternoon, Judge Mashile.
Good afternoon, CJ.
Before I proceed, I've been told that the Premier is attending virtually. Let me check if she is there. Are you there, Premier? Premier, are you there? Okay, we might have to wait until she is there, because there might be legal challenges if we continue and she's not there.
Good afternoon, CJ. I am available in the meeting.
Okay, good afternoon,
and
Premier.
good afternoon to...
I greet you on behalf of all the commissioners present here, Premier. Are you well? Can you hear me, Premier? We just need to make sure the Premier is...
Chief Justice?
Yes, Commissioner Singh?
Yeah, she is logged in, I can see, on two devices, but
yes.
Yes.
Yeah, she can't hear. Let me just see if Secretariat, would you know whether there are people are trying to assist so that she can hear us and we can hear her? I'm told they are reconnecting the Premier.
CJ, can you hear me?
Now we can hear you. Can you hear us?
Oh, thank you so much. My apology. I had a network challenge. I think I'm fine now. I was saying good afternoon to yourself and the rest of the commissioners in the meeting, and of course our JP, who's in our midst today as well.
Thank you very much. Good afternoon to you. You are most welcome. Thank you. I had greeted you, Judge Mashile. Are you well today, this afternoon?
I am, especially after that short break. I welcomed it, actually.
Oh, Judge Mashile, how can you behave about the break before the questions start?
Yeah.
What will happen when the questions start? Okay, welcome. Thank you very much to you for availing yourself, Judge Mashile. We really appreciate it that you have availed yourself and you have come to this interview. Yesterday, we adopted criteria for the selection of candidates for judgeship, And in the document containing those criteria, we agreed that while on the one hand, the questioning can be robust, at the same time, as we question candidates, we will have due regard to the candidates' human dignity, will show respect and courtesy, and there is nobody here who is here to try and humiliate anybody or to treat them unfairly. I'm going to ask you some questions, Judge Mashile, and after I'm done, I will give the JP of the Mpumalanga Division an opportunity to put questions to you, and after that, it will be the Minister, and after that, the floor will be open to other commissioners. So we are going to start, but before I give the JP the opportunity, there's going to be a time when I will give you about 15 minutes to give you an opportunity to share with the commissioners what challenges you have identified in the division, Mpumalanga Division, and how, if you were to be appointed as Judge President, you propose to deal with them in that division. You understand?
I do.
Thank you very much. Please tell us your qualifications, academic qualifications.
It's a BA LLB.
Which you got from which universities?
With the University of the Witwatersrand.
Yes. Before you were appointed as a judge, you practiced for many years as an attorney, is that correct?
That's right.
Was it about 20 years that you practiced as an attorney?
Yeah, plus minus, yes.
Plus minus 20 years?
Yes.
Okay. And your practice, how diverse was your practice?
Fairly. Okay. You're not saying I must mention what we did, but just it was fairly diverse.
Yes, in terms of different branches of law, that's what I'm talking about.
Yes.
It was fairly diverse.
Yes.
You had commercial law as well.
We had commercial law in the sense of commercial litigation.
Yeah.
The bank work, yes.
Yes, okay. And you were then appointed to the High Court. When were you appointed to the High Court?
2013, July.
So in 3 months' time or so, you will finish 10 years as a judge of the High Court.
Correct.
Before you went to Mpumalanga, to the Mpumalanga Division, you spent some time, didn't you, in Gauteng?
That's right.
Yes. And when did you go to Mpumalanga? Was it when it started, the new division was started?
Well, shortly, formally, or remember, we used to go on circuits.
Yes.
So I would go for a month, 2 in a year.
Yeah.
And ultimately, in 2019, I think it was, that's when I transferred to Mpumalanga.
Yes.
And I think it became effective around October 2019.
Yes.
Yes.
Okay. And now you have been in Mpumalanga from 2019, is that correct?
Correct.
And if you compare the work at Mpumalanga and Gauteng, what is the difference in terms of the different types of work that one gets exposed to in those divisions?
Well, obviously, Gauteng, it's more assorted. Whereas in Mpumalanga, it's depending on where you are. Middleburg would be exposed to, for example, the mines. Mpumalanga would be your admin because of the seat of government. But essentially, you have almost everything. It's only volumes. So you would have, or there are there's certain work that is specific to areas like Mpumalanga, agriculture, servitudes, and other stuff. But when you talk variety, Gauteng has a more varied scope of work. I'm not sure
Yeah.
whether I've answered your question. But in terms of volumes, the work is sufficient for the number of judges that are there. Gauteng has a whole lot, but it has a larger number of judges.
Are there about 7 judges in the Mpumalanga division?
9, I think.
9.
You've got the JP, the DJP, and 7, yes, judges. So
Yeah.
if you exclude the 2,
Yeah.
we are 7.
In the seniority, whereabout are you among the judges of the Mpumalanga division?
I would be the 3rd from
You'd
the
be-
JP.
You,
Yeah, am I right? No, 4th. Sorry.
you are the 4th if you count from the top.
If you count from the top, yeah.
Yes, okay, all right. Now, I would like now to give you a chance to share with us what challenges the Mpumalanga division has that you have identified and how you would propose to deal with those challenges if you were to be appointed as judge president of the division.
Well, it's quite open-ended, but let me start here. Maybe accessibility, because of the size of Mpumalanga, unlike Gauteng, you can travel from the south to the north in probably an hour, not now with load shedding though, but in Mpumalanga it's quite massive. So you have the challenge that people travel for quite a distance to reach justice. For example, if you go to the southeast, it would be, say, the area of Mkhonto. They travel to, I think, New Brighton for a high court. That's about 120 to 130 kilometers. So you would, I can't remember, but I know that the JP was concerned at some point about that. But that's one area. And obviously, one way of solving that problem is to identify those areas that require circuit courts and raise it with the probably the office of the CJ to see whether one cannot establish circuit courts. Another one which is quite, it affects, it would be for disabled people, accessibility of the building to disabled people. There are ramps, but I see that for blind people, you don't have brailles, for example, at the door or doors. It's one area where you can make some changes. I think to engage even with people to find out what the problems of people who use the court, the legal fraternity around. I know that they have complained about our directive, except for the high felt. The low felt has not seriously engaged to say we have challenges. How do you assist us? But my belief is that if they were to engage, because these directives are made for the people around, so if they confront challenges, the only thing that they can do is to engage with us vigorously. And I think that's the little that I've identified, CJ. I don't have much.
Yes. Okay, so accessibility in terms of long distances that people travel to get to court.
Yes.
To accessibility in terms of buildings so that they are accessible to disabled people. And then 3 directives that have been issued that some people complain about. Is that right?
Or generally, people must find it easy to engage, because you find that people, instead of engaging, they would go to the media or they would go somewhere else, and the next thing you're surprised when you haven't been engaged on something.
So what would you do about that?
Well, encourage that kind of environment that where there is a problem, and I think it's already happening because there are various committees where they are supposed to be represented. But what I'm saying, people may not express or vent out at some of these committees that are meant precisely for that. So is to create that environment, to encourage them to engage.
There you are talking in particular about practitioners.
Practitioners, yes.
Yes.
Or the legal practitioners in general.
Yes. Those are problems that you have identified which exist at the moment. Are there some problems which existed when soon after the court has started but which are no longer there? Or were these always the problems or challenges that were there from the beginning?
Well, some have been resolved. Outside of that, obviously the court being new, you've got a lot of teething problems, infrastructure teething problems, roof leakages. That has been a major challenge. Something's not working. But infrastructure.
Are you saying there is also some problem with regard to infrastructure?
There is. The other day I was missed by some falling object from the top. So, and there was water leakage. For some reason it stopped. I hope they've resolved it, but as far as I know, it wasn't resolved. But there must have been water leaking in the ceiling. And the next thing just dropped on my table.
What is the state of case backlogs in the division? Do you know?
What, civil or criminal or
all,
generally?
All of them.
Civil, I think our case management, case flow management, I think that works for the division, I must say. Since it was implemented. I mean, if your case is certified ready today, you can be sure that you will not wait for 3 months to be allocated a date.
You won't wait for 3 months to be allocated a date?
A hearing date, yeah.
Does that mean you'll be allocated a date that falls within 3 months, or that means you'll be told of a date that falls outside of 3 months, but you will get the notification within 3 months?
Within, you'll be heard.
You'll be heard within 3 months?
Yeah.
So that suggests that there probably is not any serious backlog.
No, not insofar as civil is concerned.
Yes. Okay, thank you. Judge President, I give you the chance to put questions to the candidates.
Thank you very much, CJ. Judge Mashile, you appreciate that the break that we had because of the problems which the Premier had. I understood you to be saying that you felt somehow intimidated and that helped you. Am I right?
Yes, you are correct, JP.
but I've seen that in your last interview in 2013, you were referred to as a lion or Dao. I had always thought that lions are not easily intimidated. Are you okay now?
I am fine, yes, I'm settled. Thank you.
Thank you so much. The post that you have applied for would require some sort of administrative expertise or knowledge. Do you agree with me?
I do.
You have been an attorney for almost like 20 years. Were you there as the owner of the firm of attorneys, or were you somehow working as a professional assistant?
Well, I started the company or the firm. Yeah, and until I left, I was the owner.
You were the owner?
Yes.
Now, by the time you left, how many staff did you have, and perhaps how many attorneys did you have, or candidate attorneys?
Well, there were four partners, and I was the fourth. So staff, we would talk about probably 20, because we also had maybe slightly more, but we also had a call center. So that took the numbers up. But on the just legal side, we would have been about 10 to 15.
Were you also playing a role in the administration of the practice?
Absolutely.
I'm deliberately asking you this question because after having been an attorney for almost like 20 years, I have discovered that that administrative experience comes very handy when you are a judge president. I just wanted to make that statement for now. Now, you came to the division by way of transfer that was mechanism created for Mpumalanga and Limpopo in terms of Section 50 of the Superior Courts Act. Am I right?
Yes, you are right.
Why did you elect to come down to Mpumalanga? I had always thought that it's good to live in the cities.
I think I was a bit tired. Another thing, I hail from Mpumalanga. My parents hail from there. I grew up in Alexandra. My parents lived here and had a house. So, in Pilgrim's Rest. So I always, during holidays, would go home and come back during school term. So I've always had one foot that side and another this side. So I think I was getting tired of bumping people around town. There aren't many people in Mpumalanga, unlike Gauteng.
Okay. Now, when you came to Mpumalanga in 2019, you were one of the most senior judges. It was the JP, then it was Judge Hweli, then it was yourself, and then it was the present DJP. Am I right?
Yes.
Okay. Now, there are two seats of the division. That is the Mpumalanga division, Mbombela, which is the main seat, and Middelburg, which is the local seat. And they are far apart by about 200 kilos. You're aware of that, am I right?
I am.
And as the JP, before the appointment of the DJP, you are aware that the most senior judge, that is Judge Hweli, left us, and I think towards the end of 2019, to act in the ACA, and she came back last year during the fourth term, am I right?
Yes.
And before the DJP was appointed in Middleburg, you were the most senior judge in Mpumalanga, that is the main seat, am I right?
Yes.
Yeah. Now, by now I'm sure you are aware of the volume of work regarding a person who is the JP, and in most of the times you would be the one who will stand for me if I'm not at the main seat.
Yes.
You also have the opportunity to actually allocate matters to some of the judges on my request.
I did.
Okay. And probably as you are allocating, you are checking your judges and the kind of matters that you needed to allocate to them, am I right?
Yes, that's very important, yeah.
Okay. Now, do you think that to a certain extent helped you in terms of the position that you are applying for?
Yeah, most certainly, because that's part of the duties of the JP.
Okay. Now, you will recall that the interviews for, the shortlisting for this position took place on the 30th of January. I think that was the case. And a day thereafter, I wrote an email to you and to the DJP after both of you were recommended, or when you were shortlisted, am I right?
Yes.
And the email reads as follows. Once again, allow me to say congratulations to you. I have been thinking what I can do as part of preparing you for the interviews without seeking to preempt what questions may be asked during the interviews in April. For this, I hereby extend an invitation to both of you to approach my office for information or briefing regarding the working of the office of the Judge President. Now, you availed yourself for that opportunity since the 1st of February, am I right?
I did, thank you, yes.
And you came to know that in addition to allocate matters to the judges and also taking some of the most important matters and allocated them to yourself as a head of the court, you also discovered that there is a committee referred to as PEC, am I right?
Yes.
You have recently attended a meeting of the PEC, am I right?
Yes.
And you have been provided with the previous meeting, the previous minutes of those meetings. Am I right?
Yes, I have been.
Now, did you find that helpful in terms of what is happening at the PEC meetings?
Yes, and even from attending, I think I attended 2 of them, but yeah, that gave me a pretty good idea of what is going on.
You also, because you actually extended your hand to say, I want to know better about the working of the office of the Judge President, you also became aware that there are other ceremonial functions which, as head of court, you need to attend in your own division or province.
Yes.
Amongst others is the invitation during SOPA, State of Province Address.
Yes. Yes, I was part of it.
You were also part of the judges who attended the State of the Province Address this year, am I right?
Yes, I was.
And we have actually emulated what is happening in Cape Town. In other words, we get properly roped together with the judiciary in the lower courts, the regional court president, the chief magistrate, and we go there with designated places and also a separate office so that we can run away from politicians during the attendance. Am I right?
Yes.
Okay. I'm sorry. Not really running away, but just not to create the impression that we are not separate. Now, during your interaction with the Office of the Judge President, you were also told about management meetings, which are held every month. That is between the head of court, the DJP, the director, and the court managers. Am I right?
Yes.
You also had the opportunity to attend some of these meetings.
I have.
And also you had previous meetings relating to these meetings.
Yes.
Did you find that to be helpful in terms of the position that you are applying for?
Well, yes. It's always helpful to attend them because one then gets an idea of what is coming or what will be coming if one is appointed. And it's in preparation, in fact. So, yes, I appreciate that I was given opportunity to attend those meetings.
You also discovered that there are registrars meetings with the JP every month as well. Am I right?
Yes.
And you also had the opportunity to attend some or one of these meetings.
Correct.
Okay. And you also asked for the previous minutes of these meetings.
Yes.
Okay. Did you also have the opportunity to attend what is referred to as facility meetings?
I did.
The CJ was asking you earlier on about some of the challenges, and you mentioned some of those challenges which are connected to facility. Am I right?
Yes.
Okay. And you also had some minutes of the previous meeting relating to this, which meetings are also conducted every month. Am I right?
Yes.
Okay. Did you find that helpful?
Very.
And this would have included what is happening at the local city in Mecklenburg, am I right?
Yes.
You are also aware that we intend to establish a circuit court at Mpumalanga, and probably in the course of this term, we might have the first case to be had at Mpumalanga.
Yes, I am aware.
And that is to bring the cost closer to the people, as you have indicated to the CJ, am I right?
Yes.
Okay. You are aware that I have asked the DJP to have regular meetings, which should be referred to as a provincial judicial forum. That is the heads of court to come together to discuss challenges, especially taking into account the coordination functions of each court of each head of the High Court in relation to Section 8 of the Superior Courts Act. Am I right?
Yes.
And that has been assigned to the DJP to deal with, and meetings have not been held in terms of you attending. Am I right?
Correct.
Okay. Now, I'm also aware that you have submitted response to some of the issues which were raised by practitioners, and that you submitted, I think, last week, Thursday, am I right?
It was, yes, Thursday.
I must tell you, Judge Mashile, I was intrigued by how you concluded in that response. And I'm just going to refer you to some of what you actually said. Amongst others, you said this: complaints do not detract my suitability to be appointed as head of court. My commitment to my judicial duties demonstrate par
excellence that I am suitable candidate. And I want to deal with this issue of par excellence. And I can assure you, Judge Mashile, when I allocated matters to the judges, I never doubted your ability to deal with any matter. And I would imagine when you speak about par excellence, you're talking in particular by the fact that you are blind. Am I right?
Yes.
Yes. And I can assure you that, in fact, when I allocate matters, I do not think of you in that context. And in fact, I think by virtue of the fact that you are the most, or amongst the most senior judges, I have always allocated matters to you without blinking and thinking about your blindness. Now, and I just wanted you to know that. And I also had the opportunity to sit with you as a full court. And the recent matter that we set together related to the REF matters. Do you remember that?
Yes.
I was the scribe. And I circulated a judgment which was almost the longest judgment I ever written. You were the first one to come back with your comments, almost like 3 days or 4 days thereafter. How did you manage that?
Well, I went through the judgment as quickly as I could and identify those areas where there was something wrong, or they were cosmetic. Yeah, I would say they were cosmetic, albeit that there was one or two things, but not so serious. Yes. How, I don't know whether you want me to go into how I read and so on.
We'll come to that.
Okay.
Cosmetic, I think you have been modest. It was not. I mean, you raised very important issues that in actual fact were included there. But here is your last statement in your response. And you are saying this: my appointment will not only be significant to our division, but to the Republic and continent as well. It will demonstrate that no barriers cannot be overcome. That's what you said in your response. Now, I have always been reluctant, and perhaps I did not have the courage to ask you this question. When did it start? How did it start? And how did you manage to be where you are today?
Yeah, I'll be brief. So essentially, how did I become blind? How
Yes.
did I? Yes.
Yes?
Well, my blindness was the result of an assault here in Alexandra.
When was that?
That was 1979.
At what age?
I was 16.
Okay, yes.
And from there, I think I stayed for 3 months in hospital. When they confirmed that there was nothing that could be done, I had to go for rehabilitation. And I lived with a very young brother, so he had some other businesses to attend to, as you can imagine. So I was left to myself, and he had to make sure that I was independent so that he can attend to other things. But I then went to St. John's Eye Hospital. They had a rehabilitation center. That's where I learned Braille, mobility, to walk and so on, cooking, cleaning, and so on. So I was fully rehabilitated there. And a year later, I went back to the same school, the same high school where I was when I went blind, which is Alexander High School. So went up to matric and then applied to vets. In the process, so when I completed matric, there's a family that took care of me, and they made sure that I went to university, and I got a bursary. So I did from 83 to 85, it was my BA, 86 to 88 LLB, and then
Record time?
Record time, yes. No, I did not delay. So thereafter, I served articles with Edward Nathan. It was Edward Nathan Friedland then. I think now it's called ENS. Shortly thereafter, I then, in 1991, I became what was referred to as a PA then, professional assistant. I worked for about 5 months, and I opened my own.
Yeah. But
And
yes,
in
fast-
1991.
Yes, fast forward. How did you manage this? Almost like you did not need what you did not have at that time. How did you manage this?
I did not have what?
How did you manage to achieve all of this?
Look, at university then, we obviously didn't have computers, but literally each lecturer would stand in front there and ask students to volunteer to read material onto a tape. So that's how I did it. Braille was useful when I was still in high school, but remember, I did not grow up using Braille, so it didn't come naturally to me. I could not read as quickly.
Yeah.
So when I went to university, I had to switch over to listening. So students would, or fellow students would read material onto a tape, and I would read. And for typing for my answers, I used a typewriter.
Yeah.
Typing, but I could not read what I was typing. So there's one incident, I think I was just, the problems, for example, of typing what you can't read. I remember one day I was writing a paper.
Okay.
I wrote for 3 to 4 hours, and I was using a typewriter.
Oh.
At the end, when the invigilator came, I've put a stack of papers which I thought were my answers. They were empty.
Okay. And how do you currently manage to deal sometimes with voluminous matters before you? How do you manage that?
Well, I asked the parties to forward their papers to me electronically and in Word, if possible. If they don't, then someone must. I have a system where I convert PDF to Word, but that doesn't yield the best results always because depending on the print, it distorts the letters. So it's always preferable to have the parties to send the papers in Word to me. So that's how I do it. But invariably, the annexures to the papers are always in PDF, which is a hindrance to my preparation at times.
CJ, thank you so much.
Are you done, JP?
I am done, but perhaps just one last thing. As a JP, you have got a lot of administrative work to do, and almost like on a daily basis, you'll be getting letters from the practitioners. How are you going to deal with that if you are appointed?
Well, the email, and look, what happens is whatever you read from your computer, I have a voice synthesized software computer which reads everything that is on the screen. It's called JAWS, it's a screen reader. So everything that you see on the screen, a voice, in my case, reads.
If I send you an email now and you open that, there will be that voice, you'll know exactly what I'm saying in the email, because I've always been surprised. 5 minutes, 10 minutes down the line, you respond. Is that what is happening?
That's what happens, yeah.
Oh, okay. Thank you, CJ.
Thank you, JP. Premier, I now give you the opportunity.
Thank you very much, Chief Justice, and good afternoon to Judge Mashile.
Good afternoon, Premier.
My first question, Judge, it's with regards to Section 174, subsection 2 of the Constitution, which places an obligation upon judicial officers to ensure that the judiciary is transformed and reflect the racial and gender dynamics of our country. Now, can you tell us, in your time in the judiciary, how have you contributed to the transformation of the judiciary? And if you were to be appointed in this position, how would you advance the need to transform the judiciary?
I think that effort is already there, not to me as an individual in particular. When you talk about gender transformation, that's a song that is sung every day. And I think we are very close to achieving that gender parity on the bench. I think if you look at our division, the number is almost balanced. You have 3 female judges in Middelburg and 1 male. And in Bombela, you have 1 and 4. Let me see. So, yes, it balances out. We have 4 females and about 5 men. So, and that's, I think, the picture that you get nationally. Because I think at the moment we must be around 43 to 45% female and the balance male. I'm not sure whether that answers your question.
Yeah, Judge, you are saying it's almost like a broken record. And of course, transformation, in my view, it's something that happens almost on daily basis, or rather it should happen on daily basis. Having been there for quite some time, and you have clearly articulated what has been contained up to thus far in terms of the 2 divisions that we are having. Are there any deficiencies perhaps that you may have identified as an individual who might be seized with the responsibility to lead our High Court? What would you do to ensure that we take the record to greater heights, if not maintain the status quo, the current status quo? What would you do?
Well, is to encourage our female colleagues, or shall I say, practitioners, female practitioners, to take up the opportunity. There are seminars whose aim is to train aspirant judges but they are not discriminatory. But I know that Judge Mujapelo, for example, has been appointed by or requested by Sajay to train specifically aspirant female judges. So something is being done. We are not sitting back and hoping that something will happen without us actively participating. What else? Oh, yeah. Even the people who are invited to our division, I think if you were to take statistics, you will find that more female have been invited to act, or the number is higher than those of males. So that way, we hope to have more people or a larger pool to draw from when the moment comes. And that's a pattern that one is going to try and encourage, or encourage, not even try, to continue with that what's the word? My God. Yeah, but that's what we'll try and persist with. It's already happening, and we'll continue to do so. Thank you.
No, thank you very much. My next question would be, and I want to borrow from where Judge President has left off with regards to your excellent turnaround time. I've been going through the packs that we have received from JSC. Now, what I could establish from that is that emanating from 2022, you have about 12 reserved judgments. Now, having said that earlier on that you seem to have quite a good, excellent turnaround time. Looking at the judgments that you still have in your desk, does that not disadvantage the people whom you are supposed to service? And what measures would you put in place to make sure that you overcome the backlog of your reserved judgments?
Yes. It certainly does. But unfortunately, this occurs because I am attending to the service of the nation in other capacities. And I'm not saying I want to neglect the other part, but already I am doing that, attending to those reserved judgments. And as I say, of what I had mentioned last year when I applied, I'm left with 3. And of course, there are other judgments that have since been reserved. But that's the life of a judge. Yeah. But also, I think I've tried to explain how this had come about. It's not something that has always been there. It's something that slowly crept up, I think, crept up when I was appointed to the NCCS, which I think it was inundated with quite a lot of work when I joined, and everyone was complaining. So, and I do mention there that we had to put time aside to attend to that. That has since been cleared, and that should improve the number of, or the quality of my work, or the number of judgments that I've reserved in my daily, during my daily work. So that's how I intend doing it. In fact, that will resolve itself. And of course, I'm working quite hard on it.
Thank you very much, Judge Mashile. Thank you very much, Chief Justice. I have no further questions.
Thank you, Premier. Minister?
Thank you very much, CJ. Judge Mashile, good afternoon.
Good afternoon, Minister.
Yes, given that this is a leadership position, what is your leadership philosophy, and how are you going to apply it to this position if appointed?
Well, I think the idea, well, fortunately, one will be leading a group of judges. It's not anyone. So one would say you start on the understanding that these are people who respect their duties. And my responsibility remains, of course, to leading the people. Well, the philosophy is I can't run ahead alone. Okay. I'm not sure whether it's okay. Not.
I think you can continue. Yeah, I think you can continue. Oh, we can't hear you. Can you hear us?
And I can hear you very well.
Yes, okay. No, you can continue. That was load shedding, but we are able to continue. You may continue.
Well, Minister said, what is my philosophy? Well, I believe in running ahead, but still not leaving people behind. Because you might find yourself being ahead alone. By that, I mean that whatever decision one comes up with, one must run it through one's colleagues to see that you are not running alone. And that way, decisions become popular amongst your colleagues. And that's what I believe.
Thank you, CJ.
Thank you, Minister. Commissioner Mpumalanga.
Thank you, Chief Justice. Good afternoon, Judge Mashile.
Good afternoon.
Just one question from my side. In responding to the concern about the reserve judgments, one of the issues that you alluded to was that the reserve judgments could partly be attributed to the cautious approach in dealing with the ref matters, and also your responsibilities as the chair of the NCS. You have elaborated on the NCCS, but you have said nothing about the cautious approach in dealing with the road accident fund. Can you just elaborate on that? Because it will be quite important to understand why the word of caution when you deal with the RAF, thus leading to the number of your reserve judgments. Thank you, Chief Justice.
Thank you. I think I have touched on the point, but thank you for giving me the opportunity to go further. What happens, or what happened when RAF stopped defending? Practitioners bombarded us with what they refer to as default judgment, not in the conventional sense, but default judgments nonetheless, in the sense that they would say, look, the other party is not defending. Therefore, we don't have to lead witnesses. We do not really have to prove. Once they say an accident occurred, you must accept that an accident occurred. I have a police report. Once a person says, I was in hospital, you must accept. Once an expert says, I have seen this person, I'm a psychologist, this is what happened, and you can't question that. So my attitude has always been, but if you say an accident happened, I need to be convinced that indeed it happened, because we have seen very strange things happening. At times, an accident occurred, but the merits are not necessarily in favor of the plaintiff, or the RAF wants to settle where it shouldn't. So they don't really, you find that some things don't make sense. You read the reports, you find that there are discrepancies. There's a discrepancy between a psychologist and the actuary. Someone is progressed from stage this to that, and the actuary calculates based on the psychologist or a psychologist. But you obviously see that it doesn't make sense. You question, and you find that indeed it doesn't make sense. So you have to go back, read these papers properly, and write a judgment. You cannot just sign an order and say, I think an accident occurred. It has to be proved. And that's what I mean when I say I've been fairly cautious, and not necessarily with RAF matters. Generally, probably I'm a bit sensitive because of my situation. Criticism, that no, we understand the poor guy is blind. That's why he couldn't. We didn't see this. So I tend to be more cautious than I believe other people, just to make sure that what I produce is correct. But that doesn't go very far, because I was only told late, very late, by a colleague, a senior colleague, who said, look, don't worry too much about whether you're right or not. Just write, as long as you believe that you're right. I'm not sure whether that makes sense.
It does. Thank you, Justice Mashile. Okay. Thank you, Chief Justice.
Thank you, Commissioner.
Chief Justice, can I follow up on that, please?
Yes,
on
yes,
that last
please,
question.
you may.
Good afternoon, Judge Mashile.
Good afternoon. Sorry, I don't know the surname.
It's Baloyi.
Yes, Ms. Baloyi.
Yes. Judge Mashile, your explanation for the delays in delivering judgments, it seems to me that they remain constant. So you continue to be cautious, as I don't think there's anything wrong with that. You have this responsibility at the NCCS. It remains in place. You continue to sit as a judge, and yet you are you want to tag on, or you will be taking on additional responsibility if you are appointed to this position. How do you, is there any way you give comfort, given all of this, that you give comfort that these complaints about delayed judgment will not be a recurring issue? Intuitively, it seems it should be a problem, because you are taking on head of court responsibility if you are appointed.
Oh, absolutely. Look, if it happens, you cannot do this together with the work that I do at the NCCS. That's just, the load is too much. The minister will tell you, he knows. But if I'm appointed as a JP, I cannot continue as a chairperson of the NCCS.
Thank you. Thank you, CJ.
Does that mean you will resign?
Well, yes, but I didn't want the minister to hear that during this interview. But that's what it means. I should, just to be honest, to make sure that I do justice to the appointment. You cannot carry both responsibilities and still do well. Yes. Thank you.
Thank you. Commissioner Nyambi.
Thank you, CJ. Afternoon, Judge Mashile.
Good afternoon, Commissioner Nyambi.
It's one question from my side. As this is a leadership position, and you are going to be the helm of the High Court in Mpumalanga, probably if you can share with the Commission your understanding of good attributes of a JP, and mainly focus on those two that you think you possess that can come handy and assist you if you can be given the opportunity to lead that division.
Well, and this is something that I said, I think, in 2013. If you ask me, well, I've seen quite different worlds. I was one-sighted, I'm now blind. So I'm supposed to understand both sides. I lived in townships, I live in a suburb. So somewhat, I'm exposed to both cultures. And I've been in leadership positions before. I've delivered in those leadership positions. The NCCS, the minister I'm sure can attest to this. I mean, I was the head of a firm of attorneys for quite a while. I was the chairperson of the Pilgrims Rights Development Forum. We delivered. We did get the land back to the community. So, yes, I think that record speaks for itself.
Thank you, Judge Mashile. Thank you, CJ.
Thank you.
Thank you, Commissioner. Commissioner Marumwaha.
Thank you very much, CJ. Good afternoon, Judge Mashile.
Good afternoon.
I have a question for you, and the question might be a little bit unfair, because I'm going to ask you based on a case that the judgment that you delivered when you were still at the Gauteng local division, or the Gauteng division, Johannesburg, in 2015, perhaps, and I understand that you may not remember the facts and all those kind of things, but I think there are some important things that are coming out from that case that I really want to debate with you. It is the Tutubala versus Road Accident Fund. I'm not sure if you remember that case.
I do.
Yes. In that case, the very last paragraph of that case, you said that the mother of the son should fail because she was unable to prove her indigency and that she ever received income from the deceased son. And I think you may have been right in relation to the order that you gave. And the question I want to ask you is a general one in relation to claiming for loss of support in the context of claims that are brought under the Road Accident Fund. The question I want to ask you is this: how does one determine duty of support in the context of claiming for loss of support in these Road Accident Fund cases? And how central is the question of indigency in those claims? But most importantly, is the approach that is followed in South Africa an approach that should be followed, particularly when the claims are brought by parents in respect of their deceased children who may have not ever supported them in any way or means? I'm not sure if my question is understandable.
It is. But look, can I carry on?
Yes, you may.
Okay. How should one approach indigency? But look, in the context of Tutubala, perhaps, let me just go there. She came, the plaintiff came to court saying, I don't have money, I am indigent. Yet, as you say, I was probably right. Given what the facts of that matter, I don't know whether it's, you referring to that case, I don't think it's in line with what you're asking. But if you want me to confine myself to that case, because simply she was earning more, she was getting money, and she was actually getting more than she needed per month. That's why I came to that conclusion. But generally, when coming to parents claiming loss of support from their children, that's, I think, recognized even by, I think there's a judgment by the judge who's now in the SCAs from Cape Town, Babu, anyway, I've forgotten the name, but that whether it's customary law or not, the test is indigency. If a person is unable to support oneself, you can't say, I'm not responsible for my parents. You are obliged customarily to support your parent. And even on the, shall I say, Western this thing, I'm not sure of the word though, but in Western societies, the same thing applies, and it should apply in customary law. But in not customary law, what's the word? Sorry, but kids do owe their parents a duty of support, as long as one can establish indigency, whether is customary or not, they owe a duty. That must be established, that there is or a need exists to support them.
Chief Justice, I'm aware of the agreement that we made, but the response made me wanna, with your indulgence, may I just follow up? Or
Okay, all right.
I'll try to keep it.
Yeah.
And that's where the issue is, Justice. And I think perhaps on the law you may be right, but I'm asking a broader question in relation to the law itself.
Mm-hmm.
Because when you look at the concept of duty of support, quite generally, and how one obtains that duty, for instance, between spouses, it's through marriage. Mother to child is through birth. But it becomes quite a different sort of consideration when a parent is actually claiming on the basis of duty of support from a child who has never supported them in any way. So the question that I'm asking is a broader question, that should we still have indigency in the true sense of the word as the test for you to be able to claim for loss of support under those circumstances? Because in any event, what you are claiming for is loss of support for the purposes of the money that would be available due to the accident, because we don't know what would have happened in the future. That's where the question is actually located.
Well, unfortunately, I'm a creature of, I fit somewhere on the ladder hierarchy. So that's what the courts above me say. And that's what I'm using. I think as a general proposition, yes. As you know, customary law would actually probably relax the indigency standard. Because at some point, and I think there has been attempt to lessen the impact. Because remember, indigency means that you can barely make it. And it's what is the word? They say the basic necessities of life. Now that's very low. If you don't have that, then you qualify. But it has to be applied in context. For example, a person who was getting living on 50,000 per month, if that person is down to 5,000, he's probably indigent. A person who was living on 100,000 per month, once he's down to 20,000, he's indigent. So, because he cannot measure up, and there are cases to support that approach.
Thank you, Chief Justice. I will leave it here.
Thank you, Prof. Commissioner Makwanishe.
Thank you very much, Chief Justice. Good afternoon, Judge Mashile.
Good afternoon. I didn't catch your name. You said
Commissioner Makwanishe.
Commissioner Makwanishe, yes. Good afternoon.
Yes.
Thank you very much. Now, I also have one question. As a head of the court in Mpumalanga, from time to time you'll be required to deal with issues of change management. So how will you manage the change management process from what you found to what you desire?
Well, I'm not sure whether there are things that should be changed at this stage. But if those were to come up, certainly I will attend to improving them, changing, if necessary. But so far, I don't think there is anything. But I'm not going to, or I'm not, you see, you've got people who, when they walk into an environment, they turn everything upside down and put in something new. Even if whatever you found works, if it doesn't work, then there is a need to turn everything upside down and come up with a new strategy. But so far, I think I am happy, probably because I've been part of the process of making what is there work.
Are you done, Commissioner?
Thank you, Chief Justice.
Thank you. Commissioner Shabangu Mdawe.
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Commissioner Mdawe.
When you were talking about the challenges of the division, you mentioned that legal practitioners are complaining about directives, and when the CJ asks you as to what is it that you think you can do to change this, you indicated that they do not engage. So this is it's a long challenge that has been there for quite some time. And as a new judge president, what is it exactly that is different that you can do just to deal with this challenge or this problem that is in that division?
I assume that you're talking about the practice directives?
Yes,
or other things.
the court directives.
Yes. No, look, I'm certainly not aware that, look, that problem of practice directives does not arise or was there in the Highveld. And the legal practitioners in Middelburg If you're not sure that I'm blind, now you know. Look, that problem was there in Middelburg. They had challenges. What they did was, I think they approached the JP or the DJP and said, let's talk about this thing because we have serious concerns. And all of us went to Middelburg and listened. We explained our position, where we come from. And I believe, probably that's what you'll hear from the DJP when she comes in, that practitioners in the Highveld are happier than they were before we went to them. Because there were things that they did not understand with the practice manual. What I have not found in the Lowveld, Bombela, is that no one has come to us and say, let's sit down. We have issues with 1, 2, 3. And we would have done exactly what we did. And that's I think my first thing. Because we saw how successful the Middelburg one was. When we came back, I think we discussed with the JP that, look, we need to engage these people, the practitioners in Bombela. And I think that process is still there. What I think the JP has been doing is to conduct as people come to court, he would take his time to explain how the directives, the rules fit in with the norms and standards. Now, but a proper way beyond that would be to have a larger gathering with everyone around Mbombela, White River, Barberton, and so on. Let's engage on this thing. And ultimately, those directives are meant to serve the people of the province. So it is that document. It is not the document of the division as such. But just remember that they are there to make sure that there's a smooth running of matters in that division. And so far, I think it is successful. There might be 1 or 2 issues, and if you do have, we are open. We say, come, let's engage. Maybe the way you approach those directives, it's incorrect. And for as long as people do not understand why they are there, you'll never be able to, you'll always be dissatisfied. I'm sure that's the only thing that I can say about those. But I think there's nothing, I can't go beyond engaging each other. It might well be that we are wrong, and we need to be shown that you are wrong, or that we are wrong. So let's talk about it.
Thank you, CJ.
Thank you.
Thanks, Judge Machine.
Thank you, Commissioner Mdawe.
Thank you.
A follow-up.
Commissioner Matolo-Hlepu.
Thank you.
1 second. I don't have anybody after that and would like, if possible, except for Commissioner Pillay. Okay, let me just do this first. Okay, Commissioner Matolo-Hlepu, you may proceed.
Thank you, Chief Justice. I just wanted to follow up on the issue of the directives. That is it? I just want to find out from. Okay, good afternoon, Judge Mashile. What I wanted to find out, is it not perhaps better to consult before you do a directive instead of doing a directive, then consult after, and consult the profession after? Thank you.
So you say instead of, okay, maybe I should say this. It's never possible to have a gathering drafting a document. Someone must come up with a document and then engage. And that's what I'm calling for. I'm saying there's the document. If one is unhappy with parts of it, don't go criticizing. Approach the people who came up with it and say, did you or do you realize that this is the impact that it is having instead of this? So, but I'm saying someone had to take the initiative to come up with a document. And the JP did, he engaged us, we engaged him, and this is what we have now. So if you think it's not, we think it delivers. If you think it's not, please, let's engage. And we can't come one by one. I think the organization, either the LPC or the Mbombela Tennis Association must organize it, or PLA or NADEL. But a larger forum involving everybody will be helpful.
Okay, thanks, Chief Justice.
Thank you. Mlambo JP wishes to have a follow-up, and I think Justice Spencer also wishes. Mlambo JP first.
Thank you very much, Chief Justice. Tau, good afternoon.
Dinek, afternoon.
You know me. Thank you. On these directives issues, as an aspirant head of court, do you agree that you need the buy-in of the litigation public you want to lead in what you want to do?
Yeah, absolutely. And I think that's what I mean when, if you have regard to what I've written, I say, if it doesn't address, so it must grow up out of the traditions of that particular area, of the area in which the division is. So if it doesn't, you'll have people attacking the very document. So one must indeed have in mind what is happening in that area when you draft these.
Well, I'm asking this question as a follow-up because this directive issue features a lot in your candidature as well as the next candidate's candidature. And we've dealt with it in Gauteng. I've not heard you tell us how you'll ensure there's buy-in in these directives. We've seen a lot of criticism that's documented. I understand you to be defending the directives, yet you are aware that there's no buy-in from a certain quarter. I would like to hear what you will do if you are appointed to ensure that there is buy-in into these directives. Thank you, CJ.
Thank you. JP, maybe I'm not coming across very well. I'm saying those people who do not buy into it, make us aware. Let's come together and let's see where the problems are. They might well have a point. As they are, we think they serve the purpose. But maybe, insofar as they're concerned, it's not, either because they are incorrectly implemented, or their perception is wrong, or we believe it's working when it's not working. But so far, we believe that they are working. But the first thing that one should do is to engage with the legal fraternity, people who use those directives daily because it affects them, or they affect them on daily basis. So they can't keep quiet and complain without engaging us. I'm saying, let's talk about it. And I didn't mean to sound as though I'm defending. I'm saying, let's talk about what is eating you. What is it that is wrong? For example, I think the GCP did point out to one or two. They raised 3 paragraphs in the directives. And I did address those, that this is where we come from, just by way of example. But, so obviously there are many others where there is a lot of dissatisfaction. Let's talk about them. We never said we are drafting a document that is cast in stone.
Am I correct to simply summarize your response, Judge Mashile, by simply saying you haven't identified who the people are who may be unhappy about the directives, but as soon as you know, you will engage with them to hear their side of the story and see whether there is a need to amend the directives or withdraw them or do whatever that will be a solution out of those engagements?
Yes.
Yes.
Yeah, I agree. In fact, I'm saying it should be a document for everyone. It's not for the court.
Yeah.
It's for the area. So it must be a document that is supported all round.
Yes, okay, all right. Judge President Lambo, you were going to be the next one.
CJ.
You did a follow-up.
Oh,
So I'm
yeah.
just mentioning you may be covered by your follow-up. Oh, okay, all right.
Thank you very much, Chief Justice. Tau, it's me again.
Yes.
The JP mentioned that he introduced you to the Provincial Enhancement Committee, PEC, Efficiency Enhancement Committee. Have you chaired one such committee meeting?
Have I?
Have you had the opportunity of chairing a PEEC meeting?
No, I haven't chaired, but I only attended.
You've only attended. And am I correct that that's the forum that brings together all the important stakeholders in the justice system of the province?
Yes, you are correct.
Thank you very much, CJ.
Thank you. Justice Spitzer, I forgot that you all wanted to follow up on the previous question. Please do.
Thank you, Chief Justice. Good afternoon, Judge Mashile.
Good afternoon, Justice Spencer.
Just a follow-up on this issue of directives. Don't you think, if you could clarify this for my benefit, don't you think that it was desirable before they were brought in, they were implemented, for you to engage the organized profession?
But you see now, look, as I say, remember, you're talking about what I am going to do, not what has happened. So I think the question rather is a bit unfair on me. I can't say what should have happened. I can say what will happen or should happen.
Let me put it this way for Justice Spencer. Please forgive me, Justice Spencer. What would be the proper way of handling it if you were the head of the court and you wanted to issue directives, Judge Mashile? If you are appointed as JP and you wanted to issue directives, how would you go about it?
Well, the first thing you identify the need. Is there a need? And you come up with a directive, send it to the people involved, the stakeholders. This is, I've identified this problem, this is how I think it should be addressed. And you invite comments.
Okay.
That's how it would go about.
Okay, thank you. I think that has helped Justice Spitzer. Commissioner Singh, I understand you have a question.
Yes, thank you very much, Chief Justice. Thank you. Good afternoon to you, Judge Mashila. It's Commissioner Singh here.
Commissioner Singh.
I'm on the virtual platform. I think, Judge, you will recall the Moyo versus Old Mutual matter that you presided over, and then the matter went on appeal subsequently. But you recused yourself from the second matter because there was an application for your recusal. Now, during that matter, there was allegedly an unsavory statement made about judges to the extent that, and I quote, a single individual who happens to wear a robe. That's what was said by the chairman of Old Mutual, and I know he later apologized. But I just want to know if one of your judges in your division find themselves in that position, what would you do to protect the integrity of a judge, judicial officer, and the judiciary at large? Thank you.
I'm sorry, I'm not sure whether I understand your, what will I do to protect the integrity of the judge in that situation?
The judge and the judiciary at large in these kinds of situations when those kinds of statements are made. Although I want to emphasize that the statement was later withdrawn, because you must have felt terrible when it was made. Thank you.
Okay. Well, I would rather not talk about me, but generally what should happen. I don't think, but as you know, judges speak through their judgments. If that's how he felt, it's for, and I think he was reprimanded, or you expect the relevant organizations that have interest in a proper working legal system to defend judges. But it will not help for me to respond, or to have responded to that kind of, I don't know what to call it, a criticism, but to respond to that kind of a statement. The judgment is there. If a person is unhappy, should be appealed, and which they ultimately did. So it was just unfortunate that it was the appeal was foreshadowed by those kind of statements. Or there was something that was said before they took the right, this thing. You can't attack judges because you do not like what they've produced.
No, thank you. Just to follow up, I just would like to know, did you recuse yourself voluntarily, or was it because of the application that was made? Thank you.
There was an application that was made. There was, I can't remember the ins and outs of the recusal, but there was an application, and I found that there was merit in withdrawing or recusing myself.
Thank you very much, Judge Mashila. Thank you, Chief Justice.
Thank you.
Thank you very much. I have Commissioner Nochesi and Commissioner Pillay. I'm not aware whether on the virtual platform there is anybody else, but otherwise I would propose to end with these two. Okay, Commissioner Nochesi.
Thank you, Chief Justice. Good afternoon, Judge Mashila.
Yes, good afternoon, Commissioner Chesi.
Yeah, I was not going to ask, but there is difficulty I have. In relation to your answer about the reserve judgments, particularly the 3, and if I count from November, that would be December, January, February, March. It's almost 5 months. Do you accept that one of the responsibilities of the Judge President is to monitor compliance and implementation of the norms and standards? That's one. Last question, which is built on this, is that if the JP of a division
sleep in these circumstances with the kind of the response you give. What can you say about that? Because judgment, 3 months, 6 months, is part of the norms and standards. The question of delivery of judgment. It's not just a by the way. You know. So I just wanted to be clear on this. That's my discomfort.
So what is your discomfort precisely?
What I'm saying is the delivery of judgment
Yes.
is dealt within the norms and standards.
Yes.
It's set up, there are time frames. Within 3 months, the judgment must come if you are late. And you could even be charged for the late delivery of judgment.
Yes.
Now, in this instance, I'm looking on the 3 judgments that you say, because you say others have been delivered, but there are 3. And then this, from your form, it was filled in November.
Yes.
If you count from November up to now, you have almost more than 4 months, you know, from the date of reservation of that judgment.
Mm.
Is that not going towards the transgression of the norms and standards? And which would be your responsibility as the JP to see or to monitor its implementation and compliances?
Yes, okay. But
Maybe before the candidate responds, let me just say, I think the general thrust of your question, Commissioner Jesse, is correct. But the 3 months in the norms and standards, it's what we aspire to achieve as the judiciary. It doesn't become misconduct just because you are over 3 months. It becomes misconduct much later. So I just wanted to clarify that. But 3 months is what we aspire, we would like to achieve one day. Okay.
No, I accept that, Chief Justice. I accept that 3 months is a warning, and then beyond 3 months, but 6 months.
And in many cases, it is
when
achieved.
But the JP, obviously, in 3 months, must start to find out from the judge, where is the judgment, what is happening? Because he implement, he monitor. That's what I'm talking about. That is the essence of my question.
Yes. Look, I'm aware of the seriousness of not delivering on time. But as I said, maybe there was lack of balancing on my side because of the other responsibilities. I have to work on that as soon as possible. That list must be cut down immediately. But unfortunately, that cannot happen when I say cut down. Obviously, if I relieve myself of the other duties, you will not see that there. And you can go back to when I was not a chairperson, when the responsibility was not as huge. I worked in Gauteng, where on any, if you are in opposed motion, you could reserve as much as 10 judgments, but you are able to work on them within time. I'm not saying there weren't other judgments that were somewhat late, but I'm saying at any one time, you would have judgments, and depending on how your the whole roster is structured. If, for example, you have you are in civil this week, next week you are in the following week you are in opposed motions, depending on the size of the role, you are obviously going to carry quite a lot. But all I'm saying, I'm aware of the seriousness of the situation. But at the moment, I've got another responsibility. There are people, there are lifers that the minister want considered. So I must also attend to that. But once I am relieved, I should be able to give my attention fully to that list.
Thank you, Chief Justice.
Thank you. Just a follow-up. I think the question behind the question, if I can put it that way, Judge Mashile, may be whether the delays in the handing down of judgments that are referred to in the documents have not sent a message to you to say you should consider stopping the other functions that seem to interfere with your core function.
Yes.
What do you say to that?
Yes, I think I wasn't going to serve beyond my. I've been appointed as chairperson for a term of 3 years, and this is the final year. But again, I didn't want to disorganize the department by just saying I'm dropping off. So that's where I come from.
But you are not going to disorganize them. You are not going to just drop them off. You'd give them notice, and they could always find somebody else.
Yes. No, my term is coming to an end, Chief Justice.
So no matter how much those responsibilities interfere with your core function, you won't resign. You'll wait until the end of the term?
Yeah. Not necessarily. Maybe it would have come to, it hadn't come to that stage, that point. But I'm sure I was going to consider it at some point.
Yes, okay, all right. Commissioner. Oh, do you feel strongly, Minister? Okay, yeah, okay. Minister?
Yeah, Judge Mashile, maybe for the benefit of the public, why do you think it's important for you to perform this function on the NCCS?
Well, as you remember, we deal with, this is the other side of the duty that we discharge as judges. There are offenders who must be considered, like us. I mean, that's what we do. We advise on, or we recommend to you who should be placed or not placed on parole. The importance is there's overcrowding, and there are just quite a lot of lifers in the system, I think it's important that they be considered and this thing. Hence, we embarked on this thing, on trying to reduce the amount of those files.
Commissioner Pillay, you are the last one.
Thank you, Chief Justice. Good afternoon, Judge Mashile.
Good afternoon, Commissioner Pillay.
Judge Mashile, just before I deal with some adverse comments, I must put to you that there's a bit of a startling feature of your application, and there may well be a very simple explanation for it, but just to tag on to the line of questioning raised by JP Mlambo around getting buy-in and support of the broader community within which the court operates. It was very striking that in your application, there doesn't seem to be any support from any of the law bodies, and particularly with black leaders in the judiciary, you usually find support from the BLA, from NADAL, etc. And that's absent in your application. And in fact, your nomination comes from an individual and not from any organization. Perhaps you'd want to deal with that.
I don't know. I did not, look, I don't know how to deal with that one, quite honestly, why I wasn't nominated by one of the organizations. But with BLA, I think it was said that as an organization, they would not do that because or they don't do it. Well, that's, I used to be a member of BLA. Did not want to come across as supporting, as a body, come across as supporting a particular individual, but rather the members, individual members can do so. In other words, a nomination must come from a member, not the organization. I don't know anything about Nadel because I'm not, yeah.
Sure. And apart from the question of who nominated you from the position, what do we make of the fact that there are no letters of support or no support from these organizations, from kind of law bodies in general, leaving aside the GCB who gives almost a kind of a strict assessment? What do we make of that fact?
Well, it left me staggered. That's all I can say. I'm also surprised, and I've been raising it as well, that I'm not sure why these bodies have not responded.
All right. Then can I just move on to the fact that, as you are aware, there are two objections to your application. The first objection comes from the Amalgamated Lawyers Association, and it's quite a kind of a compound complaint or objection. So if you just give me 2 seconds, I'm going to put to you the 4 features of the Amalgamated Lawyers Association complaint. And the first issue, and they really, they revolve around the application to strike one Mr. Maluleke from the role, who was an attorney. The first complaint is that you ignored an application for special leave to appeal to the SCA, and you proceeded to decide the main application despite that application. Now, as I understand and you've given us, and thank you for that, you've given us comprehensive written responses to the objections. And as I understand your explanation, it's that the application for special leave came a day after you had decided the matter.
Yes.
All right, so that's the first aspect of the ALA complaint. The second part of the complaint is that you disregarded the order made by Semenya AJP, that the postponement application brought by the applicant must be heard by judges in the main application, and that was you and Judge Ranchard. Now, as I understand your explanation, it's that, in fact, you followed the terms of that order because you duly heard the application for postponement and eventually dismissed the application for postponement.
Yes.
All right, there's a third aspect to the Amalgamated Lawyers Association objection, and that's that you failed to afford Mr. Maluleke the right to be heard. There's 2 aspects to this. The first is that you, according to them, you refused to allow him to file an answering affidavit. And secondly, that you proceeded to hear the application after hours, after court hours, and in circumstances where Mr. Maluleke had indicated that he had to excuse himself from the hearing in order to attend to his minor child who had taken ill. And the matter was adjourned, but a little while later, a few hours later, the matter resumed in his absence, and the matter was determined in his absence. And the ALA is raising the fact that infringed his right to be heard, his right to audi. Your response to that, Judge Mashile?
Well, the response is there under the document, but let me say this. Remember, that's a matter that came a long way. 2016, although papers were, or the application was launched in 2017. All along, if you read that file, until this year, there was no answering affidavit. The matter was punctuated by interlocutory applications throughout. And as I say, according to us, those interlocutory applications were designed to come to the decision to which we ultimately came. Now, that coupled with the reasons that were given for Mr. Maluleke not coming back to court. He said, he asked to be excused between 5 and 6. We agreed. And around just before 6, he said, look, there's load shedding, I'm going to delay. And we said, sure, we'll extend until 6:30. That reason, load shedding, changes at about 6:15. It becomes, my child has taken ill. This is the very child that he just collected from school, taking home. The child was not sick until 6:15. And as I say, couple that with the delay that has been there since 2017, we thought we had to finalize this.
Can I just ask in relation to the former issue, and in fairness to ALA and Mr. Maluleke, Judge Mashile, one of the issues raised is that at the stage when Mr. Maluleke sought to introduce his answering affidavit, that there really was no reason to prevent him from doing that because the matter was not urgent.
No, we did.
And obviously you could have coupled any order with a punitive cost order for any delay caused by the late admission of his answering affidavit.
No.
So that's the first leg of the complaint. The second is that it's inexplicable that the matter was heard until quite late hours of the evening, far beyond court hours, in circumstances where the matter was not urgent. And I think that's the nub of the complaint raised.
Well, and I do say why we had to do that. Okay. This is a person, according to the papers, who should not be on the roll of practicing advocates, according to the papers. This is a person who has been found guilty in a disciplinary inquiry. This is a person who, in his affidavit for application to become an advocate, said, no, I'm a fit and proper person. Did not report that he had a record, a disciplinary hearing record. Now, I don't know really what is it that, how could have helped. It's not an easy matter to strike off somebody from the role, but we had to do it. I can't do more than that, or better than what I'm saying. And the question about urgency, it was urgent, because this person is not supposed to be there. And I wasn't going to be available the following day. And pure, obviously, the way we regarded the matter, we said, no, look, this matter has been here forever. And it must come to an end. And we looked at the facts, the background facts, and said, yes, it was supported. Our decision was, we could justify it, that we had to end it on that day. But that we went into the night, we had made it clear during the day that we would proceed into the night if necessary, because I wasn't available. I wasn't going to be available the following day.
All right.
That's all that I can say about that.
Judge Mashile, that leads me to the second, I'm going to call it cluster of objections. It's equally complex and it's a compound objection, and it comes from Mr. Leroux. It's quite a fact-intensive matter, but essentially, Mr. Leroux complained.
CJ, it's me here. Yeah, Julius.
Oh, yes, I'm sorry.
I thought we agreed. I really thought we agreed.
Yeah, no, she is dealing with objections, putting objections from law bodies to the candidate.
Yeah.
So she's different from all of us in terms of putting all the objections so that the candidate can deal with them.
So when we deal with objections, we can do that.
Well, I have specially asked her because sometimes if I leave it to everybody, some might fall through the cracks. So I've just said she must look for them so that we never have the situation where everyone thought so-and-so would deal with it and then nobody deals with it and the candidate leaves.
Okay.
So that's the only, so it's not her question, it's just the objections for all of us.
Okay.
Yeah.
These are the questions of the Chief Justice.
Yes, she helps me also so that I don't have to look at too many things, yeah. Okay, okay.
Thank you, Chief Justice. And Mr. Malema, I'll be brief. Commissioner Malema, I'll be brief. It's the objections that emanate from Mr. Leroux, and it relates to quite a kind of a complex series of applications that come before your court, and it stems from the spoliation application, and your first handling of the spoliation application on the 22nd of December. Now, Mr. Leroux has raised the complaint that you gave the order that you gave on the 22nd of December, notwithstanding the fact that in his view, he had obtained a favorable order from, at that time, Acting Judge Shabangu Ndawe in relation to the spoliation. Now, I've read your response. I just want to put your response on the record so that it's clear and you can confirm whether that's the case. That in fact what Acting Judge Shabangu Ndawe had done was granted a rule nisi, and that what the respondent had done was anticipate the return day. And you heard the matter on the return day. What you were dealing with was the return day of the spoliation and a reconsideration of her order. Am I correct? That's your explanation?
Yes.
And that's
Was
how...
that a yes?
Yes, so you say, so just repeat that, so it came back to me, it was a rule nisi, it was an anticipated rule nisi.
That's correct, yes. Yeah, and that's how it came back to you. I think the complaint raised by Mr. Leroux, and he's given the JSC an entire bundle of documents, and I'm trying to extract the relevant portions from all of those documents. The complaint was really, his first complaint was that you granted an order in the face of a judgment already handed down in his favor. And I think the real issue is technically you were merely faced with an anticipation of the rule nisi.
No, it couldn't have been a judgment. That's why it's a rule nisi.
Yes, no.
There was a return date which was anticipated. So
yes.
It had to be either discharged or not.
All right, and then when you do reconsider the matter on the 22nd of December 2020, you do it in relation to the fact that there are 9 portions of land. In relation to 8 of the portions, you find that there was that the applicant was not in undisturbed possession, and in relation to 1 of the portions, that's the last portion, 39, you find that he was, Mr. Leroux was unlawfully dispossessed.
Yes.
And you restore possession. And that's the end of the spoliation application at that stage.
Yes.
Now, what happens is that a new application is brought by the respondent, who then becomes the applicant in the new application, for the eviction of Mr. Leroux from portion 39. But that application comes on the unopposed roll. Now, you grant the application for Mr. Leroux's eviction on an unopposed basis on the 12th of April 2021.
Yes.
And the complaint raised by Mr. Leroux is that that was improper, given the history of the matter, and the fact that, according to him, he had filed a Rule 30 and a Rule 30A notice a few days before you had granted judgment.
Yeah. Yeah. Unfortunately, Mr. Leroux, as I say, that Rule 30 was improper, in the sense that I just don't know what he was trying to do, but let me just put this into perspective. They were not successful on portion 39. They came back to court. They served
that eviction notice on him. Yeah, they did. So ultimately, it came to court. I don't know what is wrong. I'm struggling. They came to court on the 12th. I looked at the application. I then granted the order. I don't know what is wrong with that. Because they were entitled to it.
The penultimate complaint by Mr. Leroux is that he asks for reasons for your order granted on an unopposed basis. And that there has been that you haven't complied with that request for reasons.
Yeah, but you see, Mr. Leroux is also, as I explained there, that he's quite prolific in writing. He doesn't give you one thing. He gives you a heap of documents. And in the midst of all that, I probably missed the reasons. And until now, that I haven't given him. But that didn't stop him from appealing.
All right, and then the final complaint raised by Mr. Leroux is that he was quite shocked to see that you were allocated another one of his matters on the 17th of November 2022. But I think you've clarified that that's an error on his part, that you were not, it wasn't meant for you. I mean, you were not set down to hear the matter on the 17th of November 2022. I think it was another judge, rule officer, who was meant to hear it.
Was never, no, Judge rule officer, I think, is involved in that matter. If I recall, yes, it involved Judge rule officer. That's why I said I couldn't have, none of us in that division would have heard that matter because Judge rule officer has been acting. You will recall that he's like a permanent acting judge because there's a challenge about his appointment. So he's a colleague. No one can do that matter. So anyone who does it will have to come from outside.
Thank you, Chief Justice. I've tried to distill a very complex set of documents that were given to us, but I think that's the essence of the complaints.
No, thank you very much. I think you have done a very good job because those big bundles from Leroux must have been. I think we have come to the end. We have taken quite long. I think I must thank you, Judge Mashile, for making yourself available. You are now excused.
Thank you very much.
Should we take a comfort break before the next candidate? Okay, let's have a 5 minutes comfort break then. Good afternoon, Deputy Judge President. Please switch on your mic. Good afternoon.
Good afternoon, Chief Justice.
How are you this afternoon?
I'm fine.
Okay, all right. So you don't want to know how I am. So, but it's okay.
I thought you were tired, so I didn't want to ask the obvious.
I'm full of energy, even if it's the afternoon.
Okay.
Thank you very much, DJP, for making yourself available and coming to this interview. We appreciate it very much. We adopted yesterday selection criteria for candidates for appointment as judges, and part of what the criteria and the guidelines say is that all of us accept that interviews may require that candidates be asked robustly, ask questions robustly, but at the same time we accept that we must always have due regard to the candidate's human dignity. We must show respect and courtesy. So everybody who is here is committed to making sure that, while making sure that questions that need to be asked are asked, and are asked robustly if necessary, at the same time, there is courtesy and respect. So I wanted to share that with you. I'm going to ask you questions. After I've finished, I will give the Judge President the opportunity to ask questions, and then the Premier and the Minister, and thereafter the floor will be open to commissioners. Are you ready for me to start?
Yes, I think I'm ready.
Yes. Please share with the commissioners what your academic qualifications are and where you got them and when you got them.
I got B.Proc and LLB from the University of the North, and I have a diploma in insolvency law and practice from the University of Johannesburg. And I successfully completed a program in disciplinary inquiries at the workplace and a certificate in pension funds law from the University of Pretoria and University of South Africa, respectively. Those are my qualifications. And over and above, I attended short courses offered by the Law Society when I was still a practicing attorney, and various courses offered by SAGE.
Yes. Prior to your appointment as a judge, you practiced as an attorney, is that correct?
Yes.
When were you admitted as an attorney?
In June 1998, on the 11th of June 1998.
And when were you appointed as a judge?
To December 2013, so I practiced for about 15 years.
You practiced for about 15 years?
Yes.
Yes. And then you got appointed as a judge. The diversity of work in your practice, how was it?
I started first as a claims handler at the Road Accident Fund before I managed to secure articles. And I served articles, and thereafter I opened my own law firm in September 1999. And thereafter I opened at the same time a liquidation firm. So I was doing both firms. And I was servicing. I can't say that I was specializing. I was more of a general practitioner. I had a diversity of clients. I had corporates, government institutions, non-governmental institutions, and small businesses and individuals. And I attended also in the insolvency on the administration of insolvent estates.
Okay.
And I was a member of the company's tribunal, and also served on the licensing committee of the Financial Services Board, and as well as a member of the Broadcasting Complaints Commission of South Africa.
Yes. Let me mention also that before I give the JP the opportunity to put questions to you, I will give you a chance of about 15 minutes to enable you to share with the commissioners the challenges that you are aware exist in the division and that need to be addressed, and for you to say how you propose to address them if you were appointed as Judge President. So I'll give you that opportunity in due course. When you were appointed, you were not appointed to this division, you were appointed to another division first, isn't it?
Yes, I was first appointed to the Gauteng Local Division in Johannesburg, and then I moved to Pretoria, and then eventually to Mpumalanga.
Yes. So you have been in Mpumalanga for how long now? In the division?
Let me recall, because I spent some time there before, I think I was transferred in 2019 in October, but before then I had an opportunity to go on circuit, and I acted as a Judge President of Mpumalanga before the appointment. It was whilst the JP was the only permanent judge in Mpumalanga, and he was going on long leave. Then I was appointed the acting Judge President before I was formally transferred to Mpumalanga.
Yes. Now, when were you appointed as DJP?
In August 2021.
Yes. And how have you found the responsibilities of DJP in the time that you have been DJP?
I don't know now if I'll couple it with the question that you're saying you're going to give me 15 minutes, because I managed to make some observations during that period.
You want to deal with it during that 15 minutes?
Yeah, I think it would be ideal, because that's when I observed some challenges.
That's fine.
Yeah.
That's fine. Now, so you have been DJP for, is it 2 years, more or less?
Yes.
And during the time that you have been in this division, including before you were DJP, you say you have acted as acting JP in the JP's absence, is that correct?
Yes, CJ.
How many times have you acted as JP, if you are able to share that with us?
No, it's only from 29 January 2019 to 11 May.
Okay, that was like two terms or one term and a few months, a few weeks?
I think it's a term and a few months, if I'm not wrong. I stand to be corrected.
Okay. Before you became DJP, did you act as DJP?
I did. I acted for a period of approximately 36 weeks.
Yes.
In 2019, 2020, and before the appointment in 2021.
Yes. Okay, all right. Let me now give you the opportunity to share with the commissioners the challenges that exist in the division and how you would address them if you were appointed as JP.
It will obviously address my vision if I'm appointed as a JP.
Yes, included in that,
Yeah.
you can tell us where the division is now and where you would like to take it if you were appointed.
Okay. My leadership style is inclusive. I envisage to encourage participation and have the system to run optimally. Everyone in the division must appreciate the importance of their role and contribution in making justice accessible. My vision for today, it will be focused on the following: is access to justice, stakeholder relations, modernization, case backlog, insufficient number of judges, transformation, and accommodation for the Middleburg Code. Obviously, we are guided as the judiciary by the norms and standards and the Judicial Code of Conduct in order to, I'll use that as a guide in order to ensure accountability and efficiency. Fortunately, in our division, we don't have a serious challenge as far as the civil matters are concerned. We don't have challenges in long reserve judgments and case backlog in civil judgment. And that I'll give credit to our leader because he's so committed and adamant and taking us along in the implementation of case flow management. And as a result, we don't have a challenge in that regard. Unfortunately, as far as criminal law cases are concerned, we have a serious backlog. And this has been worsened by the COVID-19 pandemic and the load shedding, as well as the high level of crime, which leads to an increase in the number of the matters that we already have on our roll. The other issue that's contributing to this, we had 5 circuit courts dealing with criminal cause. Due to the insufficient number of judges, we had to collapse 2 criminal courts. And whilst I mentioned before I lost sight of it, the issue of the load shedding, we have a very serious challenge, especially in Middleburg. We don't have a generator. So we are indebted to the SAPS. We are reliant on their generator. And when we are told it needs repairs, we have to patiently wait. But we have raised this with the Department of Justice, and we have been promised that it's being attended to. On the issue of the case flow, of the case backlog of criminal matters, we had several engagements with the JP, with the Office of the DPP, as well as the legal aid, in order to address the issue and find means and ways to alleviate the backlog. And we addressed this as well as at our PEEC meetings for input from other stakeholders. One of the strategies that we have employed in our division at the moment is, as most of the matters, we have legal aid officials representing the accused persons, is per a court, it's one judge, one same official from the prosecution team, and one same official from the legal aid board. So that ensures that if you have one matter collapsing, maybe in the middle of the week or whenever, then you can fast forward the matter. You are not told that the other officials are engaged in other matters. And for this, I'll give credit again to our leader in the division, because this strategy is bearing fruits and we're seeing it being successful. After the collapse of the courts, the strategy at the moment is the JP, at the beginning of each and every term, will write a motivation to the Department of Justice, to the Minister, asking for appointments to deal with the backlog. And it's for some time now we have an additional judge there's a vacant position where we can appoint an acting judge to help us to deal with the matters. And for that, we are indebted to the Department of Justice, even if at the moment it's not enough, but at least we're getting something. Whilst we're waiting for a permanent solution. On the issue of the insufficient number of judges, our division, like any other division, we were invited to make submission to the Committee on the Rationalization of Areas under the jurisdiction of the divisions of the High Court and Judicial Establishment, which was set up in 2021 under the chairmanship of the former Deputy Chief Justice of South Africa, the Honorable Moseneke. I had the liberty of attending and making the submission with the JP, and one is just looking forward to the finalization of the process, because one is hopeful that at the end of it all, the number of judges in our division will be increased. Because honestly, at the moment, it's a little bit challenging and difficult for us. I can't overemphasize the need for the reopening of all the circuit courts. It's causing a backlog, and we are getting a backlash from the community, especially in matters involving minor children and matters involving gender-based violence. Because if we don't have enough judges, we are not able to finalize matters and deal with them efficiently. So I need not make more motivation at this point, Minister. We really need to take justice to the people. Whilst I'm still on the second course dealing with the criminal codes, the general idea is only to take the criminal matters to the people. I think we must have a shift, there must be a shift in idea, and I firstly need to mention that in our division, the JP has already indicated the desire to have some civil matters to be had at our Mpumalanga Circuit Court. But at the moment, because of infrastructural challenges, it's not happening. But one hopes that it will be attended to not long. I think taking division, especially the geographical area that we're covering in our division and the nature of the division that we're serving, we need to take as well, as far as we can, the civil matters to the people and be heard more on Circuit Court, and not only limit them to Mpumalanga Circuit Court. If I'm appointed the JP, I intend to establish mobile courts for each circuit for the issuing of processes and the sitting of the civil courts, which will be informed by the number of civil matters ready to be heard. It can be arranged. One appreciates the financial challenges and the challenges that we are experiencing, but one was thinking if one can have a mobile court where, you know, on certain days, it's maybe in Kwandebele is the date of issuing, and sometimes people go to Barberton, and then they rotate, and after you'll have to allocate days to make sure that you have a judge to attend to matters in those circuits as well. This will address the plight of the outlying communities who must travel long distances at huge cost just to access the courts, I beg your pardon. I had this idea because recently we have more people appearing in person in our courts. I think it's motivated by, especially in matters involving Rule 46A applications, where in terms of the rule, people are, even if when this rule deals with circumstances when banks are about to attach houses, residential properties, and be due to the aftermath of the COVID-19 pandemic, we see the increase in this type of applications. So at least the rule allows people, even if they are not opposing and they are not having legal representatives, just to come to court and put before the court their personal circumstances. So we see an increase of these people. But in reality, if you imagine a person, for instance, traveling by public transport from KwaNdebele coming to Middelburg, by the time he arrives there, I'll be done with my role. And that will defeat the purpose of the rule. So this is what motivated me to think of establishing of the mobile courts. The other related aspect in relation to access to justice is the services offered by the Master of the High Court in our jurisdiction. We are happy and we appreciate that we have the two offices established, one in Bombela and one in Middelburg. I had an opportunity, whilst we were having challenges, to engage with the Chief Master to discuss the need to offer the full complement. As it is, we are not, people in Mpumalanga are not receiving the full complement. For instance, there are challenges with the Guardians Fund, and that's a very important component that they have to serve because it's for the benefit of the indigent. It doesn't help for people to travel, to still travel to Pretoria to access. So we have agreed with the Office of the Master's Office that they will give us regular reports about the developments on how far are they and on the rollout of the services that they are going to offer in our jurisdiction. And when it comes to the issue, again, of the litigants who appear in person, the other issue that's a barrier for access to justice is about the language. Most of these people doesn't understand the language of record. And it's only fortunate when they find a person who understands their language as a presiding judge when they appear, because then you are able to engage them. So our thinking that if appointed, I intend to establish a help desk that will be manned by a multilingual official who's independent from the Office of the Registrar, who will be able to assist. Because sometimes some issues, people just have to be pointed sometimes to a right direction, like for pro bono services or to the magistrate courts, whatever service that they want. But at the end of the day, those lay litigants must leave the court being satisfied of the service that they receive from our courts. On the stakeholder relations, I'm indebted to the Judge President for having allowed me to chair the PEC, the Provincial Efficiency Enhancement Committee. I have chairing the meetings for some time now, even before my permanent appointment as the Deputy Judge President. The committee is mandated to enhance performance and outcomes in the delivery of quality of service. We had a very effective committee, and we were meeting physically. Unfortunately, our performance was affected by the COVID-19 pandemic, and as a result, when we tried visual, there were load shedding issues which resulted into network issues. So our meetings were affected. And when you have to postpone meetings where you're meeting different stakeholders, it sometimes poses a challenge. But I'm happy to announce that recently we are back on track, even if there are some members who are not yet back. We wrote letters to them just to remind them to come back to participate and make them to appreciate their role in the committee. Therefore, I undertake to ensure its optimum functioning.
We have gone past the 15 minutes, but I'll give you 5 minutes to wrap up.
Okay, over and above the PEC, I had an opportunity to engage some stakeholders outside the meetings, depending on the nature of the challenge that we had. Like I had a meeting with the Department of Health where we had a problem in the province. We didn't have a psychiatrist to evaluate and assist in criminal matters. And with the approval and direction of the JP, I managed to form the Provincial Judicial Forum, where I have meetings with the Regional Court President and the Chief Magistrate. It's not long that we have started that, and it had its own challenge, but I had a buy-in for them, and they are very cooperating. And one is intending to intensify and making sure that it's going to operate to its full optimum. And on internal stakeholders, I intend to contribute to the training of the staff to make sure that they appreciate what we intend to achieve. And on the issue of modernization, some judges in our province attended the training offered by Judge Malambo. We're still waiting eagerly for the rollout of case online and court online. I think I'll just end there then. And the issues of transformation.
Yeah. Okay, no, thank you very much, DJP. I asked the previous candidates whether there is any backlog in the division. I just want to put that question to you. I see you talked about backlog. Case backlog.
Yes, criminal matters we do.
How serious is it?
It's very serious.
Fairly serious.
I'm not proud to announce that we have the issue of the collapse of the two circuit courts.
Yeah.
Yeah, and the office hours as well.
Yeah.
The court hours affected by the load shedding. Remember, the circuit courts are in the magistrate courts, and you find there where there are no generators.
On the civil side?
On the civil side, we're doing well since the implementation of the judicial case management.
Yes. Okay, thank you. I now give the Judge President the opportunity to put questions. Judge President.
Before, can I be just proactive before we move on? There's an issue that I just wanted to just to be proactive and put it on the table before the commission.
Yeah.
I wrote a note to the commission regarding an issue that happened subsequent to me having submitted my application.
Yes. You want to talk about it?
Yes, maybe just briefly.
Yeah, talk
because
about it.
I've written a note and explaining, and at the end why I believe it doesn't have an effect on the issue doesn't have an effect on my capability to be appointed as such.
Yes, deal with it.
Yeah. there were civil summons issued against me without notice consent being obtained from the judge president, and I got hint of it. And when the attorneys advised the attorneys for the plaintiff, then after some engagement, they withdrew the summons against me and the other two liquidators, but the other defendants where the action was not withdrawn against them. And before they withdrew against us, we issued an exception, and the other parties as well did an exception. After it was withdrawn, then we left it. Then they approached the JP for a consent, and through my attorneys, I made representations that one, this matter, whatever caused the claim happened in 2005 whilst I was practicing, some 17 years ago. And it has prescribed, and secondly, and the main thing is that there's no merits to the claim. In the meantime, and the JP granted them, eventually he granted them consent, and I accepted his decision. Whilst waiting for their papers, because according to them, they stated in their letter that according to them, the claim was prescribing on the 10th of November, 2022. And my view was it prescribed in 2008, but they insisted that it was 10 November, 2022. Then I waited for the summons, nothing was forthcoming until the end of November. And before the end of November, the other parties proceeded with the exception, and Moshwana AJ in October set aside the particulars of claim, and they had a period of 30 days to amend their papers, and they did nothing. So that ran flat. Yeah. And I waited until the last day. I submitted my application form, and that's why I didn't indicate anything about the matter in my papers, because I thought sense prevailed after they considered the exception of Moshwana AJ, and after the 10th of November that is stated in their letter has come and gone. So according to me, it has prescribed. So after that, on the 2nd of December, they issued the papers, and on the 12th of December, they served me with the papers. Yes. And I'm of the considered view that their claim has prescribed, taking into account
It's a civil claim.
Yeah, it's a civil claim. On their own version, it prescribed on the 10th of November, and we have the exception on the same basis that we are defending our matter. Moshwana AJ upheld the exception.
Is it a claim based on an allegation that while you were practicing as an attorney, there is something you didn't do properly, or what?
It's a claim that I was a liquidator. We allowed people to mine illegally. We as liquidators, we rely on documents that are issued by the Department of Mineral and Energy. So the department is the one who gave us permission, even in the sale, because we sold it in the same year, in 2005. We got the consent from the department. It's the department who gave us the information that the company that was in liquidation was the rightful miner.
Okay, I know that's all right. JP?
Thank you so much, CJ. This issue that you have told us about now, you will recall that it is something that is worrying me very deeply. And you're aware that on the 28th of January 2023, that is 2 days before the shortlisting, I wrote a letter to you. Fortunately, you have shared that letter together with your response there to the members. I'm going to leave that to the members of a commission within their wisdom to deal with that issue. But you know that it is an issue that is deeply worrying me. Now, let us go where we need to go. You are aware that even before you were interviewed for the position of the DJP, I started actually offloading, almost like doing some sort of handover. And that has continued until today, am I right?
Yes.
Many things that are supposed to be done by the head of court is now done by your office, am I right?
Yes, JP.
In
The ones that are listed.
Yes,
No.
the ones that you have listed. And many meetings with stakeholders that I attended to, I have taken you along, particularly with regard to some of the meetings with the stakeholders. You are also aware that I have engaged and I've been engaging Judge Mashile. Even the post was advertised to help me in Bombela before the return of Judge Hwele. I'm not sure if you're aware of that.
No, I wasn't aware. I only became aware in that meeting with the stakeholders, with the NDPP.
Yes. And you will recall that on the 1st of February, I wrote a letter to you and Judge Mashile, where I've indicated and invited every one of you to approach my office to know about the ins and outs of the working of the office of the Judge President, other than some of the meetings that I have allocated to you. You're aware of that?
Yes.
Yes. And I'm not sure, you know that since that time, Judge Mashile has been part of us in terms of the engagement with the stakeholders and some of the meetings that the office is normally holding with the staff. Am I right?
Yes, he attended the meetings.
Yes. Now, you have also spoken about the division doing well in terms of the backlog relating to the civil role. Am I right?
Yes. Okay.
You know that since September, almost like on a daily basis, I've been in court implementing the judicial case management.
Yes. Okay.
And that has cut off the civil trial role by almost 60%, because many matters, especially with RAF, are resolved during the first and or the second judicial case management.
Yes,
You're aware of that?
Yes, JP.
And all the colleagues are participating in that respect.
Yes.
Yes. Now, you may not be aware of this. The waiting period, if I was to certify a matter trial ready, because almost our trial role has collapsed, because in each and every case management conference, REF is there. We have done it in such a way that REF attorneys will always be in our court. You are aware of that?
Yes, JP.
And today we actually had about 30 judicial case management matters in Middleburg. I'm not sure if you're aware that tomorrow I'll be presiding over another 30 matters which we have pulled in Middleburg. You're aware of that?
No, I wasn't aware about
Yes.
tomorrow.
Now, the waiting period, if a matter was to be certified today, trial ready, the waiting period is about 3 weeks or 4 weeks. Judge Mashile said 3 months, but it is actually 3 to 4 weeks waiting period. You are aware of that. If I was to certify a matter trial ready today, either the 8th week or the 9th week, if the parties are ready, they will be on trial. You are aware of that?
Yes, JP.
Okay. That is all. Thank you so much.
Thank you, JP. Premier, I now give you the opportunity. Premier, are you there? Oh, it looks like there is a complete.
Thank you.
Oh, okay.
Yes, I am. Thank you very much.
We
There's no shading.
Oh, okay, all
Now,
right.
I was saying, can you hear me?
No, we can hear
Can
you.
you hear me?
We can see you as well. You can go ahead. Oh, you were frozen for a few seconds.
Okay, thank you very much, and good evening to just okay. Now I'll try because I'm in a darkness now. I'm just trying to organize the lights. Just the first question that I want to ask that she has chaired the PEEC on a number of occasions when she was delegated by JP. And I see that she only has 2 reserved judgments, which to me, even though it is not completely, we must commend that considering the position and the responsibilities you are holding and your active participation in the African Women Lawyers Association, just to cite the few, how has that additional responsibilities impacted on your caseload? That would be my first question.
Yeah, you can answer, DJP.
On the matters that I have, the matters allocated to myself, or caseload of the whole judge, I didn't, because it keeps on breaking, I didn't
Oh, you
get
didn't hear the question?
Yeah, clearly.
Okay, Premier, would you repeat your question? Just ask one question at a time.
Okay.
Premier, are you there? Can you hear me?
Yes. Now, I was saying that given the work that she has been doing over and above the responsibilities in terms of the comment, can you hear me? I can hear you.
Yes, now I can hear clearly.
Hello? Chief Justice, can you hear me?
Yes, we can hear you, Premier.
Okay. Now, I was saying that given the extra okay. I was saying, Chief Justice, given the extra responsibilities that she has been given over and above the core mandate that she has to undertake as the Deputy Judge President. And she has, of course, indicated that amongst those would be sharing of the PEEC, of which she was delegated by JP to do as such, and amongst the other responsibilities, that is participant in progressive legal formation, such as the South African Women Lawyers Association, just to mention one. And considering the workload that she has. Now, the question that I'm posing to her is that how has the additional responsibilities impacted on her caseload? And I also see that
Premier, are you asking how her additional responsibilities as DJP, how they have impacted on what caseload?
Yeah. I think I can answer.
Are you there, Premier? I wonder whether there isn't another way. I'm wondering whether she can phone somebody here who can then who can then tell us what the question is. Premier? Yeah, I think maybe let's go to other. Let's ask other. I'll continue, and later on she might be in a better position.
Chief Justice, at least this question, she completed this one. And
Well,
we all had-
if you had it, please tell it to the
No,
candidate.
even the candidate had the
Yeah,
question.
did you hear it, DJP?
Yes, I think the activities that she specifically mentioned, I have to clarify that the PEEC, we only hold a meeting once during the recess. And the South African Women Lawyers Association is an organization of legal practitioners. I don't attend their meetings. It's only upon invitation when they are having seminars or workshops. So it's not like things that I attend on a daily basis, and they don't have much impact on my workload.
Yes. Okay, Premier, if you can hear me, we are going to proceed. In the meantime, try and find a place that will not have network challenges. So we will give you a chance later on. But in the meantime, I will go ahead and then we'll come back to you in due course. Minister?
Okay.
Okay.
Can you hear me?
We can hear you now. Okay, let me give you a chance, but if there's a problem again, we'll move on and then come back to you later on when maybe you might not have those challenges. Continue.
Okay.
Continue.
Yes. I think I'm a bit disadvantaged. She probably might have not heard the question that was posed before her, and I heard her response just towards the end of it. But then I just want to move on to the second question that I wanted to ask, which is in line with Section 174, subsection 2 of the Constitution, which places an obligation upon the judicial officers to ensure that the judiciary is transformed and reflect the racial and gender dynamics of our country. In your time in the judiciary, how have you contributed to the transformation of the judiciary? And if you were to be appointed, how will you advance the need to transform the judiciary?
DJP?
The contribution that I've done is, like I mentioned, when invited, where legal practitioners are, like I mentioned in my profile, that the BLA, when they're having their trainings in Bombela, when they are inviting, I participate for the empowerment, and even Saula, when I'm invited, and the legal practitioners. And when the JP invite me to submit names of maybe potential candidates, I try to nominate the names of women. But what the House must appreciate is that in our division, especially in Middelburg, you only have one position of an acting judge. And for me, transformation is not only about that, it's also transforming even the people that we are working with, for them to appreciate what the judiciary aims to achieve. And that's the other part that one is busy on as well, for us to have a common goal and to transform the whole system, to make it accessible to the community and be user-friendly.
No, thank you very much for the response, Deputy Judge President, and thank you very much for an opportunity, CJ.
Thank you very much, Premier. Minister?
Thank you very much, CJ, and good evening, Deputy Judge President. And
Good evening, Minister.
You have indicated in your vision that you will also look at putting some mobile courts and all that. And I know one of the biggest challenges the court is facing is the maintenance of the existing infrastructure, particularly the new building, and the other circuit courts. What do you see your role as a JP playing in engaging the stakeholders to ensure the maintenance, the fixing of the infrastructure, including how you are going to deal with these issues of the mobile courts, which will also need these other stakeholders? What do you envisage the role of JP being in that process?
Fortunately, we have already started in our division under the leadership of the JP. We are having regular meetings with the stakeholders. I stand to be corrected by the JP. I think it's almost monthly. We get regular reports. We are engaging the Provincial Department of Justice and DPWI and all the stakeholders. We're trying to put pressure on them, and we're meeting, and that's how I intend to intensify. There's an initiative that's working for us, even if sometimes progress is very slow, but slowly we're getting there.
Thank you, CJ.
Thank you, Minister. Commissioner Nyambi?
Thank you, CJ. Good evening, Deputy Judge President Mphahlele.
Good evening, Commissioner Nyambi.
It's only one question from my side. The last time in 2021, April, when you were interviewed to be a DJP, as it's also a leadership position, I must indicate that you interviewed well and you made some commitments about issues. To remind you, maybe one or two of those. Minister asked you about the challenges that is experienced by the Master's Office. Some of us ask about the challenges of the division of Mpumalanga. And out of all those commitments, probably if you can single out what we have done, because currently you are a DJP, in terms of making sure that you provide leadership, and if you can be given the opportunity to be the JP, you can take the division to greater heights. So in short, progress report out of those commitments we have made in 2021.
I haven't prepared my progress report, but what comes to mind now is about the issue of the master, which I think we have made progress, like I've already indicated, and it's work in progress. And the second one, there are two that comes to mind immediately. The second one is about the user-friendly of the court, especially in Middelburg. Remember, it was not accessible to disabled people. So in our new old court, it's an old court, but we call it new, we had phases. So I undertook that the phase that we're in, it will be made accessible. But I'm very sad to announce that it hasn't been attended to. But in these stakeholder meetings, I keep on reminding them and I get an undertaking. But fortunately, in the third phase that we are about to occupy not long, it's user-friendly. People, you can use a wheelchair so far. So those are the two that I can quickly remember.
Thank you, DJP. Thank you, CJ.
Thank you, Commissioner. Commissioner Marumoahai.
Thank you very much, CJ. Good evening, Judge.
Good evening, Commissioner Marumagai.
I want to ask you a question which generally troubles me, and perhaps maybe I'm asking it to you because you are here, but it's not necessarily intended for you. It is a question that deals with how judges write their judgments. And I understand the fact that at the High Court level, judges are under pressure, they have many matters, and sometimes it is not easy to consider seriously all the judgments that they are writing. Sometimes they are pressured to release judgments. But nonetheless, the concern remains that as law lecturers, we use judgments to teach. And if we do not do that and we produce candidates which are not well suited for practice, we get criticized. And that is the context within which I'm asking this question. There is a judgment that you wrote. If you could just bear with me just for a second. It is, the parties are Invest Tech, Investec Bank Limited versus Mildred Tsakani Chauke. It was delivered on the 7th of December 2021. Do you remember that judgment? It dealt with, in this judgment you were
Sequestration also.
It dealt with sequestration, yes.
Yeah, I have an idea.
Yes. No, now I'm not going to ask you about the specific in terms of the facts, but I was quite intrigued when I was reading the judgment. And when I look at paragraph 24 and paragraph 36 of that judgment, it gives me an impression that you have this thing called sequestration, and in order for a person to be sequestrated, there is this requirement, advantage to creditors. And in the judgment, you don't necessarily deal with the requirements for sequestration. And it is not particularly clear to me as to what act of insolvency in Section 8 was applicable in the judgment. But most importantly, and what is concerning to me is, you don't deal with, assuming that you're not dealing with voluntary surrender and you're dealing with compulsory sequestration, it doesn't appear from the judgment that you deal with the procedural and substantive requirements, Section 4 and 6 respectively, of compulsory sequestration. And I'm saying this on the backdrop of what I said, that we use these judgments to teach. So when I'm confronted with a judgment like this, which does not necessarily assist me to understand the context within which the law that is applied comes from. I'm not sure, do you have a comment on that?
I want to comment, but I'm thinking...
The judgment is part of your PEG from page 62, if I'm not, page 63. It is fact orientated, so it deals much with the facts, but it's not really that rich in the law. I'm not sure if, it's not a criticism, and I'm not criticizing you. I just want to get your sense of the point that I'm putting across.
Yeah. Page 63 and paragraph?
From page 63, the entire judgment, but I was really concerned about paragraph 24 and 36. Paragraph 36 in particular says that, look, this thing, whatever, because advantage to creditors has been proven. So it gives a sense as if that is the requirement.
No,
for,
I'm sorry, 63 is the point law
No.
one. I think maybe the numbering, yeah. 63 is the point law judgment. Oh, okay.
On the PEG
No,
that I have...
I was looking upwards, I'm sorry.
Yes, on the PEG that I have, page 63, that's the first page of the judgment, Investec Bank
yes.
Limited versus Mildred Tsakani Chauke.
Yes.
Yes.
Yes, the paragraphs that you're referring me to.
Oh, the first paragraph is paragraph 24. You say the respondent maintained that she had made arrangements with other creditors and it would not be for the benefit of creditors should she be sequestrated. And that is quite right. That's nothing wrong with that. I'm just saying it gives an impression, the entire judgment actually, it gives an impression that this is the requirement that one has to comply with.
Yes, it
is a requirement,
Yeah,
yes,
it
but
is
it's
a
not the only
requirement.
it's not the only
Yes,
requirement.
Yeah, it's not the only requirement.
But your judgment gives an impression that this is the only requirement, at least from the way I read it.
Commissioner,
No, if you go through it, I dealt with the issue that he was not able to pay the debts that he was called when I called upon to pay. I dealt with the issue.
Commissioner, can I put this question in a different way?
Yes, please assist me.
Yeah.
Perhaps maybe I'm not putting it correctly.
Yeah. As I understand the Commissioner's concern, is that your judgment dealing with sequestration would have been expected to indicate what the legal requirements are for you to grant a sequestration order. And when you read the judgment, it seemed to refer to only one requirement, and that gave the impression that that's the only requirement, which I think he's saying that's not correct. And he's concerned about that because when he teaches law students and when they read this judgment, they might think this is the only requirement, whereas he's teaching them there are other requirements. I hope I've not misrepresented you.
No, the
trust.
The rephrasing is correct. Perhaps maybe if I can assist the judge. The section 4 and section 6 of the Insolvency Act provides both the procedural and the substantive requirements. And when one deals with benefit of creditors, that is one of the substantive requirements. There are two others. You do deal with them factually without outlining them. But I'm saying the way in which, and it's not a criticism, don't take this as a criticism. I'm just putting across a general concern that I have with a lot of judges. That reading your judgment, you might well be right in your judgment, but I'm just saying reading your judgment, it gives an impression that there is only one requirement that one needs to fulfill, especially for compulsory sequestration.
Okay. I take the concern, but I have to say that if you go, I admit that I did not mention the requirements, but I dealt with the requirements. To the extent that I mentioned that demand was made, and I found that he failed to show that she was in a position to pay, so I dealt with them without mentioning them. But I take what you have mentioned and your concerns. Thank you.
I will leave it there, Chief Justice.
Thank you, Commissioner. Commissioner Shabangumdawe, I have two more, and then I go to the virtual, and I will see if there are others, but those are the ones I have at the moment. Commissioner Shabangumdawe.
Thank you, CJ. Good evening, DJP.
Good evening, Commissioner.
How are you?
I'm fine, yourself.
It has been a long day. DJP, the candidate before you indicated to the commissioners that there's a challenge in the division where legal practitioners are complaining about the practice directives. And he also indicated that, I'll just put it this way, nothing has been done thus far to attend to this challenge. Should you be...
I'm sorry, Commissioner. I'm not sure that that's a fair reflection of what he said.
What he said they are not engaging.
Yeah, but he didn't say
They-
that nothing is being done.
Okay, I'll rephrase it. They are not engaging.
Okay.
So, you, DJP, as a leader of that division as well, can you share with us maybe as to what is it that has been done thus far to address this challenge? Because from what I believe in is that the legal practitioners are also very important stakeholders in the division, where you need to get a buy-in from them for whatever that, particularly with regard to the practice directives. And what is it that you will do going forward if appointed as a judge president to deal with this challenge?
Through you, CJ. I've noted on the comments by the GCP that the issue was raised as well. When practice directives are issued, after they are being issued, and I don't know, this was not our first set. Remember, we are the new babies on the block, so to say. The first one we issued, there was an invitation, I remember, to the practitioners, the locals, to comment. And these ones, I think you were invited to comment, but we were already, it's like we were implementing, and then you were welcome to comment. The only practitioners who engaged is the practitioners in Middelburg, and we had a workshop with them, and after that, they were happy. And I need to mention that when chairing the PEEC, the representatives of the legal profession and the LPC, they informed the meeting that they are happy with their engagement with us. The issue of the practice directive was never raised. The first time I saw the concern, it was in the comments. And reflecting on it, I thought, because now, as you know, in Mpumalanga, we promoting appearances. We hear people, and most of the people who are appearing before us are coming from Johannesburg and Pretoria. I thought to myself that maybe when we consulted, when the invitation went out for comment and engagement, it did not reach the people who are regularly appearing in our court. And the practice directives are not cast in stone, and the office of the JP is open for engagement. And what I think can be done, the other suggestion that I have, is that we have a liaison committee with the PLC, that we have that committee where we will be liaising with on an ongoing basis. And we welcome feedback, and we saw what's noted in the comment section, and we'll go back and reflect.
Thank you. CJ, I've got my last question today.
And if I may add, if you remember, Commissioner, you were present at the meeting of Saula when I was invited in August to celebrate the Women's Month. I was a guest speaker there, and I made an invitation to the female practitioners there that I'm willing to use my weekend time to come and discuss with them the implementation of the practice directive, and I'm still waiting for the invitation.
Okay.
Commissioner, you remember, one, unless there is strong motivation. One question, unless you strongly motivate to me.
I think this one is, yeah.
What is the motivation?
It deals with transformation, CJ.
Why can't we do without it and move on?
I can't leave this one out, CJ.
But what is the motivation?
It's very short. It needs
Ask
only
quickly,
one answer.
okay?
Thank you, CJ. DJP, there's this saying that the gender transformation of the judiciary will strengthen South African judiciary, right?
Yeah.
You as a woman and also a leader in the judiciary, have you ever invited women from Mpumalanga to come and act, so to mentor her, at least to be on the very same chair that you are sitting on in future?
I have to confess, mentoring I done, but it's people in Gauteng. In Mpumalanga, I haven't done it as yet, but they are appearing in the code there, so they are serving the people of Mpumalanga.
And they want to hear DJP as to, is there any chance that one day they will be considered to act? Because we really, women from Mpumalanga to come and act.
Yes, we have in Bombela, we have, I don't want to call the first name. I forgot the surname because I'm used to call her on the first basis.
Of course,
we
you
have
consider
two.
them because you are not excluding them, isn't it?
No, we are not excluding them.
Yes, you will consider them.
Yeah, we will consider them. We are. They are acting.
Yes.
We have one on the roll now.
Okay. I have Commissioner Dodovu, Commissioner Matolo Lepu, Commissioner Singh, Commissioner Pillay. Commissioner Dodovu.
Thank you very much, CJ.
Let me just say before you proceed, Commissioner Dodovu, we are at 6:45. I would like us to see if we can finish at 7 with this candidate. Okay?
Yes.
All right.
No, mine
Anyone
is very, very short.
Who doesn't feel strongly about a certain question, please allow us to finish. Only those where you read. Now I'm talking about those that I've got here. Okay, all right.
Okay. Yes. Managing tensions and conflicts is one of the key responsibilities of leadership. And conflict is everywhere, and I can see with my 4-year experience in this commission that there is tension and conflict too within the judiciary. In your own experience as a leader, how do you manage conflict? Or how will in the future, if you are considered for this position, ensure that you manage conflict and tension in your division in a way that will ensure that your division is successful and it does what is expected of it?
It depends on the cause of the tension and the conflict. I only think that you saying you have observed tension and conflict, but I want to believe that judges, as far as emotional intelligence is concerned, they must be at the top of it. As adults, who have these enormous responsibilities. But if there's tension, as a leader, you must intervene just to harmonize. And it will, like I say, it will depend on the nature and the cause of the tension. I wonder if
CJ is okay, in the interest of time.
Yeah.
Yes, okay, thank you. Commissioner Matolo Lepu.
Thank you. Thank you, CJ. Mine is just a comment. I mean, in your vision, you indicated that to encourage access to justice in the court, you are going to maybe recommend that somebody outside from the registrar's office just to assist members at courts guide members of the public. What I just wanted to find out, have you considered, especially because Mpumalanga is a vast province, have you considered working with community-based organizations? Because most of them are trained paralegals. Because we are doing it in Gauteng, we can still do it. We are supporting it as the LPC in Gauteng, we are supporting it in the Free State. Maybe we can approach the LPC to assist in that regard. I just wanted to comment on that.
Okay. I'm really grateful for the information, and one is willing to engage the LPC in that regard.
Thank you, Commissioner. Commissioner Singh?
Thank you very much indeed, Chief Justice, and good evening to Judge Pasela. I just want to know, going back to 2021, whether you've had any run-ins with attorney Mr. Sheikh Omar. There were some complaints then, and I trust you have dealt with them. And secondly, to appreciate your positivity, because in 2021 I asked you specifically, do you have any intentions or aspirations to be the JP of Mpumalanga one day? That was 2 years ago, and your answer was, I do, like in a marriage ceremony. So I'm very glad that you have availed yourself for this particular post. But just a question on Attorney Sheikh Omar. Thank you.
Maybe I didn't get, have I ever encountered him after? Is that the question?
Yes.
No, no, I haven't encountered him thereafter.
Thank you, that's an answer. Because you complained bitterly the last time, but you dealt with it then. Thank you.
Thank you, Commissioner Singh. Commissioner Pillay?
Thank you, Chief Justice. Good evening, DJP Mpasele.
Good evening, Commissioner.
Pillay.
Oh, Pillay, I'm sorry. You're my thousand apologies.
No, that's fine. Yeah. Can I say to you, I couldn't help but notice that the 3 judgments that you attach to your application, that none of them are reported judgments. And in fact, it goes a bit further than that, because the one adverse comment raised by the GCB is that you do not appear to have any reported judgments in your 10 years as a sitting judge. Now, given that we would look to the leader of the court as providing not only administrative leadership, but also intellectual leadership within the court, what do we make of the fact that you don't have any reported judgments?
Firstly, I'm looking through my papers. I have one that I didn't even mark reportable. I was still in Gauteng, dealing with the jurisdiction of Mpumalanga. But on that aspect, I acknowledge, but it would be, for lack of a better word, not proper to assess me on the number of judgments that have been reported. Because one has to look at the judgments that are produced, the type of judgments that are produced. And I don't have authority over the people who decide what to report or not to report. And what's comforting is that all the judgments are available on SAFLI for the broader community.
Am I allowed to follow up?
Follow-up,
It's just a factual thing.
Yeah.
The difficulty with that explanation, DJP, is that obviously as a judge, you have control about whether or not you indicate if your judgment is of interest to other judges. And in all of the judgments that you've put up, which I'm assuming is the best of your lot, I mean, you've put up your best samples. In all of those, you've indicated that they are not of interest to other judges.
Not that I want to be defensive, but what I can mention is maybe one is modest. I can mention judgments like the ones that I mentioned in my PEG, a judgment where I had to deal with a lacune in the Poker Act when dealing with the attachment of the accused person's assets, and one judgment where I had to deal with the relations between the district courts and the regional courts, and that judgment was even discussed in the Rebus, the magazine for attorneys. Maybe one is modest in not indicating, and I take take responsibility for that.
Thank you, DJP. Thank you, Chief Justice.
Thank you.
Thank you. We have come to the end of this interview. Thank you once again, DJP, for availing yourself for this interview. You are now excused.
Thank you for having me this late.
Let me welcome the Judge President of the Northern Cape Provincial Division of the High Court, Judge President Laletsi. JP, you are welcome.
Thank you, Chief Justice.
Thank you. I also understand that the Premier of the Northern Cape is on the virtual platform. Premier, are you there?
I am on the platform, CJ.
Thank you. You are most welcome, Premier. Welcome. We are happy that you are able to join us. Thank you. Let me just mention for the benefit of the Premier and the JP, who were not here earlier. Because of time, we are trying to make sure that we don't take too long unnecessarily without compromising the job that we are doing. Earlier on, we had agreed in the earlier sessions that no commissioner would ask